Lordship recollects, yes. This was that matter where the amendment was allowed by the Lordship. The Supreme Court upheld it, and Lordship had fixed the matter on 27th of June at 12 p.m. 27th, it was a holiday, declared a holiday, so
Okay,
could not, Lordship, I have given notice.
Defendant, Lordship, Mr. Shomrat Shen is senior advocate. He's leading.
Recollects that they had asked for
Filed by
dismissal of
that needs to be heard out, Lordship. That may be
any date
any date next month, Lordship. He's not available from 23rd to 30th
next month.
July. Or
Next month.
He is not available.
January, the amendment was allowed by Supreme Court also.
It has been heard out partially.
What application you filed? Dismissal of suit?
Yes.
That application is of not absolutely dismissal of suit, but of the claims, Lordship.
Of the claims.
Part of the claims, Lordship.
Yes. कोई है डेट उट कुछ है?
Somewhere this month, Lordship. Somewhere this side.
I don't. नहीं है. 12th August is Tuesday.
Hardly it will take 15 minutes from their side and 5 minutes from my side.
पहले कुछ नहीं है. July last.
I'm not sure, Lordship, Mr. Sen.
Yes.
24th July.
Yes. Yes.
Lordship, I'm told he's not there.
When?
He has not appeared.
30th.
But he has never appeared.
Okay, come on, 18th July. 12th July. 12th August. Come on, 12th August. At कितना बजे?
11. I'm good.
Item number 40. As per prayer made by the counsel for the respective. As per prayer made by the learned counsel for the respective parties, let the matter appear on 12th August 2025 at 12:30 as a specially fixed matter.
Highly obliged.
Sir, with regards to item 83 of the list,
Yes.
so the matter is fixed for arguments.
Which matter?
Item 83 of my lord's commercial list.
Yes.
But this matter is fixed for arguments. Well, it's an ex parte suit. The difficulty is the deposition that we have applied for copy of the deposition to be given to us. We have not yet received it.
83.
Yes, Lord. But there's the department.
HTC impacts.
Yes, no. The department is saying the file has to go to the department for them to make
send the
available to me the depositions.
Send the file. Why they are not giving the requisition here? The department, if the
was-
file is there, then department has to give the
But
requisition
I
to
do
the
not know
court.
what happened. The deposition they gave us was not
No,
pertaining to
no.
this
If
matter.
you file the application for certified copy, the department find that the copy file is in the court, they could have been given a
That
requisition to
was
the
made
court.
known to them
Okay.
also. We had told them of the same
Send
thing.
the file.
But then will this matter shall appear next week, will it?
Let's see.
Very well, Lord. Obliged.
Yes.
May I have my lord's kind leave to mention
Hmm.
a commercial suit for fixing of any day for witness action. My lord, I am for the plaintiff. My witness had been examined in chief partly on one day. Thereafter, my lord, the sole defendant took out an application under Order 7, Rule 11, which was part heard before my lord Justice Sugato Mojumdar. Now, my lord, the Order 7, Rule 11 has been dismissed and my suit may proceed. My lord, my witness is from Shiliguri. My lord is pleased to
It's
fix.
undefendant suit.
No, my lord, the defendant is appearing. My witness
For
was
the other
under-
side.
My lord, I have given notice
So let
to
it be
the
fixed
state.
tomorrow as to be mentioned.
I am obliged, my lord.
And issue the notice to the others.
My lord, I am mentioning upon notice. I shall intimate
Issue-
again. I am
Because
obliged.
it has
My
the
lord,
date is to be fixed in presence of both the
My
parties.
lord, I am obliged.
Yes.
Lordship, may I permit to mention, I have been
My lord, I'm mentioning upon notice to my other side. I'm for the judgment debtor in
Huh?
this matter, your lordship.
Yes.
I'm for the judgment debtor in this matter, your lordship. By an order dated June 23rd, I'm suffering an injunction, your lordship. However, we've entered into an agreement now, and we've decided to settle the matter now. If your lordship could be kind enough to just keep this matter tomorrow, any
Where
day
is the
this week.
matter which is listed?
It's not
22nd
on
it is
20
listed, but then it has been settled. It can be kept
And I'm
for
unable.
Settlement in the execution proceeding.
the execution.
Right, your
Parties
lordship.
are settled that
Yes,
this
Right, your lordship.
Everything also.
to be
They want
mentioned.
to do business if they but
We're unable to do business because of the injunction, your
also
lordship.
won't get any money.
Come tomorrow as to
Lordship. I'm grateful, your
I'm
lordship.
My lord, may I be permitted to mention one company application, my lord? It was returnable today, my lord, 16 July, as per the judge's summons, my lord.
it is not listed
It is
today.
not listed today, my lord, and this is taken up only one.
Do one thing at come at 2, mention that I will try.
I'm grateful.
Matter will be taken at 2, come at 2.
I'm
My lord,
grateful.
may I have leave, my lord, to mention, my lord, one modification application has been filed Against my lord's order of letter of administration. But my lord, inadvertently, master summons has been taken out, my lord, to list the matter before my lord just to in the movement. Please, my lord, kindly direct my lord to appear before the court.
No, it has to be released. Get it released from the court. It is listed before the, but my order, modification mentioned before the court will release that, then it will come here. Correct.
My lord, may I be allowed to mention, lordship, this is a election petition which my lord is hearing. Matter is ready for final arguments, my lord.
Election petition.
Election petition, my lord. It
Election
was
petition,
listed, it was supposed to be listed on 30th of June at 11 o'clock.
yes.
My lord, if my lord pleases to keep it tomorrow, we are ready with our arguments. It can be finished off tomorrow itself. We're ready with our notes also.
Who is for the other side?
I have given notice, my lord. Mrs. Sinha is
It is
appearing for
not
the
in
other
the
side.
list.
It's not in the list. It was supposed to be listed on 30th of June, my lord,
Hmm.
at 11 o'clock for arguments. And there was a peremptory order for cross also.
Hmm.
However, I had
Correct.
spoken to my learned friend over phone though, so they do not wish to cross-examine, I believe. So
Okay, let it fix tomorrow as to be mentioned. Inform the other side.
I
let
will.
the- both the party come. Friday.
Friday. Grateful, my lord.
Friday is to be mentioned. Let the both party
Great.
come.
Lordship, I am appearing on behalf of the defendant number 1
This is just for filing,
for
my lord, notes.
written notes of arguments, Lordship.
My lord,
Our
we have
note
got
is-
our notes of
our-
argument. My lord,
Our
we are
note
filing it.
ready, Lordship.
My lord, kindly
Kindly
make
there
it
has
CAV.
been made certain changes. I am praying for just 1 day's time to file it tomorrow, Lordship.
My lord, let them
Can-
file it, my lord, in the meantime
In
with
the
your
course of the
lordship.
Let
them
it
file
come
with-
tomorrow. Let it come tomorrow as to be mentioned.
Kindly make it
I am
CAV.
taking your. note.
Very well, my lord.
Learned counsel for the plaintiff has filed written notes of argument after serving the copy to the learned counsel for the
No,
defense.
my lord, we have
Not-
it,
not,
sir.
sir.
Notes.
Okay.
Okay, let the same be kept with the record. Police counsel for the defendant number 1 prays for a day's time to file written notes of argument. Let the matter appear tomorrow under the same heading for filing written notes of argument by the defendant number 1.
Grateful.
Good.
Lordship, item number 2, I appear for the respondent.
Yes.
This was the plaintiff's application under Order 13A. Lordship has heard us in full. Today was only for the limited purpose of filing the notes. May I hand up?
May I also hand it?
Both the parties have filed their written notes of argument. Let the same be kept with the record. CAV.
My lord, I'm the commissioner in this matter. My lord, I'm supposed to file my report today. My
Hmm.
lord, it is ready, my lord. It's just getting xerox, my lord. If I may file it in the course of the day, my lord. and
Not today. Not today. Come tomorrow. Not today.
But I appear for the plaintiff. At my instance, the commission took place. Not today.
Not today. Come tomorrow.
Kalki report. Tommy, this one. But here I appear for the
My lord, in this matter, my lord was pleased to appoint the learned commissioner
Hmm.
to record the evidence. My lord, the witness action is going on. PW1. I appear for the plaintiff, my lord. My lord, we are in the midst of the examination in chief, and then, my lord, we felt that we need to file a certificate under the old 65B of the Evidence Act, my lord. Unless I take your lordship's leave, my lord, the commissioner cannot receive. And my lord, the tenure of the commission need to be
Where
extended.
is the affidavit?
My lord, the witness is abroad, my lord. Who will prepare the affidavit immediately before the call.
No, if he file the affidavit, I will take on record. Then I will.
My lord, kindly grant me the liberty to file it before the commissioner.
He's out of India.
He's
I'm not standing in the way because subject to evidence, whatever.
and my lord, the tenure of the commission be extended.
I have to cross-examine the witness.
Learned counsel for the plaintiff.
Yes, my lord.
Learned counsel for the plaintiff submitted that by an order dated 24th of April 2025, this court directed the commissioner to file report by 15th of July 2025. Counsel for the plaintiff submitted that examination in chief
Yes.
of the plaintiff witness is going on, and there is requirement of filing an affidavit under section 65B of the Indian Evidence Act 1872, and as such, he prays for leave to file affidavit under section 65B of the Evidence Act before the Commissioner for exhibiting the documents, electronic documents. At the learned counsel for the plaintiff, the plaintiff is given liberty to file the affidavit under section 65B before the Commissioner. Full stop. The Commissioner is directed to complete the. Then your evidence you will have this further evidence.
Yes, my lord. Now that
So then you will also have this.
Yes, my witness.
The Commissioner is directed to file report.
So far, my witness is concerned, it can be on commission, but the bank will not pay for the commissioner's fees and all.
Okay, let they complete.
Yes,
first.
yes, let them complete first. Yes, the bank will not pay for that.
File on 26th August 2020.
grateful, my lord.
Item number 5, your lordship, if it pleases your lordship, this is my plaint, your lordship. Suit for recovery of money for goods sold and delivered.
Yes.
Goods are, your lordship, machinery and parts of equipment.
Hmm.
Your lordship, I am seeking leave under clause 12 of the latest patent and dispensation of the rigors of section 12A, mediation.
See, why 12A?
Yes, your lordship, 12A, because the pleading would be at page 7, your lordship. Kindly takes paragraph 12 and thereafter paragraph 18 at page 9. Paragraph 12, your lordship, I have stated that I have served a notice of demand which has crystallized the debt as on the 9th of January 2025, your lordship. Thereafter, there has been no response and the defendant has refused to come to an amicable settlement. Thereafter, your lordship would kindly take page 9,
and
paragraph 18. I have stated, your lordship, that the plaintiff has requested for amicable settlement and has failed, and the defendants are purposely delaying and not making payment. I have also stated that I have come to learn that the defendant is in the process of winding up and or disposing of their assets. Therefore, I state that in the circumstances, mediation would perhaps be an empty formality, your lordship.
When the last payment was made?
When was the last? Lordship, no payments have been received.
Nothing. When the last material was supplied?
Yes, your lordship. When was the last material supplied? Last material supplied. Lordship, sometime in 2023, I'm told, your lordship.
Go for the mediation. Why you are not going to the mediation? Only you are given the allegation that siphoning off. There is no document and there is no such.
Lordship,
thing.
there's another issue that a proceeding is also pending between the parties, and I have annexed that, your lordship.
What proceeding?
Lordship, before the criminal court.
138.
Yes, your lordship.
So,
that pleading is there, your lordship, in the plain.
okay, when 138, what happened?
Is in that?
Yes, he's taken bail and gone.
He has taken bail in that proceeding, your lordship.
130 is different thing.
Lordship would
He's
kindly
taken-
consider this is my pleading on record. I cannot improve on this, your lordship.
Go for the mediation. Go for the mediation.
As it falls from your lordship. Lordship, in that case, would permit the plaintiff to withdraw the suit.
Draw and go for
And
that.
we shall.
Instead of order, you.
Yes, your lordship. And lordship would kindly direct the department to return the court fees, your lordship.
The plaintiff prays for withdrawal of the suit with the liberty to
File afresh.
approach the plaintiff for pre-institution mediation process. According to plaintiff prays for allowing to withdraw the court fee and to use the court fee if the plaintiff files the suit again after failure of mediation. But the learned counsel for the plaintiff and this CS Com 74 of 2025 is dismissed as withdrawn. Liberty to approach the pre-mediation process, and the department is directed to refund the court fee to the plaintiff with the liberty to use if in future the plaintiff intend to institute a suit after failure of the mediation.
Lordship has granted me liberty to withdraw and file afresh. Gratefully, Lordship. Limitation is covered in the Mediation Act. Grateful. Covered by the mediation.
कोई नहीं है? Not today.
I take paper in this matter for the respondent number 1 and 2.
Yes.
Lordship, as per the last direction, Your Lordship, rule has been issued against the contender number 3.
Yes.
And we have, Your Lordship, taken all steps, Your Lordship, for the.
You are appearing for
1 and 2, Lordship.
who is for the 3?
3 is not written, my lord.
रिपोर्ट आया है क्या? कौन आया? डिफेंड नंबर 3, कंटेंट नंबर 3, क्या नाम?
बोला तो बस चीज है. Lordship, my instruction, Your Lordship, that contender number 3, Your Lordship, has already appeared.
Who is? Call the name. Kripa Shankar Kushwaha. क्या नाम है आपका?
शंकर कुशवाहा.
हाँ, क्या बोलना है आपका?
जी?
आपका तो वारंट इशू हुआ है ना, रूल इशू हुआ है.
जी.
क्या बोलना है आपका?
जी,
आपने वकील किया है?
तबीयत खराब था इसलिए हम नहीं.
वकील कहाँ है आपके? आपने वकील एंगेज किया है?
वकील लगाए हैं कोई? कोई वकील साहब है आपका? कोई वकील लगाए हैं आप?
क्या नाम है वकील का?
वकील साहब का क्या नाम है?
मैनेज करो হয় না.
So, Lordship, I beg to appear on behalf of the contender number 3. My lord, he is present before the court today.
Why he has not appeared on the earlier occasion in spite of service of notice?
तबीयत सब खराब था इसलिए हम नहीं आ पाए.
So what is your instruction?
My lord, what he has told me that he was not aware of the order. Now he knows about the order and he will comply. There won't be any violation and he is not violating at present.
File affidavit.
My lord, affidavit is ready today. I'll affirm and file in the course of the day.
Okay, I'm fixing tomorrow. Come tomorrow.
Lordship.
I record an order. Alleged content number 3, namely Kripa Shankar Kushwaha is present in person. Full stop. Learned advocate appearing for the content number 3 submits that his affidavit is ready and requires a date time. Accordingly, case adjourned. Let the matter appear tomorrow for filing affidavit compliance by the affidavit by the alleged content number 3. Release the matter tomorrow under the same heading. Come tomorrow.
My lord, does he need to be present?
Come tomorrow. I will see the affidavit. Then I will take.
I'm grateful.
Yeah.
Number
Okay.
8.
Item number
The
8, Your Lordship,
content
with
number-
my, oh, I'm so sorry.
The content number is 3, directed to appear tomorrow in person. Yes.
Item number 8.
Item number 8, Your Lordship, is my application. We have been served with the affidavit in opposition yesterday. Lordship would kindly permit us to file a reply to that. We had been granted 2 weeks to file a reply. They were granted 2 weeks. They were out of time. Lordship would kindly permit us to file a reply to this.
Thank you.
14, my lord, I believe, my lord,
We
service
got
was-
yesterday.
Huh?
Yesterday we got an online service. Maybe get a hard copy, Your Lordship.
The hard copy, they were refused.
It was.
No, because they were out of time.
Achha, get a copy right now.
LS contender file affidavit in opposition after serving
you.
the copy to the learned counsel for the plaintiff. Let the same be kept with the record. Counsel for the plaintiff prays for time to file affidavit in reply. Let affidavit in reply be filed.
2 weeks. 2 weeks.
Then a week, 2 weeks.
2 weeks. Lordship had granted
2
2 weeks.
List the matter on 31st July.
Grateful.
My application appearing after service. My affidavit of service in the way. This is the copy I have. They have received, they have called us also for settlement, but settlement has failed in the meantime. That passed an interim order on 8th of June, 18 June, which is existing till today.
Yes.
My
Lordship, I appear for the defendant. On Monday, the settlement talk has been initiated, and as far as I am instructed, the plaintiff has said that they will be coming back with their
No.
proposal.
No.
In the meantime, let the order be extended. We do not have objection with
Okay, I
that.
am extending this.
Yes,
If it's settlement, otherwise
If it is settled, we will inform the honorable court.
very well, my instructions are that they have said that they are not in a position to pay. Now, it's yesterday evening.
That is not the issue.
Now,
Lordship, we have the bill.
the issue is that had passed an order with regard to one bank account. That bank account also the checks have defaulted. Now, when my learned friend is appearing, at least he may take instructions. What are the assets? What are the assets? That's much. My lord, extend the time. Kindly let him take instruction and disclose what are the assets.
Lordship,
That's all.
Since the settlement talks are going on, Lordship may grant us a date. If it is then
Only
completed the
disclose,
settlement,
that's
then
all.
the entire issue will be
Okay. I
completed.
am extending it.
Yes, let that,
And,
let that be
I
extended.
will record your submission. I am extending the period, and I also record you if its settlement is failed, you file affidavit disclosing the
Bas.
total assets.
Take.
Landed counsel appearing for the defendant submits that a talk of settlement is going on, and he prays for time. And counsel for the plaintiff submit that though there was a talk of settlement, it has not been materialized. He submit that the interim order granted is till today and prays for extension. Till today and prays for extension of the interim order. In view of the submission made by the counsel for the parties, the interim order is extended till 18th of August 2025 or until further order, whichever is earlier. In the meantime, if the parties have settled the dispute, the parties are liberty to mention the matter before this court. In case of failure of the settlement, the defendants are defendant or defendants?
Should be only defendant.
Defendant
Only.
shall file affidavit in opposition by disclosing affidavit in opposition, also by disclosing the assets of the defendant within a period of 3 weeks. Reply if any there to be within a week thereafter. List the matter on 18th August.
File the original affidavit. It has come.
Affidavit service filed by the plaintiff be kept with the record.
I'm appearing for the plaintiff. Mr. Shuddhasattva Banerjee was appearing the matter. He slipped in court yesterday. He was only praying that if your lordship could make it not today, he'll be there tomorrow.
Who is for the other side?
I am for the respondent. There is a direction for filing opposition filed by
Praying for recalling of the order.
Yes, ma'am.
Lordship, the
And there
opposition.
is a section 5 recalling of the order and allowing to cross-examination the witness.
You are for the
I am for the defendant.
defendant has filed an application.
Yes, my lord.
Lordship, we have filed it has been served.
My advocate on record says not. So can it be soft copy?
What you are filing? Reply.
Lordship, affidavit in opposition. It had been served on the advocate on record.
Affidavit in opposition in connection with which GA?
I'm sorry, I have only.
GA number?
1, 2, and 3.
All three. Serve the copy.
Sir.
So you will file reply.
We will file a reply.
Lordship, it is out of time. The
I'm
matter
sorry,
is
my lord.
closed.
I just.
This has been continuing in
No,
this
no,
matter
there's-
from
It
the
is not
beginning itself.
intentional. I'm sorry.
The plaintiff has filed affidavit in opposition in connection with GA-Com 1 of 2025, GA-Com 2 of 2025, and GA-Com 3 of 2025 after serving the copy to the learned counsel for the defendant. Counsel for the defendant prays for time to file affidavit in reply. Let affidavit in reply be filed within a week.
That you may get a soft copy of the Millard replies, Millard. I'm sorry, Millard, if they can provide soft
It was
copies of-
provided to him.
Yes,
He
it has provided to me. I'm not saying
Provided.
that. It has
Yes, yes.
my signatures because I'm sorry, I forgot Millard might be. May I get a soft copy at least because I have to give. I'm
Very well.
grateful.
Within a week, list the matter on
No, hard copy.
29th July.
Thank you.
Next.
Lord, this is my application. I am appearing on behalf of the plaintiff. My lord, application for recalling of an order of 17th April 2025, my lord, where my client was dismissed for default.
17th April.
Yes, my lord. My lord will find from page number 8.
None appears.
Yes, my lord. But I have also given the reasoning, my lordship, at paragraph number 8. Inadvertently, my lord, the counsel has missed, your lordship, when the matter was called. And there are, my lord, 3 pending applications, your lordship. Pleadings are complete. Praying for
Which for the defendant?
my lord, Shormi Dotto was appearing, my lord. She is not there. But, my lord, we have served the application.
Have you saw where is your affidavit of service?
My lord, it's filed, my lord. My lord, we have served.
The plaintiff has filed the present application being GA-Com 6 of 2025, praying for recalling of the order dated 17th April 2025, wherein this court has dismissed CS-Com 337 of 2024 within bracket old number CS4 of 2022 has dismissed for default. Consequently, all interlocutory applications were also dismissed. Full stop. The counsel for the plaintiff submitted due to inadvertence, common law advocate appearing for the plaintiff could not appear before this court and follow the matter listed before this court. Accordingly, could not appear before this court when the case is called. Heard the land counsel for the plaintiff peruse the application and the ground shown in the application. This court find that sufficient ground has been shown, sufficient reason has been shown for non-appearance of the plaintiff on the date fix. Accordingly, the order dated 17th April 2025 is recalled. CS-Com 337 of 2024 within bracket old CS4 of 2022 is restored in its original file. Consequently, all applications are also restored. Full stop. The plaintiff is directed to issue notice upon the defendant or defendants?
Well, only one defendant.
Upon the defendant as well as to the advocate on record of defendant by communicating this order and the next date of hearing of the suit as well as the interlocutory application. Let the matter appear on August 5th, 2025. CS GA-Com 6 of 2025 disposed of.
So great.
Next.
13. I have instructions to appear on behalf of the respondent.
Respondent, who is for the plaintiff?
Lord, in this matter, I was hopelessly out of time in filing written statement.
This application filed by you?
No. Application is by the plaintiff for restoration of the suit. But I have already affirmed the affidavit and the written statement, my lord. The fresh wakalatnama is also there. If your lordship kindly grants leave, I can put it on record. Let it not be accepted for now.
No, but the suit is not there. Where
Yes,
it is?
suit is
Let
not
they
there.
come first. Tomorrow, not today. Not today.
Kindly records my
Okay, record an order. None appears on behalf of the plaintiff. Census appearing for the defendant. For the interest of justice, the case adjourned. Let the matter appear tomorrow.
Lord, I beg to appear for the plaintiff in this matter.
Lordship, I am for the defendant in this matter.
Yes.
We have filed an application for extension of time to file a written statement.
Extension of time to file written statement.
Yes, we had received the writ of summons on 26th of March 2025. Thereafter, the defendant had to visit his hometown for a marriage, and therefore the 30-day period had expired. But soon after, when he had contacted us, he fell ill, and the documents could not be procured at that point in time, and no extension could be made then. So now we are filed the extension on.
Where is the written statement?
The written statement is ready. We'll file it. Just we are only praying for extension of time.
But there
It is for
extension of 5 weeks, my lord, 5 weeks from date. But I understand it's ready with them. Should be ready.
120 days.
Come with the written statement.
Tomorrow of time. Extension of time.
This court is having some other idea. Unless the written statement is not brought, I will not grant action. I will not extend the time.
Lordship, my senior is here.
Yes, madam.
See this, but the written statement is ready.
Come.
Yes, but tomorrow it will be difficult, because the client is. But by this week we'll affirm it. It is ready.
Come
only
on
the
21st.
accounts.
Come on 21st.
Yes, 20. Any which ways, 24 July I have to file it.
Correct.
So on 21st we'll do it.
Come on 21st.
We'll make it 22nd. The 21st have some difficulty.
21st notes, everybody has some difficulty.
Yes, well, everybody has some difficulty. That is the
Defendant has
reason.
filed an application for extension of time to file written statement. But this court finds that the no copy of the written statement is disclosed in the present application. Counsel for the defendant submits that written statement is ready. If any date is fixed, the defendant will come with the written statement. Accordingly, in view of the submission made by the counsel for the defendant, let the matter appear on 22nd July.
Obliged.
15 and 16 are my applications. Here, I'm out of time to file my affidavit in reply. Kindly extends the time till Monday, I'll file it.
My lord, I have one prayer today. My lord, may I just, my lord, take a minute, my lord, to explain the difficulty I'm facing. My lord, initially in this matter,
For the plaintiff.
no, my lord, I'm for the defendant.
Yes.
My lord, initially in this matter, my lord, your lordship had granted an injunction restraining me from operating, my lord, one bank account, and also restraining me, my lord, from creating any third-party rights in respect of a particular flat in Jaipur. The claim, my lord, across the two suits, 70 principal, 74 lakhs plus 20 lakhs of the two suits, collectively, my lord, 94 lakhs. Now, my lord, I had, my lord, submitted on the last occasion that the valuation of the flat itself is 1 crore 1 lakh. Therefore, the bank account need not be injuncted. Your lordship, my lord, directed me to file an affidavit. I was out of time. My lord, your lordship was kind and gave me 3 days to put in, my lord, the valuation of the flat and to disclose how much money there is in the bank account. My lord, the valuation, my lord, now we have filed our affidavit. My lord, we were out of time. My lord, in the meantime, the matter was listed again, where, my lord, nobody appeared. Because, my lord, the earlier advocate on record, my lord, quit the matter. The new advocate on record, my lord, came on record. There was confusion, my lord, between the two AORs. My lord, nobody appeared in the matter. On that day, lordship, my lord, passed an order, rightly so. My lord, a blanket injunction restraining me from alienating any property or operating any, my lord, bank account. My lord, this has brought my business to a complete standstill. My lord, having said so, my lord, I have now filed, my lord, my opposition, to which my friend wishes to file a reply. In my opposition, my lord, I have disclosed the valuation of that flat, which is 1.1 crore 1 lakh. My lord, I have also, my lord, stated there that this flat, my lord, is mortgaged with a bank, which has, my lord, funded my business. My lord, no shying away from that. And, my lord, I have also, my lord, disclosed, my lord, the money in the bank. But, my lord, what I have, my lord, disclosed additionally
which your lordship, my lord, would may perhaps appreciate, is that, my lord, there is a building which I own, which is unencumbered, my lord, which is not mortgaged to, my lord, any entity.
Residing over there?
I'm sorry, my lord.
You are residing in that building?
No, my lord.
Or
It is a
rented out?
it is a commercial building, my lord. And my lord, a certain portion of the building, my lord, has shops from where I get rental income. But my lord, having said that, that's my asset. My lord, it's a profit creating asset. So, my lord, that is, my lord, the land, my lord, and my lord, G+3 building. And my lord, it's in Jaipur. But my lord, despite it being like a land and building, the valuation, my lord, which we have shown, is merely, my lord, 1 crore 2 lakhs. 1 crore 2 lakh rupees. Even then, my lord, even then, my lord, the entire
claim of the plaintiff?
My lord, 74 lakhs in one suit plus interest, and 20 lakhs in another suit plus interest. Now, my lord, interest, of course, is an exorbitant, my lord, claim and extremely, my lord, ambitious. But, my lord, this particular, my lord, ground, my lord, plus 3 plus, my lord, the land, collectively I have a valuation report, 1 crore 2 lakhs, my lord, unencumbered. My lord, if I may only, my lord, suggest that your lordship may, my lord, spare me of my bank accounts and other assets. My lord, this would, my lord, unsecured, my lord, claim, genuine, my lord, disputes. I have a case, my lord, in trial.
Okay. How soon you will file?
My lord, by Monday.
On Monday. Tuesday, I am fixing. Let me.
My lord, right.
I am fixing on Tuesday. I will hear them.
My lord, in the meantime, my lord, because, my lord, I am in the railway business.
4 days, my lord, lordship will kindly.
My lord, what has happened? I'll tell you, lordship, what has happened, my lord. The father, my lord, the patriarch who's created all of this, my lord, he suffered a stroke recently. The son, who's 25 years old now, is, my lord, handling the entire mess. This includes, my lord, business with the railways, where, my lord, payments, my lord, payments have to be made regularly to contractors. Projects are, my lord, held up. My lord, kindly, my lord, the lordship may consider
Sufficient fund in any of the
My lord,
building that is 1 crore. This is your
my lord, a full ground
to
plus
the
3
bank.
story. My lord, kindly.
Plus 3, but the valuation of the building is
1 crore 2 lakhs.
2 crore and the two cases of 1.50.
No, my lord. My lord, 74. My lord,
74,
what have they shown? My lord, in their plaint, what have they shown? Bank transfer to me of 74 lakhs and another bank transfer to me of 20 lakhs. And they are pleading that there's an oral contract that I will pay X amount of interest. It's all oral. Not a single trace of paper, nothing signed. And my lord, I have disputed that was a loan.
That is perhaps not what is what is quoted from the record.
No problem. Let for the 4 days, you wait for 4 days. Come on Tuesday. In the meantime, you file. Come on Tuesday. I will take fix on as a new motion matter. I will take the new motion matter.
Well, I'm so grateful. I'm so grateful.
Come on Tuesday, because let the pleadings completed, then the whole application can be disposed.
Very well, my lord. Very well.
Without
My lord, my opposition, my lord, may be taken on record.
So your lordship was away and we all went off to sleep. We all went off to sleep. Lordship was away. We could
My lord, everybody went out to sleep, but my client was having sleepless nights, my lord. While your lordship was away.
Defendant has filed affidavit in opposition after serving a copy to the London Counsel for the plaintiff. Let the same be kept with the record. Counsel for the plaintiff prays for time to file affidavit in reply. Let affidavit in reply by file 21st of August 2025. 21st of July 2025. After serving the copy to the London Counsel for the defendant, release the matter on 22nd of July under the same heading.
Grateful.
Grateful.
My suit for recovery of money which were for price of goods sold and delivered, my lord, in the present suit, I had filed an application under Order 39 Rule 1 and 2 along with a 38(5), and thereafter, my lord, on the basis of the affidavit of opposition.
Have you served?
Yes,
Where
my
is
lord.
that affidavit service?
My lord, I have served on the last occasion. He has sought time on 2 or 3 occasions. Thereafter, my lord has made the matter returnable today for arguments, my lord. Their right to file affidavit in opposition was closed.
Interim order is extended till 15 July.
My lord, yesterday it expired. I had given notice, but since the bench was not available, my lord, I did not mention if the interim order can be extended, and I am ready to argue the matter as well.
Who is for the other side?
My lord, the defendants.
Nobody has appeared.
No, my lord, they were appearing before. Shomo Basu, 6 Old Post Office Street, my lord.
On the last 2 dates, 9 June is not appeared, 16 June is not appeared. He last appeared on 20th May.
My lord, we have served a notice on them. They are not filing their affidavit in opposition. The right has been closed. Even on 20th May, when they appeared, they sought time.
Okay, I am extending the interim order. Issue the notice on the next and file affidavit. If they will not come, then I will take up the matter in their absence. None appears on behalf of the defendant. The plaintiff submitted the interim order was till 15th of July 2025, but this court was not in session. Accordingly, he could not pray for extension of the interim order. Counsel for the plaintiff prays for extension of the interim order. At the land counsel for the plaintiff, the interim order is extended till 22nd of August 2025 or until further order, whichever is earlier. Release the matter on 19th of August 2025. The plaintiff is directed to inform the next date of hearing to the learned to the plaintiff as well as the learned advocate appearing for the to the defendant as well as the learned advocate appearing for the defendant, and to file the affidavit of service on next date fixed.
Item number 18, my lord, I am for the plaintiff, my lord.
Yes.
7th March order I am referring to, my lord, whereby my lord, GA number 1 of 2025 was disposed of, inter alia directing the lodgement of the summon where there was a delay. So that the GA number 1 is disposed of. Now GA number 2 is another application appearing. At least we have not filed that, my lord. I believe.
Who has filed the GA2?
GA2, my lord, we don't have a copy.
GA2.
Actually, we have got a
I am also instructed that GA2 has not been served upon me, my lord.
I am one of the director of the defend number 1.
But I'll have to check, my lord.
So allow them to serve a copy.
Prayer.
But I'll serve that in that event.
Let us prayer.
What the prayer should be for?
No, that
It is for
Extension of time to file return statement.
But that has been filed, my lord. Time file hoye gache?
Let
File hoyeche?
Give the copy to you. Give the copy.
na debe.
Yes, my lord. I think this has become infructuous now because I have already filed pursuant to my lord's leave of 18 June 2025.
Leave you granted, but subject to acceptance vote. No? Subject to acceptance.
Subject to
So it has to be disposed of. So
My lord, allow us
okay,
to
give
have
the
a copy and
tomorrow.
come back, my lord. So we will
Come
consider
tomorrow.
Written
but day after, my lord.
Day after.
Day after. Tomorrow day.
The concept on
Lord, day after I'm not available. Lord.
Monday, my lord. Monday.
21,
Monday.
21st. Defend number 1 has filed the present application being GA.com 2 of
22nd, my lord.
praying for extension of time to file return statement. A copy of the application is served in court today upon the learned advocate appearing for the plaintiff. Let the matter appear on 22nd July for hearing of GA2 of 2025.
Very good.
Next.
Lordship, I beg to appear on behalf of the plaintiff, Lordship. If there is a direction or grant your Lordship was pleased to grant leave to plaintiff Lordship to file a supplementary affidavit, Lordship. Lordship, this is an application for substitution and Lordship abatement of one day delay, Lordship, and that to Lordship considered earlier. Delay of filing the substitution application, Lordship.
Yes.
Lordship, that too, do you Lordship consider earlier that too because of the Lordship inconvenience caused by the department, Lordship. It was that Lordship before the puja vacation, just 4 days before the puja vacation, we filed it before the department, but department returned it on the last day of the closing day, Lordship. That there is some defect in the application. And but at that time we was unable to Lordship cure the defect, and on the reopening we filed the same, Lordship.
Yes.
So because of that, Lordship,
Have you received the copy?
yes, Lordship, we have application we have there is a direction to file the supplementary supplementary we have filed, and
What is the submission?
supplementary is regarding that, Lordship, in the application.
Which application? GA?
Lordship, GA 8 and 9, Lordship.
8 and 9.
Yes, Lordship. 8 is the substitution and 9 is the Lordship.
Substitution of plaintiff.
Lordship, heirs of the plaintiff, Lordship. Sole plaintiff.
Sole plaintiff died.
Yes, Lordship. Two son, Lordship, and in the application there are some.
Where do you mention?
Yes, we have not mentioned that, Lordship. The details of the heirs, Lordship. Only name was mentioned. That your Lordship was pleased to grant the leave.
Lordship, we were formally opposing this application on the ground of non-explanation of the delay, but
Delay, Lordship, we explain, and your Lordship considered on the last occasion. That is. Supplementary also we have filed, Lordship, it is on the it is in the record.
Where is the name?
Lordship, it's in paragraph, Lordship, 3 of the supplementary affidavit, Lordship.
3 of supplementary affidavit.
Supplementary we have filed in the department, Lordship, because there is a direction to file it in the within 2 weeks, Lordship.
Only 2 legal heir?
Yes, Lordship.
Both are son, there is no daughter?
No, Lordship.
Wife?
No, she was the, I mean, petition, plaintiff was the proprietor,
Lady.
Niyati Chandra, she's the lady, husband died earlier, Lordship, and the only 2 sons.
When she died? When he died? When she died?
Lordship, it's died on.
Where is the death certificate?
Lordship, it's enclosed with the Lordship, Annexure B, page 69 of my application, GA8, Lordship.
5th August 2024.
Yes, Lordship.
And you filed this application on November 24.
4th November, Lordship. We actually placed it on 4th August, Lordship itself, but
Plaintiff has filed the legal heirs of the deceased plaintiffs. Plaintiff, huh?
Lordship, one indulgence I'm praying, Lordship, on the last order, 17th order, that there is some inadvertently recorded, Lordship, mentioned me as a Lordship defendant. Lordship may kindly direct to rectify this.
Deceased plaintiff have filed an application being GA-Com 8 of 2024 along with supplementary affidavit for recording the death of the sole plaintiff and substitution of the legal heirs of the deceased plaintiff. Counsel for the plaintiff submit that the sole plaintiff died on 5th August 2024, leaving behind 2 legal heirs, namely Nikhil Ranjan Chanda and Ritish Chanda. Okay? Nitish Chanda. Police. Counsel for the plaintiff further submitted there is a delay of only 1 day to prefer the present application and prayed for condoning the delay of 1 day. Full stop. Learned counsel appearing for the defendant raised objection and submits that the defendant has not shown any cause as to why the plaintiff has not filed the application within the statutory period of 90 days. And as such, the suit has abated. And the application filed by the plaintiff is not maintainable. Heard the learned counsel for the respective parties peruse the materials on record. This court finds that the sole plaintiff has died on 5th of August 2024 and the application was affirmed on 4th of October 2024, but due to the procedure for filing the application, it was taken on record on 4th of November 2024. Accordingly, this court has condoned the delay of 1 day for filing the present application for substitution. At the learned counsel for the respective parties peruse the materials on record. The department is directed to record the death of the plaintiff and to substitute the legal heirs of the plaintiff as plaintiff 1A and 1B. Full stop. The plaintiff is directed to file the amended plaint within 2 weeks thereafter, after the amendment is carried out, after the substitution is carried out, and to serve the copy of the amended plaint to the defendant within a week thereafter. Release the matter on 27th of August 2025.
For witness section, it was going on witness section.
Let me complete it then. GA-Com 8 of 2024. And what is the GA9?
GA9 for Lordship condonation of delay.
GA
8 for substitution and 9 for condonation.
9 was, I think, my learned friend is a little mistaken. I think that was for setting aside the abatement of.
Lordship,
That's why I'm taking.
setting aside the abatement of 1 day, Lordship. Grateful.
Next.
I'm for the one pending.
But I'm for the plaintiff
petitioner.
petitioner.
Affidavit, may I have my lordship to file the affidavit in opposition?
Yes. You are for the plaintiff.
I'm for the plaintiff, my lord. This is my restoration application, my lord. My lord, by an order dated April 30, 2025, suit was dismissed for since I have failed to appear on the date when the matter was called. And this is my restoration application, my lord. My lord, I would want to submit, my lord, one thing on the last date when the matter was taken up, my lord. It fell from this honorable court that this suit should have been transferred to IP division of the honorable court because it pertains to infringement of a trademark, my lord. My lord, on that score, my lord, my learned friend asked for opportunity to file opposition, my lord.
Not on that score, but on the merits of the application.
Application, whatever, my lord. My lord, I have already filed my reply, my lord. I am placing the order dated, my lord, 38th April 2025, appearing as page 43, my lord.
Yes.
My lord,
Yes, affidavit. Now, what is your submission, ma'am?
The stand taken in the affidavit, will kindly take paragraph 7 with me at page 6 of their application. The stand taken by them is that despite numerous orders and opportunities granted to them.
Paragraph? Page?
Paragraph 7, page 6, minute.
Yes.
Of the application made by my learned friend, despite numerous opportunities granted to them for making amendment and also making the application, the suit commercial divisions compliant with it, they have the submissions is that they were unable to take steps because we'll see 5 lines from there from the bottom. Thereafter, the advocate record intimated the gist of the order, took steps to file an amendment application for compliance of formalities. Amendment application for compliance of formalities under the provision of the Commercial Court Act. At the juncture, advocate record was informed by the petitioner number 1, who is the instructing
that is
client.
correct. But madam, this
May I
is the
just say 2 things? With
No,
this opportunity.
only one question. If it is the IP matter,
yes,
can this court though have passed an order and subsequently when this court found that the order which this court is not having the determination, what would be the effect of the order?
Yes, but then at the same time, it was the duty on both of us that we should have intimated this.
Correct.
We could not intimate, not for whatsoever reasons, but not because of any other malafide intention, but then it did not strike us. So we did not intimate. This matter was appearing in the commercial division since 24th, since in fact, since April 20, July.
Pointed out, my lord, by an order dated
September
No, that's correct.
2024.
Now the intellectual court is
But the
already been
difficulty is
established.
that despite opportunities being granted to them, they have not taken steps
And
to either make it
now
commercial
the full bench
compliant also.
now our full bench judgment without the determination if any order is for that is non-est.
My lord, only one thing I want to submit, my lord. This particular suit was transferred to commercial division on September 20, 2024. However, no, that was transferred on September 17 and the division, IP division came in effect, my lord, from September 20. So within 3 days of transferring the suit, the IP division was constituted. Hence, my lord, this transfer was not at all bad, my lord. What happened, my lord, after transfer, the division was constituted, IP division, and then
That has been done.
whatever, my lord, but I
Yes.
was not there,
That's
my
the
lord.
merits of the application. The application, what the stand that they are taking is absolutely malafide. In 2022, we'll kindly have a look at the order. Melod's order of 2022 at page 20 of the application. Now, on that very day, I had intimated to the court and also to my learned friend that there has been a change in constitution of the partnership, and since then they have been taking time to make the amendment. I have also annexed the partnership deed. Sheer malafide. Will kindly take my opposition.
Yes.
We'll kindly have a look at the deed of their reconstitution, Millard. That is at page 8 of my opposition.
Yes, I got it.
7.
Yes.
But this deed was affirmed by them in the first day of April 2021. since the stand now taken is because I was not aware of the reconstitution or that there was the person concerned was ill. So that has been happening since 2021.
Argue before the court, having jurisdiction. The plaintiff has filed the present application being GA Form 4 of 2025, praying for recalling of the order dated 30th April 2025, wherein this court has dismissed CS Com 781 of 2024 for default. Consequently, our pending applications were also dismissed, and interim order, if any, was stand vacated. Full stop. Counsel for the plaintiff submit that the plaintiff number 1 is about 84 years and suffering from various ailments, is about 84 years and is suffering from spinal injury and is bound to wheelchair and is the father of plaintiff number 2 and 3, and they are looking after the plaintiff number 1. Due to some inadvertence, the plaintiff could not appear before this court, and this court has dismissed the suit. Learned counsel for the defendant has raised objection and submit that on several occasions an opportunity was given to the plaintiff, but the plaintiff failed to appear before this court, and time and again they are and even after the transfer of the case from the original division to the commercial division, the plaintiff has not taken any steps for compliance of the provisions of the Commercial Court Act.
We've also taken the stand that the plaintiff number 2 has all along filed the applications. He has been affirming the applications, not the petitioner number 1.
That though the plaintiff has taken the ground of illness of the plaintiff number 1, but all along the plaintiff number 2 is affirming the affidavits and all pleadings before this court, and as such the ground taken by the plaintiff is not at all justifiable and prays for a dismissal of the application. Had the learned counsel for the respective parties peruse the materials on record. This court has passed the order for dismissal for default of the suit on 30th April 2025. At the time of hearing of this present application, this court found that the suit filed by the plaintiff is connected with the intellectual property matter. But inadvertently the matter has not been placed before the before the appropriate court dealing with the intellectual property matter. And at the time of passing of the order dated 30th April 2025, this court has also not gone into the same. And as the suit is of and according this case, this court has dismissed the suit for default. This court find that the suit has been transferred from the non-commercial division to commercial division on 17th of September 2024.
2nd September 2024.
The order was passed, but the department it is showing on
2nd September 2024, and subsequently by 20th September 2024, the intellectual property division has been created. But inadvertently, the department has not assigned the number of intellectual property matter in the suit and has placed the matter before this court instead of placing the matter before the intellectual property court and before the court having the determination of the intellectual property matters. Considering the above, this court find that the order passed by this court dated 30th April 2025 by dismissing the suit for default is was not having any jurisdiction, having determination. And as such, the order dated 30th April 2025 is recalled. Full stop. GA Com 4 of
My lord, there is a interim order that was vacated, my lord. My lord, my prayer be
Recalled.
recalling. My lord,
recalled means what?
my
Recalled.
lord, let it be
The GA Com
reinforced,
4
my
of
lord.
2025 is disposed of. The department is directed to assign the IP matter in the suit and to place before the court having determination of the intellectual property matter.
Pure bad luck, my lord.
Next.
9, 7:30.
Lord, Applying for the plaintiff, lordship.
May I just
I'm for the plaintiff. My
this will
What is the order?
well, the matter is fixed before the apex court on
22nd July.
Yes, maybe, but this the direction from the apex court was to continue with this hearing this suit. Yes.
It will ultimately have an effect on whether the suit will continue.
Let me proceed. I'll not be able to finish. Let me proceed with the.
Proceed with what, the suit?
Yes, absolutely.
But there is an application.
There is no direction. My lord has asked the respondents to get a clarification. They have not got it. There is no direction for that. Direction is to proceed with the suit.
Yes, what is the stay argument?
Yes.
Argument.
Yes. Let me proceed, and I will not be able to finish it today. There is no direction.
My application is for
The direction lordship sees last order lordship passed when they moved their application. The direction of the Supreme Court was very specific that the suit hearing to continue and no judgment to be passed till the
Final decision is
absolutely. After that order, they came up with an application that it is not a commercial dispute. And lordship had yes. After that order was passed, now lordship had passed an order saying they have to get it clarified whether that hearing of that application is to be continued. And they did not get any clarification. It's been more than 1 year.
Yes.
So let me proceed with my suit. I will not be able to finish in the meantime. If they can get a clarification, well and good.
And in GS6 you have filed the affidavit?
No, there was because it cannot be heard. There was the direction of the Supreme Court to suit to be heard.
No, but that's correct.
That is why when they had initially moved the application, lordship was a specific view that the Supreme Court direction was very categoric that the suit to be heard. Whether this application can be heard or not, they had filed an application before the Supreme Court regarding this clarification, but they did not move that application before the Supreme Court.
Correct. Okay, come on 23rd. I am fixing on 23rd. 22nd the matter is fixed. 22nd the matter is fixed before the Supreme Court.
Yes.
If they will get the clarification, otherwise the matter will be taken up for hearing. Matter of 1 week.
Very good.
any event, logic demands that all applications which goes to the root of the suppose jurisdiction. Is my learned friend saying that the law court has directed
11 adjournments, there is no logic demands. 11 adjournments at a stretch, and this has been going on for the last couple of years. Oh, absolutely.
The matter is listed before the
You are not entitled to file the application itself.
The Supreme Court on 22nd of July 2025. In view of the above,
We have been seeing what has been going on.
adjourn. Let the matter appear on.
you also know what is going on.
Come on 24th July.
She fixes a time.
Come on that day. If it then I will fix the date.
She fixes. Otherwise, it will
Then
not.
I will go August.
Keeps is to be mentioned. Because if there is the Supreme Court is not continuing, has passed on, keeps is to be mentioned.
Has to be mentioned. Has to be mentioned.
Right.
Yes, next.
I'm a copy of the petition time. No, today I am little handicapped, my lord.
Why?
Apna Mamla. Others. Others. Apna Mamla. Title.
You are appearing for the plaintiff.
Lord, I am for the plaintiff.
Yes.
Lord, I am very sorry to say, my lord, the copy of the application is at present.
My lord, in 21,
Sorry,
I'm praying for not today, as the advocate for the defendant suddenly rushed to the hospital because of her mother ill health. Kindly fix any other date as your lordship pleases.
Plaintiff. Who is for the defendant?
Lord, I am for the plaintiff, Lord. There
I'm
are
a
two
defendant, the advocate for the defendant, Advocate Sumashri Saha.
Lord, there are two applications before your lordship, Lord. One is our application, which is GA3, which is an application for payment of occupational charges, my lord. My lord, this suit has been filed. Now, my lord, we are basing our application on a recent Supreme Court judgment, my lord, which says that after determination of tenancy, and if a suit has been filed, there are three situations where tenancy is sought to be determined. One is by decree, one is by determination by a notice, and after that, my lord, the defendant cannot continue to occupy the premises without making any payment. My lord, all that we seek for is in their written statement, which they have filed in the eviction suit, my lord. They have categorically admitted to certain rents, which is payable by them. My lord, all in this application that we are entitled to, we say, my lord, is on the basis of the admission in the written statement, the amounts that they admit for the number of months, that ought to be paid, and the same amount be continued till the time the suit is continued. Lord, that is my application. My lord. Now, if it's on person.
My lord, kindly fix any other date as your lordship pleases.
Who is your advocate?
Advocate is Advocate Somusri Saha. This Advocate Somusri Saha is appearing for the defendant, and suddenly she has to rush to the hospital for her mother ill health. Any other date, your lordship, as your lordship pleases.
As per prayer made by the counsel for the defendant, the case is adjourned. Let the matter appear on 22nd July.
Grateful, my lord.
Next.
My lord, kindly allow me to mention item number 6. I could not appear on time due to rain, my lord. Item number 6 was our matter, my lord. I could not appear on time due to rain, my lord.
Item number 6.
Yes, my lord.
Not today. Come tomorrow.
Grateful, my lord.
Yes, next.
This is the defendant's application under section 8 of the Arbitration and Conciliation
Item
Act.
21.
22, my lord.
Item 22.
Defendant's application under section 8. That suit has been filed by the plaintiff. In the plaint, they have disclosed the arbitration agreement. That apart, they had filed proceedings before the NCLT. Before the NCLT, they went and said, we have issued notice under section 21. They themselves have issued notice under section 21 for invocation of arbitration. Please allow NCLT proceedings to be withdrawn. They withdrew NCLT proceedings on the basis that they would go for arbitration. Instead, they filed a suit. It's a comedy of errors. Perhaps not by consent, the matter can be referred to arbitration. I'm not troubling your lordship with the papers. It's all here.
Please, I have nothing to say. What my learned friend has said.
I'll just indicate
Nothing to object, rather.
I'll just indicate to your lordship the relevant pages, not for your lordship's convenience. If your lordship is pleased to come to the arbitration clause, that is at page 145 of volume 1. The arbitration clause is at page 145.
Yes.
Lordship sees clause 18.7. We will have to take appropriate steps not to refer to the arbitrator. Now, Lord, if your lordship please sees a notice under section 21 issued by the plaintiff, that's at page 273, volume 2. Page 273, volume 2 is a section 21 notice. This is the plaintiff's notice under section 21.
Yes.
And they refer to the same clause which I showed your lordship, clause 18.7 of the general conditions of contract. That's the clause I showed your lordship. Now, Lord, we have responded to this notice under section 21 at page 277, saying that the arbitration agreement has a mechanism. You have not followed the mechanism, follow the mechanism. Lord, thereafter, Lord, if your lordship please sees the notice under the IBC for Lord, initiation of CIRP proceedings is at 268.
268.
268. This is a notice, Lord, under section 8 of the IBC for invocation of proceeding of the invocation of the NCLT's jurisdiction.
Yes.
And look, they withdrew at page 287, 27th of July 2023. The NCLT proceedings were withdrawn on the ground that they wanted to continue with arbitration.
Continue to pending arbitration.
Pending because Section 21 notice has been issued. And but thereafter, instead of going further with arbitration, they have filed this suit.
Lord, we have no difficulties, my lord, if the matter is transferred to for arbitration.
So who will be the arbitrator?
No, that they will have to initiate the appropriate give
Initiate,
notice,
take appropriate steps.
in terms of 18.7.
Yes, yes.
The defendant has filed the present application being GA Com 1 of 2025.
Cause of action.
Praying for dismissal of the suit and referring the parties to the arbitration. Mr. Samraj Sen, an advocate appearing for the defendant, draw the attention of this court to the agreement entered between the parties dated. What is the date of agreement?
Look, the agreement which I showed your lordship is part of the general conditions of contract. Look, the general conditions of contract start at page 48. Look, this is part of a construction contract.
Yes. Learned senior advocate, draw the attention of this court to the arbitration clause. To the arbitration clause. Yeah.
The date of the agreement, 26 February 2019.
26 February 2019. Along with the general condition of contract under Chapter 5, wherein in clause 18.7, there is an arbitration clause which reads as follows. Page 145, 18.7. यहाँ से लेकर के यहाँ तक. Mr. Sen submits that relying upon the said arbitration clause, comma, the plaintiff had issued notice under section 121 of the section 21 of the Arbitration and Cancellation Act on 5th of September 2022. 2022 for appointment of arbitrator. On appointment of on receipt of the said notice, comma, the defendant has replied to the plaintiff intimating that the arbitration clause is premature in presence of the negotiation clause thereto, and requested the plaintiff to complete the first steps, then you can invoke the second steps for appointment of arbitrator. Full stop. Subsequently, comma, the plaintiff had issued the notice of demand for initiation of the proceeding under the IBC code and initiated a proceeding before the NCLT being CP within bracket IB 67/MB/2022. And when the matter was taken up by the learned tribunal, comma, the counsel for the plaintiff informed the tribunal that the plaintiff is intending to continue with the arbitration proceeding. Accordingly, the proceeding initiated before the National Company Law Tribunal was withdrawn and the same was dismissed. Instead of initiation of arbitration proceeding, comma, the plaintiff has filed the present suit. Learned counsel for the plaintiff submit that if this that if the court will refer the matter to the arbitration, comma, the plaintiff will take appropriate steps. In view of the submission made by the counsel for the parties after perusing the arbitration clause, the parties, this could find that the suit is not maintainable as there is an arbitration clause between the parties and the plaintiff has acted upon the arbitration clause available in that agreement. In view of the above, parties are referred to the arbitration. The parties are directed to take appropriate steps for appointment of arbitrator in accordance with the clause 18.7 of the general clause of contract appearing at page 145 of the present application. Accordingly, CS Com 27 of 2025 is dismissed. GA Com 1 of 2025 is dismissed.
Great.
But I appear for the plaintiff, my lord.
I'm for the respondent. I'm told, my lord, the talks of settlement are on, my lord.
Not that we know.
Yes. My lord, talks of settlement are on, my lord. And today they are going to sit at 1 o'clock, my lord. That is what I.
Lord, we don't have any instruction, my lord. What are you
At
seeking?
their instance, my lord, that the talks of settlement are on, my lord.
Okay, come up.
My lord, kindly, my lord, extend the interim order and, my lord, the time to file opposition, my lord.
Counsel for the defendant submitted a talk of settlement between the parties is going on and prays for adjournment. Counsel for the plaintiff submits that the interim order is only up till 18th of July 2025 and prays for extension of interim order. In view of the submission made by the counsel for the respective parties, case is adjourned till 26th of August 2025. Interim order granted earlier is extended till 29th of August 2025 or until further order. Which
have extended their time to file affidavit in opposition.
There are two applications, my
It
lord.
is made clear that in the meantime, the parties failed to settle the dispute. The defendant shall file affidavit in opposition within 2 weeks. Reply, if any, they are to be filed within a week thereafter.
And my lord,
Release the matter on 26th.
my lord, kindly, my lord, extend my time to file opposition to, my lord. They have filed a section 10, which is GA2.
Yeah, accordingly, if the matter is not settled, both the parties shall file their respective affidavit in opposition within 2 weeks. Reply if any. Okay.
The beg to appear for the plaintiff, my lord, petitioner. There are two applications. The GA1 is, my lord, for judgment upon admission, and GA2, which I am willing to, my lord, rather praise today, is, my lord, under Order 38, Rule 5, my lord, for attachment, injunction, and, my lord, other incidental prayers.
Yes.
My lord, the suit is for, my lord, recovery of a sum of, my lord, 1,43 lakhs and odd, which has been admitted by their ledger. Now, if your lordship kindly first comes to my statement of, my lord, my particulars of claim.
It is completed.
No, this is coming for the first time. The only thing, my lord, there is a real threat. There is a real apprehension, my lord. I have pleaded that there is a real apprehension that, lord, the only property which I come to know left with the defendant is about to be, my lord, disposed. But I have pleaded, my lord, in paragraph 32 onwards.
GA1.
GA2. Now, my lord, I really don't have the occasion to know what they are dealing with, doing with their properties.
Paragraph?
The only property, paragraph 32.
32.
32, my lord.
Yes.
I factory ta describe korichi, paragraph 8 was it. Paragraph 32, if your lordship says that it has come to the knowledge of the petitioner that the respondent is and has become habitual defaulter insofar as the debts towards various other creditors are concerned, petitioner has repeatedly requested the respondent to either liquidate or execute debts which they have failed. 33, on the contrary, it has come to the knowledge of the knowledge and understanding of the petitioner that the respondent is in the process of liquidating his assets. Now, 34. The petitioner has further come to know from reliable sources certain persons have involved in the business related to that of the respondent that a company engaged in the similar line of business in the name and style, Shri Ramdut Ferro Alloy, such and such, herein after referred to his company, is in the process of acquiring the assets. Now, your lordship kindly skips over to paragraph 37, which is the most important. The petitioner has caused due inquiry, paragraph 37, I'm showing from page 13. The petitioner has caused due inquiries and have come to the startling discovery that the said company has already transferred a sum of rupees 9 lakhs and odd in favor of the respondent as part of the negotiations to take over and acquire the assets and properties of the respondent. Petitioner has further discovered that the same has been credited to the respondent in their bank account, which I have come to know. I have described the bank account.
Could I cut short the matter and indicate, well, my learned friend need not labor into this. But what had happened is there was a loan of 20 crores, which was obtained, 20 crores, in excess of 20 crores, which was obtained from the bank. The mortgage, this property, which my learned friend is talking about, is of WBIDC. We had taken it on lease. We had mortgaged the leasehold interest of this property. We were unable to pay the lease rentals. So this lease has been attached by WBIDC, and WBIDC really is transferring it to this Rajdut. And Rajdut will be directly paying to, has paid, Ramdut, who will directly pay to WBIDC. I am not getting a rupee, Mullah.
So
I am not getting a rupee.
We don't even want that. Only thing, Lord, Ramdut is not a party even.
You are the party.
With
No,
the
not
Lord, deepest of respect, Lord.
Interest is already with the consent of WBIDC
And the bank. And the bank.
It is in the process of being confirmed.
Lord, then
This is really the bank and WBIDC who are, my lord, who are putting Ramdut in my shoes. I am getting a rupee in my
in any case, Lord, with Lordship's permission, Lord, in any case, Lord, they are in a bad shape. There is no doubt about it. Now, my lord, I do not want, my lord, if my lord Ramdut, my lord, they are still not parties in the suit. My lord, the bank account is there, my lord, which I have described, that money has been transferred there. Now, if all the properties goes away, my lord, my suit will be ultimately defeated. So, therefore, if your lordship kindly pleases to, my lord, secure the amount in the bank account.
I am passing a short direction. Let the affidavit be filed.
My lord, let them not transfer the money lying in their account in the meantime. Otherwise, if it is transferred, everything will
Money
go
is
away.
not lying in my bank account.
Let them file the affidavit. It will clear.
Yes, money is not lying in my bank account.
And what about the Ramdut?
Ramdut is not a party yet, my lord. Perhaps, my lord, they
have not filed any application. If
they have not filed any.
To me, then I can file an application.
Lord, may I just submit this? May I just submit this? Lord, no relief is claimed against Ramdut. Ramdut, no relief is claimed against them. Lord, there is no reference of Ramdut even apart from, my lord, paragraph 37. Paragraph 37 is really an allegation against, my lord, the defendant, which they have to respond. Ramdut perhaps have nothing to say here even. Perhaps that can be decided on application if they.
The company has already transferred in the 9 crore in favor of the respondent.
Yes.
Which company?
The defendant. But I have not transferred.
No, I have said paragraph in paragraph.
Kindly come to the paragraph 37.
Yes.
The petitioner caused due inquiry and came to
the said company.
Which company?
The said company is described in, yes, in paragraph 34, Ramdut. So I have come to find from sources in the common business field that Ramdut has transferred this money in favor of the defendant in respect of certain transactions, some transaction which I really don't know about. I assume that it is a transaction relating to this property.
So
I don't know the real status of the property.
If that amount you are claiming, so why you are not made a Ramdut as a party?
I am not. I have no claim against Ramdut. Now, if Ramdut has transferred the money, my whole claim is, Lord, that the money doesn't go away, doesn't fizzle out of the hands of the defendant. The money is only secured. That's why I have mentioned here that these only I have mentioned to show, my lord, that certain monetary transaction has happened in respect of the only property left to the defendant.
Yes.
Now,
let you file the affidavit.
in any case, the respondent is in very bad health. My lord, that might, my lord, the money or whatever property is lying with them might, my lord, get away. My lord, let them at least give an undertaking that the properties that they have won't be, my lord, transferred in the meantime. And my lord, some security on the security on the money, my lord. Your lordship has seen, my lord, only one more thing, my lord, upon insistence. My lord, your lordship has seen, my lord, Rahul Eshra, my lord, 5 times a day. My lord, if I may just show one judgment which your lordship has passed, my lord, in my lord, just one, my lord, just for my satisfaction, my lord. Lord, Mr. Choyan Gupta, my lord, Mr. Gupta is, my lord, I'm thankful to him, rather. Lord, it is him, my lord, and my learned junior colleague here. Lordship kindly takes up. My lord, relying on Rahul S. Shah, Lordship has, my lord, found. Sorry, sir. আরেকটা কপি এই তো আছে একটা। Lord, kindly, if your lordship comes to internal page 3.
Yes.
Internal page 3, my lord, the plaintiff has relied upon email such and such, my lord, referred. Then, my lord, the plaintiff relies upon the judgment of my lord, Rahul S. Shah, Honorable Supreme Court. My lord, next paragraph, counsel for the plaintiff submits that the case of the plaintiff is squarely covered by the judgment of the Honorable Court. I'm sorry. Oh, I'm sorry, my lord. The last sentence of the second paragraph at third page. The court may at any stage in appropriate cases during the pendency of the suit using powers under 151 demand security to ensure satisfaction of any decree. This is, my lord, clearly, my lord, coming out of the principle laid down in 48.7 of Rahul S. Shah. This is, my lord, a clear, my lord, that is followed here. Counsel of the plaintiff submits that the case of the plaintiff is squarely covered by the judgment of the Honorable Supreme Court. Defendant issued checks, but that had been dishonored, and the defendant had been agreed the amount by an email. Considered submissions, the court finds that the defendant have issued check of such and such amount, which was dishonored. Subsequently, 2 checks have been issued for performance, so on and so forth. Thereafter, my lord, your lordship pleases, my lord, to pass a direction for securities. Now, my lord, here it was a case of, my lord, dishonor of checks, which can even still, my lord, have, my lord, defenses to it. One can raise a defense even in a case of a check. Here, my lord, there is a balance confirmation. If I may just show the balance confirmation once. Your lordship kindly takes up page 221, which might be in volume 2. Lordship. Lordship kindly takes up page 221 first. This comes after my demand notice. My demand notice is of September 2024, which I will show. Yes, November 2024, which I will show after this. Lord, page 221, first, my lord, your lordship finds at the very beginning, my lord, MB Ferroalloy, that is the defendant. Defendant is issuing this ledger in favor of, my lord, Nondi Trading, the plaintiff. Now, if your lordship kindly takes up the next page at 222, the closing balance, there, my lord, your lordship will find that the confirmation of date is there. They have acknowledged the date. And, my lord, further signed and sealed by the company on 20th of December 2024.
Yes.
Only, my lord, I'm seeking for, my lord, a security on this admitted amount, which your lordship has been, my lord, giving it, my lord. Mr. Gupta has also secured such
Whose account is? Whose account?
My lord, defendant's account. But this is the ledger of the issued by the defendant.
No, it's plaintiff.
No, page 221.
Plaintiff's prepared ledger for defendant's account.
No, page 221. Lord, it is stamped. Lordship will kindly see it is stamped and sealed by MB Ferroalloy.
Correct.
At page 222.
Correct.
Right, dekhalam to. And the
your ledger account. It is your ledger account maintained by the defendant.
That yes, my maintained by the defendant. The defendant is issuing this.
Okay.
It is issued by the defendant.
Correct. So 1 crore 31 lakh.
Yes, 1 crore 31 lakhs. And Lord, this comes after my demand notice, which, my lord, is at page 224. First demand notice is at page 220. I'm sorry, 229. 229 is my demand notice of November 27, 2024. And your lordship will kindly find from the subject itself, it will be clear that I have claimed a sum of rupees 1 crore 50 lakhs and odd. That, of course, includes interest. And thereafter, certain, Lord, part payments are also made.
I have claimed one.
Which, my lord, brings down my claim to a certain extent to the claim that I have made it today in my plaint. And, Lord, their security, they have admitted their debt. They have admitted their debt to the extent of
131.
131.
I have claimed 132.
My claim is 132. They have admitted 131. So, Lord, my whole prayer today is, my lord, till the time they come back with affidavits, they might, my lord, use, my lord, ploys.
But where is the, you're not, kindly come to the prayer. You're not mentioning your account, whatever it is. Which account?
But that is not.
37. You're telling you have taken the ground of the
Kindly comes to my prayer.
Property now the Ramzan. 37 I mentioned the
paragraph.
37
No, but today at this interim, ad interim stage, I'm not pressing. Not today at interim stage, I'm only pressing for.
Property belongs to whom?
Factory, in my my lord, knowledge and my lord, according to my information, my lord, belongs to the defendant. That's what I've said.
Assigned to them.
That's what I've said. I am not even pressing on the factory for this time.
That's why if it's not, so furnishing security, the so cause is to be issued A. And come the prayer A.
Yes, prayer A. Prayer A is my which remains.
Can't pass an order at this stage. Furnishing security.
But,
And with regard to the prayer B and C,
BNC, I'm
factory.
BNC, I'm really not in a position to pray at an interim stage. I admit that.
Correct.
Now, only thing is, Lord,
You have not
since
made a
the
prayer
Lordship
with
has-
regard to the account.
account, Lord, I've sought for furnishing security. If your Lordship, it is pleaded in
Furnishing
paragraph 37.
security is different thing.
Your Lordship can, in the powers, your Lordship can, Lord, at least.
Where's the account number? There is no account.
The account number I've indicated in page 37. I've indicated. I'm sorry, paragraph 37 in page 13.
You're not prepared for that. Yes, Mr. Gupta.
But they might also not furnish the affidavit of assets that they have today.
My instructions are that this money which my learned friend has pleaded in paragraph 37, this 967.50, it has come in the account, which is that loan account from which the bank is adjusted the outstanding. There was around 16 crores.
Now their demand will with regard to 1 crore 31.
Yes. So I do not have any money in the account. There was a default. This factory has been sold to not sold. This was transferred under the aegis of the bank.
Correct.
Bank has got that money out from my account. They have given it to my
Let
account.
them
that
furnish
will
the
be
affidavit of assets that they have now today.
take it. I shall file the affidavit of assets. Your Lordship will provide that.
File that.
Yes.
Not in a short
In
time.
my affidavit, I shall. Yes. In my affidavit, I shall.
Deeply.
Consistent with the
Bank
plaintiff
has a
has
first
filed the
charge.
present application
My
GA
approval
com 2. What is the one? GA1?
GA1 is not order 12 order 12 rule 6 judgment upon admission, which perhaps they need to file affidavits on that.
Plaintiff has filed an application being GA-Com 1 of 2025, praying for judgment upon admission, as well as GA-Com 2 of 2025, praying for interim order. Full stop. The counsel for the defendant prays for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Within 2 weeks, reply if any thereto be filed within a week thereafter. The defendant is directed to disclose their assets in their affidavit in opposition. List the matter.
Only one defendant.
There's only one defendant.
Only one defendant.
Defendant. Only defendant, huh? Not dependent. List the matter on 6th August.
6th August. Deeply. I'm grateful for the patient hearing your Lordship.
Pleasure to record the fact that we intervened and
Record an order.
Council
What is on
Ramdut
Ramdut?
Pero Private Limited.
Learned senior advocate.
30 points.
The
Prays
land
for
planted machinery have been
Ramdut.
right.
Where is the name?
Paragraph 34.
Paragraph 34, your Lordship will file.
Ramdut Pero Private Limited. There is no alloy.
Sri Ramdut Ferro Alloy Private Limited.
The alloy will not be there. That's wrong.
Alloy will not be there. Sri Ramdut Ferro Private Limited intend to intervene in the matter as the factory.
Land at the factory.
Land and the factory is being transferred by WBIDC or bank. Bank is transferred.
WBIDC and the bank.
WBIDC is the owner of that property.
WBIDC as well as the bank has transferred the factory along with the land along with the factory in the name of Sri Ramdut Ferro Private Limited. Full stop. In view of the above, comma, the plaintiff is directed to serve the copy of GA2 of 2025 to
May I, Lord, kindly let them file an application. Not after the application, we can.
only I am giving only with regard to this application. The suit I am not allowing.
But we can provide the cause title to them if they need to, Lord, file the application.
Serve
Lord.
the copy
The
of
entire
this
application, Lord.
application being GA2 of 2025 to learn advocate appearing for Sri Ramdut Ferro and their liberty to file their affidavit in opposition within 2 weeks, reply if any. It is made clear that this court is allowed to intervene in the matter only with regard to this application, not in the suit.
Not supplying the inter subject to correction, supplying the inter application will not disclose certain information that you don't want to disclose. Lord,
What
if
can
they
be
need
done?
to intervene, Lord,
Your
they,
case is there, otherwise this court could
Lord,
not.
if they want to intervene, Lord, only the cost title suffices. Lord, that's your Lordship, Lord. I'm so grateful, Lord, for the patient hearing.
And the liberty is given to file wakalatnama within a week from date in the department.
Behalf of Shri Ram.
Behalf of the Ramdut Alloy Private Limited. Yes.
Great.
May it please your lordship, this is my application.
I'm appearing for the defendant. We have not been served till date.
What? We are moving.
Last occasion also we have appeared, but and asked for a copy of the application, but it has still not been served. That a copy may be served upon us, and the matter may be kept after 2 weeks.
They wanted to
but we wanted to move.
Add interim, madam.
Lordship, since we are appearing, kindly a copy may be served upon us, and we shall come back.
Okay, send the copy. Come tomorrow.
Come tomorrow. Okay,
Come tomorrow.
No
problem.
We are.
My only humble
I will here tomorrow. I will here. Let us send the copy, but make sure I will take the matter at interim injunction application hearing tomorrow. You are appearing. I am allowing you to serve the copy.
Only one thing I should indicate. Only one thing I should indicate. They had moved a Section 9 application where their injunction prayer was refused against my client.
Okay.
There is no challenge to that.
Okay,
My client.
Come tomorrow. Serve the copy today itself. The
Lord, may I take note for slightly some time, Lord, because this suit was filed on 25th of April. Lord, we are in July. Lord, there cannot be any urgency, that they need to move it.
That's why I will hear tomorrow. They wanted to argue the matter.
Lord, if it could be
praying for the
on Monday, Lord, then we could take some instructions and come back. Lord, they filed it on in April. Lord.
We were trying to move it, but the business of the court did not permit it to be moved, because this court was not there. Otherwise, we had immediately filed the suit, taken the leave, and filed this. And the difficulty, may I indicate why the urgency, and may I only restrict now to that, and then my learned senior friend come back with instructions that the CIBIL report is being affected for reason of this. Your lordship would recall, my lord, when I was presenting the plaint for leave under 12A, the urgency was that, my lord, this loan which was taken, our digital signatures were implanted in this agreement. I did not receive anything. They came to the company, that loan got squared off. Now, on the strength of that, further amounts have been given for which my CIBIL report is being hampered. So, I have annexed that report. Okay. It's for that reason. That is the urgency.
Counsel for the plaintiff is directed to serve the copy of the application along with the documents to the advocate appearing for the defendant in course of the day. This is the matter.
Lord, for defendant number 1, my lord.
Defendant number 1.
One.
Let the matter appear on 18th July.
Friday. I'm declared.
Friday.
Need the petition. No? Happy for the plaintiff petition in this matter. My application for interim relief.
I had an application under section 8 opposition I've received just yesterday. I need to file a reply to that, and also the opposition to the injunction application I'm filing it here.
My lord, may I tell your lordship, my lord? 20th May, directions were given for exchanging affidavits, and the matter was referred to mediation at the suggestion of the court.
Lord,
Mediation
we have
failed.
opposition to Mr. Thakkar's application. No reply has come as yet. We have filed within time.
Why have you not served the
time,
reply?
but no reply has come.
To
No
Mr.
reply has served on us.
To Sena and Company? GA1. Very well. It's been served on me. Anyway, so my lord, 20th May, directions were given to file affidavits, and the matter was referred to mediation. Mediation failed. 10th June, the matter came before your lordship, my lord. No affidavits filed. Section 8 application came to be filed. Your lordship's desire was that both matters would be heard together. Further directions for affidavit given. 23rd June, further directions for affidavit given. Today, the matter is coming up for hearing.
Yes.
Their Section 8 application, my lord,
which they have filed. The respondent numbers 2 and 3 have filed. I don't wish to use an opposition. Let them argue the matter. They filed their affidavit today, taking the orders of the court for granted that whenever they come, they'll file an opposition. Your lordship will accept it. When the time to file affidavit in opposition expired on 1st of July, I wrote them a letter that your time to file affidavit in opposition is expired. Please give me a copy if you filed it. Nothing, there's no response. Today, if they want to file, let them file, my lord. I am not stopped coming in the way of a filing of an affidavit, although it's delayed by 3 occasions. Let them press their section 8. They file, now they don't have the time to file an affidavit in opposition. They file one section 8. During the same time, they file an application for revocation of leave granted under 12A. So intent is to delay the hearing of the main injunction application.
Section 8.
Section 8 is filed by respondent numbers 2 and 3. Let them press their section 8.
So he's not filing the affidavit.
No, I'm not filing any opposition. It's a question of law. I'm not using any opposition. Let him use his 8. Let him also move his GA3, my lord, which is for revocation of clause 12A leave. To that, my lord, I've served an opposition without directions from your lordship. Because the whole intention is to delay.
Mr. Sen, you are appearing to?
No, for respondent number 1.
You are not filed any.
Lord, we have filed our opposition within the extended time to
Opposition of their application.
the interlocutory application. We have not received any affidavit in reply.
I'm told the GA1 reply has been served. I'll just check.
No, it has not been submitted.
Okay,
let him move his 8 and 11.
Same morning, he's telling that he's not pressing his opposition. Otherwise, I would have sought time for a reply. As I have submitted.
I don't want to file a reply. You can't force me to file a reply.
Let me submit. The lordship keeps it tomorrow. I will hear after session. Just tomorrow.
Why tomorrow?
The matter is fixed in the list.
Your lordship kindly see also the conduct. On 11th July, they filed and they served me an affidavit in opposition to my section 8 with blanks. I don't know how it was.
No, I did not use any section 8 opposition. What are you saying?
He is telling that.
Please, I have not used a section 8 opposition.
Served me, then let me show that he has served.
I will record. Might be served. Or he is not using that.
No, that is an my lord, my learned friend is misleading your lordship with the greatest of respect. Kindly let him show the opposition which is served. That is to GA3, which has not been moved till date, which is an application for revocation of the leave granted under say 12A.
If my learned friend does not indicate to which GA he is filing an opposition, how to
Yes, because the GA is not numbered. You have not moved it. Your intention is to delay the proceeding.
All I am praying, your lordship keeps it tomorrow. I can come back tomorrow and hear out the GA.
I am ready. Let you start. Your section 8 is not filing your application.
Yes, it's his application under section. My lord, I've to the only affidavit in opposition which has been used in GA1 within time, I've served a reply to Mr. Sen's client.
Lord, we stand corrected. It has been served.
That was section 8 also. I am not ready with the judgment, sir.
Huh?
I am not ready with the judgments. Let me come back tomorrow, just one day, your lordship. I will come back tomorrow. Your lordship, because I did not have the knowledge that I have to move the section 8, your lordship. That is completely my fault.
Once the matter is listed, why you are not come ready?
Pleadings are not yet complete. I did not know my learned friend would withdraw his pleadings.
I am not filed a section 8 opposition. Where's the question of withdrawing? My lord, he has filed another application which he wants to spring as a surprise on me and the Honorable Court. That is the 12A revocation, dispensation revocation. Let that application also be listed tomorrow. Let him argue that also.
What is the GA?
Your lordship, that is GA3.
The plaintiff has filed an application being J1 is your application?
Yes,
interim
please.
order?
Yes.
Praying for interim order, wherein the defendants have filed their affidavit in opposition. You will not file affidavit in reply.
My lord, to his opposition, I'll file a reply within a day. Tomorrow, I will file it. Kindly keep.
He has also filed a supplementary affidavit.
Yes. The plaintiff prays for a day's time to file affidavit in reply. Let affidavit reply be filed by tomorrow. After serving the copy to the learned counsel for the defendant. Full stop. The defendant number 3.
2 and 3.
2 and 3 have.
My lord, I'm paying for costs, my lord, for filing the opposition today after obtaining 3 extensions.
Paying for time, filed an application. J2. Your application is J2.
Section 8 is GA2.
Filed an application under section 8 of
GA3.
the Arbitration and Cancellation Act. Section 8 of the Arbitration and Cancellation Act, praying for referring the parties to the arbitration. Counsel for the plaintiff submit that the application and the plaintiff will not use any affidavit in opposition. Let the matter appear tomorrow for hearing.
My lord, along with my lord, his GA3 which he's filed with. I have already served an opposition in GA3.
The defendant number 2 and 3 have also filed an application being GA-Com 3 of 2025, praying for revocation of
I'm asking you what is the plan?
leave under section 12A of the Commercial Court Act. Full stop. You will not have.
I filed. I've already served an opposition.
Already filed affidavit in opposition after serving.
But if they intend to file a reply, let them file it within the day.
Number 2 and 3. You will file reply. You will file reply.
I will file a reply. It has
Let
been
them
served-
file it. Let him
it
file.
was served last day only on
Full stop.
15th.
The
Yes, it's not moved till date.
full stop. Let the reply be filed by tomorrow.
Yes.
By tomorrow.
Lordship, 3 days.
Then how the matter can be taken?
Let me start with the section 8 tomorrow.
Okay. Let the let the reply be filed. आज कितना तारीख है? By filed by 21st of July 2025 after serving the copy to the landed counsel for the plaintiff. Please the matter tomorrow for hearing of GA 2 of 22.
Lordship is not inclined to grant my prayer for costs, my lord, for this fight.
Lordship, just one indulgence, Lordship. I was served also with a supplementary affidavit. My learned friend is not relying on that.
Which supplementary?
That I served before the affidavit directions were given. Please let him.
15 July, it's
Which supplementary affidavit?
Third, yes.
affidavit filed by our client by way of service to you on 15 July.
Well, in GA1, I filed a supplementary affidavit. Your lordship will kindly take it on record. It is for bringing on record the disposal of the mediation, and
Then allow me to deal with that.
he'll file it within 3 days. Let him file it.
15th is just yesterday, your lordship.
What they have disclosed?
There's not one scrap of document there.
What they have disclosed?
Let him place it.
Only the mediation failed.
It's here, my lord. The GAT, your lordship will see the supplementary.
Supplementary तो क्या है?
The copy though. Why do you file it in the department when the matter is in court? Supplementary affidavit affirmed yesterday. কালকে আছে GA1 টা ডেট দেননি শুধু GA2
So, your lordship, to my respectful submission, para 12 is actually intending to widen the scope of the GA1. So I have to deal with it.
Your lordship has given him time to file a reply to 3 days. Let him file a report. If he wants to file a further opposition, let him file it.
This is also GA1, no?
Yes.
So here it's just in CS.com. No GA number is indicated.
Supplementary in GA1.
Yes.
GA1, you have 3 days along with you deal with the supplementary also. It is made clear that the defendant is liberty to deal with the supplementary affidavit filed by the plaintiff along with the affidavit in opposition in connection with GA1 of 2020. This is the matter tomorrow for hearing of GA2.
Your lordship will fix a date for GA3 and GA1 on.
Come on, then let it be complete.
Come tomorrow. Great. Deeply. GA1 has supplementary Sinakon.
My lord, in item number 27, I appear for the plaintiff, and my GA1 is my ad interim injunction order. My lord, as per the direction of this honorable court, I've already
GA1?
GA1, my lord,
Yes.
is my ad interim injunction application. I've already served upon them. Despite the service, they are not present. So I would like to move the application ex parte, my lord.
Service completed?
Yes, my lord. As per the direction of the honorable court, I've
Only
served.
one defendant.
Only one defendant, my lord. The urgency is that, my lord, there is an admitted business transaction between both the parties, and there is an admission on behalf of the defendant by their advocate's letter, which is marked as Annexure D.
You have supplied the materials.
Yes, my lord. I have supplied the material and they have received it. And I have raised invoices which they have received it without any objection.
Material served. Material is supplied.
Material supplied, they have partly paid the amount after.
Where is that? You are arguing through the mobile phone.
I just have the. Well, all my invoices are as marked as Annexure A. Which is page number 19 onwards. And if you see, my lord, the annexure D, which is the advocate's letter of the defendant, they have accepted.
Exhibit D.
Exhibit D.
Which paragraph it is admitted?
My lord, they have accepted that there are certain amount which has been due, and after I filed the mediation application, they have partly paid around 2 lakhs after filing of the mediation application. So right now the outstanding amount is around 12 lakh 16,198 without the interest, and along with the interest, it will be around 13 lakhs 89,531 rupees. So, my lord, they have only 2 properties which I have able to stress out from other business partners. One is the bank account, and another there is a immovable property, which I have already pleaded in para 28 and 29 of my application. And my lord, if you see, they have taken the advantage of the GST, which I have filed in my GST portal. They have claimed those GST, but despite claiming of those GST inputs, they have not paid the remaining amounts.
What was the total material supply? What was the total amount? Material supplied to the defendant?
Material supplied towards the defendant, the total amount.
What was the total amount?
The total amount was 99,000. There was the amounts were supplied in various tranches. The total amount was 22 lakh 76,952 from 22 lakh 776 lakhs from 22 lakh 76,952. They have already paid me the remaining amount. Only the amount amounting.
Oh, the total amount was 22 lakh 76,000.
952 rupees.
952.
Already pleaded in para 6
and
of
they
my
have
application.
paid in 15 lakh, which is total 15 lakh 19,900.
Correct, my lord.
5 lakh 19,900
Correct.
out of 22. Then
my lord, the total after I have filed the mediation application, they have paid me another 2 lakhs.
after the mediation,
After the
receipt of the email 9, they have paid 1 lakh 65.
1,65,000. Then I have filed the mediation application. Thereafter, they have again paid some amount.
Where is that? Where you mention mediation?
Yes, my lord. So the outstanding amount was 15,91,198 pleaded in para 14. After adjusting 1,75,000, the remaining amounts before the mediation was 14,16,198. And in my lord, in para number 23, subsequently after I have initiated the mediation process, they have paid me 2 lakhs. So at present, the outstanding is 12,16,198, which can be reflected in my ledger marked in Annexure E.
So out of 15 lakh, first they have paid the 1 lakh 75.
1,75,000 they have paid, and after I've initiated the mediation process, they have again paid 2 lakhs.
Two lakhs. So 15. So what was the outstanding?
right now the outstanding amount
Like
is
16,000.
right now the outstanding is 12,16,198 without the interest part.
Yes.
And
What is your prayer here now?
my lord, my prayer is to injunct their bank account and the immovable property up to that amount, 12,89,000.
Check out. Where is your details of the bank account?
My lord, in paragraph 29, my lord.
You not prayed for any.
28 and 29, my lord. Bank account details in page number paragraph number 28 and immovable properties detailed in paragraph number 29.
The plaintiff has filed the suit paying for a decree for a sum of rupees 13,89,531 along with interest at the rate of 18% per annum from 1st May 2025 till the realization of the total amount. The plaintiff has filed the present application praying for interim ad interim order. Full stop. This court has directed the plaintiff to serve the copy of the application to the defendant, and accordingly, the plaintiff had served the copy of the application along with the document to the defendant, but in spite of the receipt of the notice, none appears on behalf of the defendant. The affidavit of service filed by the plaintiff be kept with the record. Full stop. Counsel for the plaintiff submit that the defendant had supplied what you have supplied.
Nuts and bolts, my lord.
Defendant had supplied nuts and bolts as per the requirement of the defendant to the defendant from 13th August 2020 till 24th of March 2023 for a total amount of rupees 22,76,952. Out of the total outstanding amount, the defendant has paid initially 6,85,754, leaving aside an amount of 15,91,198. Subsequently, on 27th of subsequently, on receipt of the demand notice, the defendant had paid further amount of rupees 1,75,000, leaving the balance amount of rupees 14,16,198. As the defendant has not paid the total amount, the plaintiff has initiated pre-mediation process, and after the pre-mediation process, the defendant has paid further amount of rupees 2 lakh, leaving aside the balance amount of rupees 12,16,198. Counsel for the plaintiff submit that in spite of the notice and several requests, the defendant has not paid the amount, and now the plaintiff came to know that the defendant is going to siphon off the amount in favor of third party and also going to alienate the landed property. Police counsel for the plaintiff submit that if at this stage an interim order is not passed, the plaintiff will suffer irreparable loss and the landed counsel for the plaintiff peruse the materials on record. This court has given an opportunity to the defendant defendant to appear before this court, but in spite of service of notice, none appears on behalf of the defendant. This court find that the total material supplied by the plaintiff has supplied the materials to the defendant for a total sum of rupees 22,76,952, out of which Initially, the defendant has paid 6,85,754, and subsequently, the defendant has paid 1,75,000. And after the mediation, the defendant has paid further amount of 2 lakhs. Still, the defendant is liable to pay an amount of rupees 12,16,198 along with interest at the rate of 18% per annum. It is a specific case made out by the plaintiff in the present application that the plaintiff came to know that the defendant is alienating and siphoning of the amount from this bank account, and also is trying to alienate the property. Considering the above, this court find that the plaintiff has made out a FIC case and variance of convenience and inconvenience in favor of the plaintiff. And at this stage, if the plaintiff will not, if this is an ad interim order, an ad interim injunction is not passed, the plaintiff will suffer irreparable loss and injury. Accordingly, the defendant is restrained from dealing with the bank account number 255405001596 of ICICI Bank Limited, Bankra branch situated at village Bankra, Kabarpara, KABR Kabarpara, PS Domjur, Howrah, West Bengal, by leaving aside an amount of rupees 13,89,531 till 14th of August 2025. The plaintiff is directed to serve the copy of plaint, application and all.
Paid we, my lord, 13 August instead of 14 August.
Pardon, my lord,
So the copy of the plaint, application and documents to the plaintiff immediately, to the defendant immediately, and to file the affidavit of service on the returnable date.
Much obliged.
I beg your pardon, my lord. I was in court number 14, my lord. There's no junior appointed in this case, my lord. That is why no one is appear before your lordship.
What do you want?
I
already dictated order. Come on, that yes.
Next matter, there will be only a direction for exchange of affidavits and application.
Which one? 41?
28.
28.
I appear for the plaintiff, my lord. That's my application for judgment on admission. I don't stand in the way, my lord.
You want to file affidavit?
Yes.
First move. Yes, my lord. This is a new application.
What is the application for?
This is for judgment on admission.
Suit for recovery of money, my lord, out of goods sold at some.
Counsel for the defendant.
One thing, my lord, the application is scary. My lord, the application has 8 volumes. Kindly, my lord, allow me 3 weeks time.
Counsel for the defendant prays for time to file affidavit in opposition in connection with GA Com 2 of 2025. Let affidavit in opposition be filed within 3 weeks. Reply if any.
The affidavit of service be kept on record.
2 weeks. This is the matter. This is the matter on 26th of August 2025.
Obliged.
The affidavit of service filed by the plaintiff be kept with the record.
Obliged.
Call the fixed matter.
And I'm going to complete the chief.
Sandeep Sethia. SUND double E. Double E.
Yes.
Mr. Sethia, what was the rate of interest originally agreed upon in respect of the fixed deposit?
The rate of interest was 6% per annum, payable for the first 6 months. In other words, on the 28th of May, 1985, the fixed deposit would,
In other words,
on the 28th May, 1985, the fixed deposit would be worth
what? W what?
20 lakhs and 60,000 rupees. What was to happen to the fixed deposit after 6 months? After 6 months, the defendant asked for refund. The bank should have refunded 20 lakhs and 60,000 rupees, but it did not. The defendant was constrained to file a suit for recovery of its money, which it did in 1987.
Which it did.
Was that suit contested by the bank?
Yes, it was contested by the bank.
What did the bank say it had done with the fixed deposit in that suit?
The bank alleged that it had adjusted its claims against some foreigners. It that's what they adjusted. They made, at first they filed a written statement saying that they had alleged at first it filed a written statement in 2004 saying that it had adjusted the fixed deposit before 2004. Later, after the RBI deblocked the fixed deposit account in 2006, the bank amended its written statement to say that it had adjusted the money in 2006.
How much money did the bank say it had adjusted?
The bank said that it had adjusted 20 lakh 60,000 rupees.
You are there.
I didn't even turn to say, I'm sorry. I noticed that Mr. Dutt, he's meant to cross-examine. I'm just doing the chief. Not. See? In the present suit, what is the amount the bank claims that it adjusted against the dues of a foreigner?
The bank maintained throughout the old suit that it had not adjusted a farthing more, a penny more than 20 lakhs and 60,000 rupees. It denied any responsibility to pay further money during its deposition, in its written arguments, and in its appeals. However, the bank has now disclosed that it has appropriated 1 crore and 10 lakh rupees approximately. It has disclosed documents to show that it did this by 2 separate manifolds. It did this by 2 separate manifolds, one for 20 lakhs and 60,000, and the other manifold for 89 lakhs approximately.
Were these documents disclosed in the 1987 earlier suit?
Only the manifold for 20 lakhs and 60,000 rupees was disclosed in the earlier suit. The remaining documents were disclosed as part of GA 2680. 2680 on the 8th of August 2017 as Exhibit Q.
As Exhibit
Q.
Who had filed the application GA 2680 of 2017,
The
which
plaintiff,
you refer to?
The plaintiff bank.
In the I have given production of this particular application.
I think it's important to mention that the plaintiff denied that these documents had been suppressed in the earlier suit.
Do you remember in what document the plaintiff has denied that it had not disclosed such documents in the earlier suit?
In yes, I remember. In the additional written statement, in paragraph 13, it is written that the documents were always within the knowledge of the defendant number one. In addition to that, this was untrue. Sorry, this was untrue. In addition to that, some of those documents were appended to the amended written statement of 2006 as if they had been disclosed in 2006 at the time of preparation of the judge's brief of documents. This was pointed out to the advocate of the plaintiff.
2680.
Pages 280 to 291 of the judge's brief of documents were not part of Exhibit 1/4, as they seem to be in the judge's brief of documents.
I am showing you from the records of this court a document of which production was given by the defendant today, by the defendant number one today. Can you tell my lord what is this document?
This is GA 2680 of 2017.
Is there any portion of this document which you referred to in your earlier answer? Now, what is the portion of this document which you referred to in your earlier answer?
The first part is paragraph number 25, where it says that despite best efforts, these documents could not be traced and included in the judge's brief of documents when the appeal was being heard or when the SLP was taken up for hearing by the apex court.
But since it's a part of the court record, I'm not exhibiting it. Yes, just to.
And of course, Exhibit Q is attached to the
at page
just at page 79 from page 79, I should say. Exhibit Q has been disclosed in the judge's brief of documents separately.
I'm showing you page 56. Page 56 of the judge's brief of documents, volume 1. 56 to page, I'm sorry. 66, 56 to 66. Are these, what are these documents?
These are part of Exhibit Q.
It should be annexure Q.
Is there?
That should be, and he's referring to it as, because it'll get confused with.
Annexure Q.
Annexure Q.
Through court. That whether that 56 to 66 are the part of GA
yes, part of GA 2680.
Which page?
He's given the page.
I've given
the page, but he's referred to it as exhibit. There'll be confusion later. Okay. So I was praying that if it can be corrected to annexure, otherwise
annexure
annexure Q or exhibit
annexure
Q. I'm sorry, Manoj, please answer the last line. These documents.
As a,
Annexure Q.
Q.
as a matter of fact, it goes up to page 72.
Annexure Q.
Page 56 to 72 are part of Annexure Q.
Please come to page 56.
Yes.
Of the judge's brief of documents. From this document, can you say what was the rate of interest the bank alleges had accrued on the FD?
Well, as per the computation of the bank, the rate of interest kept changing, starting with 8% on 28th of May, 1985. But this rate of interest is not a correct rate of interest. It was compounded, according to the bank, all the way up to August 2006.
Why do you say this rate of interest was not correct?
After having asked for refund of its money, RK Agencies Limited was not obliged to accept arbitrary or low rates of interest as applied by the bank. It was not even obliged to accept fixed deposit short-term rates of interest, which the bank might have applied. The lending rate of the State Bank of India on that date was 16.5%. 0.5%.
From where have you obtained this information that the lending rate as on that date, i.e. May 1985, was 16.5%?
From the table of interest rates provided by the bank.
I'm showing you a document marked Exhibit 6. Disclosed by the plaintiff bank. Can you tell, my lord, what is this document?
These are the interest rates provided by the bank as obtained from the website of the Reserve Bank of India of historic interest rates.
According to this document, what would be
just a minute.
Of historic interest rates.
As of historic.
According to this document, what would the rate of the lending rate of interest be in the year 1985?
According to this document, in column 6, the State Bank of India interest rate in 1985 was 16.5%.
Now, according to the defendant number 1, RK Agencies, what ought to have been the rate of interest that the bank would permit on the FD after the first 6 months?
Well, the bank has indicated that it regularly earns the base lending rate plus 4% on advances. And this is what it would have been earning on our money. Compound interest at base lending rates plus 4% for all this time.
So according to you, what ought to be the rate of interest as in May 1985 after the first 6 months period had expired of the FD?
20.5%.
What would be the demand of RK agency till date based on such calculations?
If one computes the interest up to today, it comes to a little over 116 crores.
Have you personally calculated or computed such interest to check the correctness of what you just said?
I have done.
Well, we have disclosed two documents today, one document today by letter. May I show that? Original to Now, one more question. Are you in a position to disclose the computation that you have made today?
Yes, I am. I have prepared it and forwarded it to my advocates.
I'm showing you a document disclosed by the advocate of the defendant number 1 under letter dated July 15, 2025. Can you tell my lord who has prepared this document and what is it?
This is the document that I have prepared and shared with the advocate on record of RK Agencies Limited. It is the computation in a similar structure to that prepared by the plaintiff on page 56 of the judge's brief of documents. It gives the comparison of the plaintiff's own computation of interest as against what the defendant believes should be the computation of interest.
On what document have you based the figures that are contained in your computation?
It's based on the figures obtained from Exhibit 6, which I just verified, and where there was data missing, it was taken from the website of the RBI.
Do you stand by the contents of this document, the correctness of the contents of this document?
Yes, I do.
May I tender it as exhibit?
This is the
It's only a computation.
If he says he has done it, my lord.
Well, this letter also should go in so that it's identifiable later, disclosed under the letter date. Well, may I say that tender the covering letter and the document. Exhibit 18.
It could have been certified or it could have been signed.
I can make him sign it. Mr. Setia, please sign and or initial the portion of these documents which you say you have prepared.
Yes, exhibit 80. 18.
Roughly, according to your calculation, what would have been the defendant number 1's claim at the time of filing its written statement in this suit, i.e. 2017?
From the calculation given, it can be seen that around November 2017, the amount was about a little over 40 crores. Yes, which is the figure that was written in the written statement.
Over 40 crores. I could actually show you. Then, besides the claim for rupees 40 crores on this account, has the defendant number one made any other claims in its counterclaim?
Yes. Apart from this money, which represents what the bank was actually earning from the money of the defendant, there is a claim for costs, which we have estimated at 1.5 crores, of which we have estimated at 1.5 crores, of which about 90 lakhs is the direct legal billing on this suit or on this litigation since 2014. And in addition to that, we have claimed an amount of 40 crores because of the misdirection and the false averments and the harassment and the fraud perpetrated by the plaintiff.
Why do you say that the plaintiff bank has perpetrated fraud?
When the earlier suit was filed in 1987, the plaintiff bank had already applied to the Reserve Bank of India for permission to adjust the foreign claim against SL Sethi Liners Limited. And the Reserve Bank of India had already denied the permission. The plaintiff bank knew that there was no legal basis for it to retain the fixed deposit for this purpose. Yet, it suppressed its correspondence with the RBI, and it put the burden to obtain RBI permission upon the defendant and used that excuse to delay legal proceedings and to continue to illegally enjoy the fixed deposit of the defendant number one. It was later discovered that the RBI had refused the permission before the suit was filed.
Last line to prove. It was later discovered. Mr. Setia, the bank, the plaintiff bank, has disclosed a document claiming to be an RBI permission being Exhibit 7. What is this document?
It seems that this is a permission of the RBI, which it has disclosed in the course of this suit. It has nothing to do with the fixed deposit of the defendant number one. And when the plaintiff approached the Supreme Court, that permission of the RBI was not necessary, prior permission of the RBI, sorry, was not necessary. It did not disclose this document.
Now, you have stated that the plaintiff bank is guilty of misdirection and false averments. Can you give any particulars? Exhibit 7. আলাদা করে তোমার witness দিয়েছে আলাদা করে দিয়েছে
For the sake of brevity, I shall limit myself to 3 specific examples.
3 specific examples.
The first is the allegation by the plaintiff that it held a decree in England against SL Setia Liners Limited. The second was the allegation that the account of SL Setia Liners Limited was transferred from London to Bombay, and therefore FERA would not apply.
Capitals.
Would not apply to its adjustment. And the third allegation was that no interest beyond 60,000 rupees was ever due or payable or paid by the plaintiff on this fixed deposit.
Are you aware of any, with reference to your first example, are you aware of any decree passed against SL Setia Liners Limited in favor of the plaintiff bank being disclosed in this proceeding or at all?
I have not seen it, and the plaintiff's witness has never seen it.
You have stated that the bank has falsely alleged that there was a decree. Do you remember any particular averment or document or pleading in which they have done so, in which it has done so?
There are several such averments. There are affidavits which have been disclosed in the present proceedings where chief managers and assistant general managers of the bank have deposed that the bank held decree against SL Setia Liners Limited. I believe there are 8 such documents.
I believe there are 8
such documents on the record, starting in 1987 and finishing in 2016.
Have all these documents been disclosed as exhibits in the present suit?
They have.
Now, regarding your second allegation that the bank falsely alleged that an account of a foreigner had been transferred to India, do you have any, what do you say to that?
This allegation was referenced in the judgments of the single judge and the division bench. It is explicitly entered in the special leave petition filed by the plaintiff, and it is there in paragraph 16 and 17 of the plaint. It's not true.
Why do you say that it is not true that the bank had transferred a foreigner's account to from London to Bombay?
Because the plaintiff, the witness, has disclosed the document, Exhibit 7, I believe, which shows that the accounts of, there are 2 documents, Exhibits A26 and Exhibit 7 will prove that the account of SL Setia Liners Limited was closed in London on 31st of December 1986. The money was transferred to the profit and loss account of the London branch, and it seems that the profit and loss account of the London branch was transferred to the London branch of the Bank of India. No asset of the London branch was transferred to India.
Did the bank identify who the inverted commas, the foreigner was as referred to in the, again, inverted commas, foreigner's account? Now, who the foreigner was in respect of, inverted commas, the foreigner's account?
The bank has identified on different dates, different identities for the foreigner, and it still seems not to have decided who the foreigner was. For example, in the Supreme Court, the plaintiff wrote categorically that the foreigner was not Drum Place Limited. Then it filed the plaint, and the declaration sought in the plaint would indicate that the foreigner was either SL Setia Liners Limited or Drum Place Limited. Then it has disclosed documents which show that in its accounting for the adjustment of the fixed deposit, Drum Place Limited does not appear at all. So it's really not very clear who the foreigner is in the mind of the plaintiff.
What was the stand taken by the bank regarding the identity of the foreigner before the division bench in the 1987 suit?
Before the division bench, there have been so many identities. Before the division bench, the foreigner was the Setia group of companies, an account which, by all appearances, never even existed.
Never even existed. Did the bank disclose any decree against a foreign company before the division bench and this in the instant proceedings? Do you know of that?
The bank appeared before the division bench on the final day of the hearing of the appeal. The senior advocate of the bank, the senior counsel of the bank, produced the Queen's Bench judgment against Drum Place Limited on that day. An application was made, and it has been disclosed already, where the bank claimed to have found that decree only yesterday. The counsel for the bank waived the decree and demanded an opportunity to be able to enforce the decree against Drum Place Limited. And it is for that reason, to enable that enforcement, that the division bench granted a stay and allowed continuation of litigation. And it is under that stay that this suit has been filed by the plaintiff. Needless to add, the fixed deposit of the defendant continued to be enjoyed by the plaintiff all this time.
Then this thing. You had stated today that you are giving 3 examples or instances of fraud. Do you remember? Do you remember any other instances which you would like to tell this honorable court?
Yes, the bank knew that Ranjit Singh Sethia did not own and control SL Sethia Liners Limited and Drum Place Limited. The deposition of Mr. Chopra, which has been disclosed in the criminal trial of his predecessor at the London branch, when it is read together with the correspondence of Zaiwala that the bank has submitted, has disclosed, suggests that the bank's London claim against SL Sethia Liners Limited was not a genuine claim. But that is not any concern of the defendant in this suit.
Now, you have disclosed a document marked as Exhibit 15, subject to objection, of a certain of a deposition passed in a criminal proceeding. Do you know who was being prosecuted by who was being prosecuted?
Yes, the defendants in this, or the accused in these proceedings, were Rajinder Singh Sethia, Mr. Babulal Bengani, and Mr. B.R. Patankar.
Who was Mr. Patankar?
Mr. Patankar was the ex-AGM or DGM, I can't remember, or DGM of the bank in charge of the London branch. The other 2 gentlemen were directors of ESAL Commodities Limited, ESAL Commodities Limited.
How is now? Are you connected to Mr. Rajendra Singh Sethia in any manner?
He is my father's youngest brother.
Are you or your father, or for that matter, SL, are you or your father connected with ESAL, ESAL Commodities Limited?
No.
Is you wrote it no. Was Rajendra Singh Sethia ever connected with RK Agencies Limited, the defendant number 1?
No.
In the plaint, I just got 3, 4 more. In the plaint, please have a look at the first prayer.
On the last question, can I say no? There is nothing has been disclosed to suggest that he was. That he ever was.
That he ever was. In this present suit, brackets is shown plaint, prayer rate to the page 614. In the present suit, the plaintiff has claimed that it is entitled to exercise a lien and adjust and or set off the fixed deposit proceeds. What do you say?
There can be no lien on the fixed deposit of the plaintiff once it is admitted that there is no claim against the plaintiff. This has already been adjudicated, and it is also explained in the judgment of the single judge at page 462 and page 464.
Which, what page numbers are you referring to?
Page 462 and page 464.
It need not be a question. I'm showing you page 462 of the judge's brief of documents. Is this the document you are referring to? Now, is this the page that you're referring to? .462 then?
No, this is not the page I'm referring to. I remembered it wrong.
Let it go down. This is not the page number I am referring to. Judgment of
The page is in the same book. I'll find it if we are given a minute.
That's in a judgment of
Recorded, no? This is not the same page.
How that you?
I think it's covered between page 547 and 549. Yes.
The judge's brief. I thought the judgment is 462 pages. It's not. No.
Yes, next.
Now, I'm showing you a document disclosed at page 527 of the judge's brief, marked as exhibit. Follow exhibit copy. A by 1 by 11. What is this document?
This is the judgment of the learned single judge.
Was this the judgment you were referring to in your
yes
earlier answers? Yes. Now, in the plaint, that's fine. I just want. In the plaint, the bank has alleged that no RBI permission was required for adjustment of these dues of a foreigner. What do you say to that? Adjustment of the dues of a foreigner with the FD. What do you say to that?
I disagree. This was the same proposal put by the bank to the Supreme Court, that neither permission was required, and if it was required, it need not be prior permission. And the Supreme Court dismissed the petition.
In the no. Mr. Setia, can I take it that you have perused the records of the 1987 suit as well as the present suit?
Yes.
In the records, have you ever come across any fixed deposit register disclosed by the bank?
The bank was asked to produce the fixed deposit register in the course of the earlier suit to prove its contention that the fixed deposit had been maintained until 2006 and had not been closed before 2004.
Closed.
Before 2004, as it had alleged in its original written statement. The witness of the bank agreed to produce the fixed deposit register, but he did not do it even after being reminded. In the present suit, the witness has said that there is no need to refer to the fixed deposit register, but he has averred that the fixed deposit was maintained until 2006.
Was RK Agencies Limited given any notice that its fixed deposit proceeds were being adjusted against the dues of a third party prior to at all? Not prior to, at all?
No.
Did RK Agencies Limited ever consent to the proceeds of the fixed deposit being adjusted against the alleged dues of a third foreigner or against the profit and loss account of the bank?
No.
In the I'll finish it tomorrow. Then I just got one or two things left, man. My learned friend is in some difficulty tomorrow, then I'll do it tomorrow because I don't want him to.
It's fixed tomorrow also?
It's fixed tomorrow and day after.
Tomorrow you will not cross.
Millard, I got stuck, Millard, in another court from 12.
12:30.
It's not that I
will
might be on.
finish. I can finish today, but I'll keep this just to see this tomorrow. If my learned friend is in difficulty tomorrow, we'll see. But this day
And
after,
Millard, only
he's
thing-
come from Pune. Day after you do.
He's come from Pune. I'll start then day after because he's come from Pune. I can't.
Let him complete then.
Let him complete tomorrow, Millard.
Defendant witness is present. And examination in chief resumed. During his examination, one document is marked as exhibit 18. Due to paucity of time, the examination could not be completed. According examination chief is deferred. The matter is already fixed tomorrow at what time? 12:30.
May I have your lordship leave to just mention the immediately the next item, 29. There's a lot of urgency. I understand your lordship will be taking up company matters.
29.
29, my lord.
Money Square.
Yes, my lord. My lord, there's a lot of urgency. Will your lordship take it up at 2 o'clock, my lord?
What, an interim order?
Yes, my lord.
You are appearing.
I'm appearing for the respondents, my lord. I'm led by Mr. Sarkar. I was requesting if it be taken up tomorrow, if it's not ready. Be taken up tomorrow.
Tomorrow?
Well, tomorrow may it then be at the top of the board, my lord. I'm very grateful.
Tomorrow is
For respondent number 3, my lord.
Yes. Tomorrow.
Very grateful.
Lordship, at the cost of being severely admonished, my lord, at the cost of being severely admonished, my lord, may I mention one matter, my lord, for drawing up and completion of an order dated 16 June, extremely.
So the matter could not be taken up. I'm praying Lordship kindly fixes the time and date so the matter can be heard.
Which matter?
Item number
Company
60.
matter?
Company matter of item number 60.
With
of petition.
urgency.
Lordship, I'm for one of the secured creditors. There, in terms of there's a consortium of secured creditors. There was a manner passed in the minutes of meeting in terms of which the assets were to be distributed by the liquidator. That is not being followed, Lordship. That is the urgency, my lord.
Okay, let us see how far with this court will go, then we'll see to that. Yes.
No, your senior. Seeking leave to file this application for transfer of the proceedings to the National Company Law Tribunal, Kolkata. The cost title that we have, they said, it's different in their file. So they told us, to seek leave to file with this cost title.
Leave granted.
My lord, may I be permitted to mention the company application, my lord? This was returnable today, my lord. For some reason, it has not appeared, my lord. There's some urgency in the matter, my lord. This gets taken up only once a week. And my lord, we have served, we have the affidavit of service also.
Why? क्यों नहीं है? हाँ. Next week.
My lord, can it be kept tomorrow or day after, my lord, as a specially fixed matter?
Because all company matters I am taking, this court is taking only on Wednesday.
I understand, my lord.
What is the urgency?
My lord, in terms of a scheme of amalgamation, my lord, I was supposed to be allotted certain shares. Now, in view of certain non-compliances by the company itself, those shares were not allotted. Now, behind my back, my lord, they have transferred an entire business undertaking, my lord. That's extremely prejudicial to me, my lord.
What you want?
My lord, at interim stage, obviously, my lord, stay of that sale. Otherwise, it will become infraction.
When the sale is fixed?
My lord, in fact, from the disclosure, we find they have already executed an agreement. So, my lord, that has to be stayed, my lord.
वो तो सब फिक्स है ना, कोई टाइम बीच में खाली है, वेडनेसडे छोड़े कोई टाइम खाली है नहीं है? ना बीच में अभी ये अरे भाई अभी बीच में बोल रहा हूँ ये वीक फ्राइडे थर्सडे फ्राइडे कल तो थर्सडे फ्राइडे कोई टाइम है नहीं है नॉन कमर्शियल मैटर तो होगा नहीं मंडे कोई टाइम फिक्स नहीं है Wednesday come on Wednesday.
My lord, will kindly fix a time on Wednesday then?
Wednesday it will be on 2 p.m. at the top it will come at.
Right.
हाँ टॉप में ठीक हमसे बात कर लो लेकिन इसको मार्क करके रखो यस
Please, your lordship, this is that Avni matter. When I had made my submissions regarding transfer of the proceedings to the National Company Law Tribunal, if your lordship remembers that, the home buyers, and then some home buyers, we agreed to execute the conveyance. Your lordship made a list, and thereafter, it was decided to transfer. Two applications are appearing on your lordship's list today. One, is CA 82 that's filed by my learned friends.
Lordship, I am appearing for the applicant in CA 82 and in CA 83 I am for R1. Lordship, I am being led by Miss Swati Dalmia in the matter, Lordship. She is on her legs before another court, Lordship. I am praying for a short...
I'll tell your lordship very honestly, Miss Dalmia reached out to me last night. So because she was under the impression also that we will file because she belatedly filed an affidavit in opposition that we'll use her affidavit in reply. But it was on a point of law. That's why we didn't want to multiply pleadings by not filing. And I told her that I will not press in her absence. I know for a fact that I told her that. So I am ready. Otherwise, I have actually made my submissions regarding transfer. Regarding this application, I can complete my submissions. My learned friends can respond. Or if she wants to do that on the same day, I am entirely up to your lordships.
Next week?
Next week.
Because I assured her, it's not fair on my part.
Lordship, I want to.
Well, just one thing, the interim order may be extended. Designated. Handing over of the office. That handing over of the office.
That is in 83.
Yes, yes. Because that we filed a recalling application, recalling of the order. And
CA 82. CA 82 2025 in CP 1 of 2026 and CA 83 of 2025 in CP 1 of 2016. Okay. Counsel for the respondent in CA 82 of 2025 and counsel for the petitioner in CA 83 of 2025.
no, it's the opposite. She's respondent in 83 and petitioner in 82.
Petition 82. First में आएगा ना counsel for the petition CA 82 and counsel for the respondent CA 83. Praise for accommodation. Accordingly, cases adjourned. Let the matter appear on 23rd July.
Lordship, in CA 83, I'm filing my opposition.
The interim order in CA 83 of 2025 is extended till 23rd of July 2025. The affidavit in opposition
in 83. CA 83.
The respondent in CA 83 be kept with the record.
I'm sorry, Manoj, I was ready to make my point. Just that.
No problem, sir.
Grateful, Lordship.
Now, for the official liquidator 5, 6, and 7, my lord, your lordship's direction was to file a report because there was an order. Lord, so far in respect of the CA number 85 is concerned, Lord, I am filing this report.
CA 76, what has happened? Filed affidavit?
No.
CA 76, there is a direction, official liquidator press for time to file affidavit in opposition.
Yes, my lord, that I will seek, my lord, only 1 week's time, my lord.
1 week time. Let record this first. Item number 5. The official liquidator, who is for the petitioner? He is not here.
He is not here.
And the counsel for the official liquidator press for extension of time to file affidavit in opposition. Let affidavit in opposition be filed by 22nd.
22nd.
After serving the copy to the learned counsel for the petitioner, release the matter on 23rd.
I am deeply blessed. I shall communicate.
Or he will file affidavit in reply.
Yes, my lord.
Okay, let you file then. Yes, call the next. 85.
My lord, this is my report, my lord, as per your lordship's order. Yes.
Yes.
This is the 2 quotation, my lord, we have received. The officer received these 2 quotations.
Renu, SB Creation Software and Elegant.
Yes.
6 lakhs.
Do not have any copy of this quotation. One is from Renu SB Creation Software Private Limited and another from Mrs. Elegant System Powerway Private Limited.
Elegant has given 6 lakhs rupees. And SB Creation, software one time. Project cost 2,15,000. GST 38,700. See, go through. Because the other Elegant has not given any
Right.
details.
My lord, the SB Creation has given.
SB has given the detail, but you have to check whether these details is covered the requisition given by you.
Yes. that I am-
So you do one thing.
Yes, my lord.
So I am giving the copy to you,
Yes,
and you
And
sit with the official
official liquidator to leave to get the copies of this.
and sit with the official liquidator and check whether this all the things are complied or not. If it is not, then
Yes.
see to that.
Very-
And counsel appearing for the official liquidator has submitted report along with 2 quotations received from SB Creation and Elegant Systems Power Private Limited with regard to purchase of account software in the office of the official liquidator at Kolkata. As per the quotation, 2 firms have submitted to list of. क्या बोला? Submitted the quotation, na? Full stop. Let the copy of the said quotation submitted by SB Creation Elegant System Power Private Limited be supplied to the learned advocate for the official liquidator, and the official liquidator is directed to verify whether the said quotation is complied with all the requirement for the purpose of account software in the account software in the office of the official liquidator at Kolkata. Let the matter appear within a week or
within a week.
Let the matter appear on 23rd. Report be kept with the record. Report along with the original quotation be kept with the record. Okay. Next.
9-0. Yes. 7.
Item number
7.
9.
Item 7.
7.
Okay. So, sorry.
But your lordships kindly turns to page 5, annexure A. This is the order of your lordships dated 16th April 2025. And my lord, the communication was made also to the auditor, my lord, page 6.
Yes.
And my lord, in reply, that communication, page 7, my lord, the chartered accountant, my lord, intimated to the official liquidator regarding acknowledgement of this letter. And my lord, he is asking for certain documents to be submitted to him for the purpose of, my lord, accounting. So, my lord, I am your lordships kindly keep this matter 2 weeks, recording the filing of report and next report also.
Learned counsel for the official liquidator has filed the report. Let the same be kept with the record. It is submitted that it reveals that on 1st May 2025, the office of the official liquidator has appointed C. Ghosh and Company as auditor to audit the half-yearly accounts of 116 companies for the period from 1/10/2022. 1/10/2022.
But I am told that all the documents required to be submitted, that has already been submitted. So it is now their time to submit the report to the official liquidator.
31st of March 2024. On receipt of the said letter, the C. Ghosh and Company has requested the office of the official liquidator to provide required documents. He has provided
that documents, yes.
The learned counsel for the official liquidator to submit that in terms of the said letter, documents have been provided, but audit report has not been received and paid for 2 weeks' time. In view of the submission made by the counsel for the official liquidator,
let them submit a report, my lord.
Liquidator
That is Ghosh chartered accountant.
Adjourned for 2 weeks. In the meantime, the auditor appointed by the official liquidator is directed to submit the report to the official liquidator. List the matter on 30th July.
30th July.
Yes.
Lord, item number 8, my lord, the same order may be passed. This is also same purpose. Lord, the auditor has already been appointed, my lord. He was sought for direct
same
documents. Same, my lord.
Item number 8 also.
I'm deeply obliged.
In item number 9, my lord was hearing CA 22 of 2017.
Yes.
Mr. Bose was not submitting, my lord, last day.
My lord, I was thinking, my lord, whether we should be issued a rule of contempt for not complying with your lordship. I really have nothing to say. My lord, it has been almost 25th of June. We are almost,
let them not take any adjournment on this ground.
My lord, there was a direction given by your lordship at para 6, based on the suggestions given by us, that we should come back with a compilation.
But I'm opposing any kind of adjournment on this ground.
Well, I have no money. I mean, I really have nothing to say. And of course, he has every right to say whatever he does.
Because my money is stuck. Milad, let him not take adjournment. Kindly, Milad, let him not
money,
take adjournment.
money
this
being
round.
stuck has got nothing to do with this application. Be that as it may.
Let him say, let him undertake, then money.
It is not a
nothing to
question
do,
of
then
my
we
giving
will-
an undertaking.
Yes.
If there is an order of court, there is an order of court. If you have not appealed against that order of court, that order is binding upon you. Be that as it may, my lord, coming back to the order of 25th of June.
Yes, compilation of the order.
No, my lord. Documents, my lord, we... না বলো না এসব বাজে কথা বলো না তাওনি রেডি করনি
There was an order, my lord, passed by the Honorable Justice
Well, if
Shobhakachi
your lordship
Bhattacharya.
recollect, this is the matter. Probate proceeding. So there was a compromise. We filed for recalling. Supreme Court gave us that liberty. Our interpretation of that liberty is that we can still maintain the fact that I continue to be the legal heir, one of the contributors. There are no creditors of the company which is in liquidation. So eventually the money, which is the proceeds from the sale of the assets of the company, which are the immovable property, it will eventually come back to the all the contributaries. So I am saying in one particular line, I am one of the legal heir. So that's the whole object. Whether if I am, then I get entitled to some. So what my learned friend is opposing, his share will get reduced. That's all. He will get his money, but his share will get reduced. So that's what they are opposing. So for that, my application has to be heard. So this is the only point.
Yes.
So where compilation is not here, what do I say? But can I just come back? Can I?
No, Milad, I'm opposing to this prayer. Milad, this is nearly a month. Milad, Milad was not there.
My
Milad,
prayer is before the judge.
Kindly, Milad, don't. Milad, kindly, Milad, this is Milad, Milad.
Can you give us, Milad, a few?
Gupta, then without all documents, how the court?
Milad, he has not done it deliberately, Milad. I'm using this word.
Correct.
Kindly allow me to use this word, Milad.
They are not
This was not done. This was not done deliberately.
Because now they start submission. I will not
Milad,
adjourn.
we all know, Milad, we all know, Milad.
Document not on record.
I appreciate, Milad, we all know that Milad only takes up this matter once a week. 1 day gone means 1 week, 7 days in the meantime. So, Milad, these we all know, Milad. We have also, Milad has also seen these things. We are also seeing that, Milad, this happens. Milad, we all know, Milad, but let him start. Let him start. Milad, let him not take adjournment on this ground.
What purpose should be served if we start the documents is not on record?
Absolutely, he knows. He knows.
Yeah,
Milad, let some cost be
CLT
put, Milad, from the next day, everything will be in line.
Yes, Mr. Boss, why you're not prepared?
That's what I said, Milad.
Let his client suffer.
But this is what I was telling them. I was so annoyed. I really have no answer to this.
We all know, Milad, let his client suffer, Milad, something.
Milad, may I come back? Subject to Lordship's convenience on the 24th.
23rd, I think so.
23rd. 23rd, I am in some personal difficulty.
No, Milad, this is too much. This is too much.
Can I come back on the 24th?
Company matters only one.
This is too much, Milad. We all know, Milad.
Can allow me to come back on the 30th, Milad?
Wednesday, only Wednesday.
Milad, kindly, Milad.
Wednesday, I am not in Calcutta.
Please, Milad, kindly. Milad, then let them make some alternate arrangements. Let them make let them make some alternate. He can join virtually.
By Milad, all these submissions, Milad,
Milad,
kindly.
yes. If you are at fault, you cannot take a march.
No heavens will fall.
Yes, heaven will fall.
On the 30th.
No, Milad, this is Milad.
Proceedings have been continuing from 1973.
Yes, no. Milad,
on 23rd,
yes.
Let your compilation come on record.
Very well.
Come on record. Then I will, on 30th, I will take up for it.
Very well. Compilation will come on the 30th. Very well. Very well.
Again, the matter will be adjourned.
Very well.
Yes, Mr. Dasgupta, I will hear. Let the compilation come on record.
I always, Milad, bow down to your lordship, Milad. Milad knows, Milad. Only thing, Milad, let the clients understand, Milad, everything is not for free.
You know, once the matter has come in my list, then it will be done.
It will be, Milad, that, Milad, I know. But only, Milad, litigants should know, Milad, everything is not free. Milad, they should be, Milad, taught a lesson.
Mr. Manak Bose, learned senior advocate, appearing for the applicant in CA 22 of 2017. Praised for extension of time to file compilation of the document in terms of the order passed by this court dated 25th of June 2025. Mr. Dasgupta, learned advocate, Nirmala Dasgupta, learned advocate, appearing for the respondent number 2. Raise objection, submits that one or the other reason the applicant is dragging the matter and press for and press and submit that let the matter be taken up for hearing without the compilation of the document. Full stop. This court finds once this court is of the view that the compilation of the documents are required for proper adjudication of the matter, and as such, for the interest of justice, time to file compilation of the document is extended for a further period of 1 week. Let the compilation be filed on 23rd of July 2023.
Oh, yes.
Is the matter on 23rd July?
Let kindly put a default clause at this time.
Yes, okay. It is made clear that on the date fixed, if the applicant fails to file the compilation of document, the matter will be taken up for hearing, whatever the document available on
Without the documents. Well.
Next.
My lord, item number 10, my lord, I am for the applicant, my lord.
Yes.
My lord, I am for the
Yes, my
official
lord.
liquidator. May I submit a affidavit of service, my lord, in compliance with the order?
My lord.
আমি কি করবো 11 আমি আছি না আমি আছি
No, my lord, item number 10 is my application, my lord. This is for the demarcation of a property, my lord, 14B on the Talal Street, my lord.
Item number 10.
Yes, my lord.
Yes.
My lord, there was a direction on the official liquidator to do the needful for demarcation of the property, my lord, that the 14B Amritulal Bo Street from 14A Amritulal Bo Street, my lord.
আমার নোট কোথায় রে
These are all connected matter.
Yes,
Yes, my lord. This is also all connected.
These are all connected. Manually, kindly take up along with
my lord,
together.
only whether the compliance has been done, my lord, a copy may be served to me, my lord.
Yes, my lord, I have
Documents.
No, my lord, I have submitted the affidavit of service, my lord, showing that this order of this Honorable Court dated 19 September 2024, if your lordship kindly turns to page 6.
Yes.
My lord, that is the order, my lord, regarding the demarcation.
Hmm.
Now, my lord, in terms of this order, my lord, your lordship kindly turns to page 5. The official liquidator on 11th November 2024, my lord, requested the Chief Valuer and Surveyor, Kolkata Municipal Corporation, to comply with the order for the purpose of demarcation. But we visited therein, but nobody turns up on behalf of the corporation.
They are not appointed any.
They are not,
for
nothing.
demarcation? There is, which portion of the order there is a direction?
Lord, kindly see.
My lord, the second page, my lord.
Internal page 2.
Two, my lord. Second paragraph, my lord.
This juncture, my lord, according to Learned Counsel for the official liquidator 6 time till after the upcoming puja vacation, such exercise to be completed. At this juncture, Learned Counsel for the applicant points out that by the order dated 8th August 2024, the cost of survey were directed to be borne by the applicant. However, in the meeting of the contributories, the minutes of which has been annexed at page 126 at present application, all the contributors had given their consent to demarcated 14B Amritolal Bose Street, Kolkata 7,05,000 from 14A Amritolal Bose Street, Kolkata 7,05,000 upon construction of a boundary wall, and the cost of such construction of the boundary wall was to be come out from the fund available in the company in liquidation. So, my lord, as per this order, my lord, I have the official liquidator sub communicated this order to the chief surveyor, valuer and surveyor on 11th November 2024. But they did not make any response.
Yes.
High Court panel.
Lord, your lordship,
Impaneled surveyor can corporation will never come.
Very well, my lord, your lordship kindly
If the
appoint.
corporation come, then other litigation will
Right.
Yes, sir. Grateful.
Kindly, my lord, appoint, my lord, the High Court's, my lord, panel.
Impaneled
surveyor.
আমার লিস্ট আছে না? So I will say it, this copy of this list will be provided to you. You tell that.
So, my lord, your lordship kindly.
Or this court can name.
Yes, yes, my lord, your
My
lordship.
lord, your lordship can pass. No, my lord, give a direction, my lord.
I hope that, my lord, the High Court has got panel. Panel lordship.
Valuers, surveyors.
Yes.
Valuers are there.
The list has never been updated. When Justice Shunji Banerjee was there, it was found that the list contains names of people who died 20 years back.
That's why I'm saying the date of birth.
And thereafter it was revised. I remember, my lord, sometime in 2015, 16, it was
18.
revised. 18.
It is 18 revised. No, as again, I have requested again, it has to be
My lord,
revised.
could be.
Because
Especially after COVID.
Right.
Because this court is facing problem on this.
My lord, your lordship kindly pass the order, keeping the name blank. My lord, your lordship after my lord, going through the list properly. My lord, then.
No, I'm giving the name here in now.
Yes.
The official liquidator has filed affidavit of service showing that in compliance of the order passed by this court dated 19 September 2024, the office of the official liquidator, wide letter dated 11th November 2024, requested the chief valuer and the surveyor from a Kolkata Municipal Corporation for making necessary arrangement for demarcation of the land as per direction passed by this court dated 19 September 2020. And counsel for the official liquidator submits that in spite of the receipt of the communication and the order passed by this court, the chief valuer and the surveyor of the Kolkata Municipal Corporation has not assigned the work to any of the surveyor for demarcation of the land in question. Counsel for the respective parties raised before this court to appoint the approved valuer or surveyor of this court so that the order dated
19 September
2024 can be complied with. In view of the submission made by the counsel for the respective parties, Mr. Purunojoy Corner is appointed as a special officer for the purpose of demarcation of 14B, Amriti Lal Bose Street, Kolkata 700005 from 14 capital A Amriti Lal Bose Street, Kolkata 700005 upon construction of a boundary wall in terms of the order dated 19 September 2024. The official liquidator is directed to communicate this order for compliance to the special officer appointed by this court for the purpose of communicate this order for compliance for demarcation of the property in question in terms of the order dated 19 September 2024 to the special officer. Let the official liquidator shall file report by 6th of August 2025.
The next matter, my lord, CA 27. Kindly give us 2 weeks extension of time to file the reply affidavit.
Item number? C27.
Yes, my lords.
Yes, who is
I
appearing?
have used my affidavit, my lord.
So just
the
a reply
applicant-
affidavit.
You will file
Kindly give
reply.
us- Yeah, kindly give us a
Counsel
week's
for
time
the
to file.
applicant. You are for the applicant.
My lord, I am.
Counsel for the applicant prays for extension of time to file affidavit in reply. Let affidavit in reply be filed within 2
2
weeks.
weeks, my lord.
2 weeks.
Grateful.
This is the matter on 6th of August. No, 6th, no, 7th, 6th of August.
Grateful.
Grateful, my lord.
But I am for the official liquidator. এই তো এখানে কিছু।
My application.
My lord, before my lord, Mr. Rulia starts, may I make one submission? I'm the sole contributory for the company. This company was owned by a husband and wife. Now the entire shares are in my name. My lord, I have come into some information about substantial properties of the company, which the field liquidator is not in the knowledge of, which will inure to the benefit of the company, because Mr. Drolia, they will not have to fight. Mr. Drolia's debts will be paid off in full. The other secured creditors will also be paid off in full. And of course, the benefit, the ultimate thing will come. My lord will just give me 10 days time to file an affidavit. I'll bring all those properties on record. These properties were left to me in a will by these people, but ultimately I found that though it was left, though the probate was obtained, these properties are not really their personal assets.
So whom you are appearing?
I appear for the only shareholder at present.
Shareholder of the PCRA company.
Exactly. Kormokar, who was, this was 2 shareholders, 2 directors, husband and wife. Family company, they died, that their property passed to their son died, and it's now come to me. So I'm the sole shareholder. There's no dispute on that. Anything which will be left will come to me. I've come to know of substantial assets which the official liquidator has no knowledge of, but which will all go to the benefit of the company.
You are not informed to the official liquidator.
I've just come to know. I mean, and that's why I'm saying, that's what I'm asking for. Give me 10 days time. I will bring all those properties before the court. Then everybody will be paid off. Mr. Drolia will be paid. The 2 of them are fighting as to who's going to get preference. No, there'll be no requirement. They'll all be paid in full.
But my lord, the amount which lying with the official liquidator, 84 lakhs would be paid by the Union of India, and with interest it is now 93 lakhs. That amount, my lord, without prejudice, can be given to the Union of India.
No, my lord, I am opposing that, my lord, because I have an application, my lord.
Okay.
Saurashtra is opposing it because
whatever the details and description of the property, let me file it within 10 days.
give me 10 days time, it will inure to your benefit. You'll get your full money with interest. He'll get his full
I
money
will
with interest.
decide your claim, because at that simultaneously his claim is also be taken into consideration.
Some addition will be made.
Yes.
In the assets of the company in liquidation.
Whatever.
My lord, the entire money was received because of the assets, because of the efforts of Saurashtra. So legally they might not have a claim, but
All the claim
equitably he
is
has
to
a
be
claim
taken
too.
into
They will all be
consideration.
paid off.
If he is telling that the other properties are there,
And
you
at the same
are
time-
aware of that. Let all property come on
Applicant,
record.
applicant number 3, my lord, also sold the movable assets. Movable assets that has not been recorded, my lord. The proceeds that should be directed, that give the details how much amount they realized by sale of these assets.
Mr. Drolia,
My lord, all these proper questions may not require
I
to be got.
didn't want to open the mouth by sitting here.
Yes.
What has happened that time? What has happened?
The same person is claiming against the bigger company.
Correct.
Now they should forgo them. Then if they have already realized the substantial amount from the assets of the company in liquidation, then further claims is they should not insist of.
Okay.
You talk about your claim. You're going to get your money. He's going to get his money. Let my affidavit come.
Let his property be come on record.
Substantial amount
my
comes, my lord,
property.
if
Though it
substantial
has been
amount
treated
comes,
as
my lord,
mine.
by this way, then that is not within the knowledge of the official liquidator.
Correct.
Because he's not done anything.
Let come.
Yes.
The official liquidator also inquire into that.
Yes.
That-
Yes.
Then
Let
I will
it be
ask for
let it be
for the
recorded.
directions.
Let it be recorded.
My lord gives me 10 days time, and my lord can keep it on 30th.
What's the good name, sir?
Rudradev Chaudhary.
Mr.
My lord,
Rudra.
one prayer is there, my lord. My lord, I will pray, my lord. Kindly make it parted. Your lordship had heard it several days, my lord. Make it parted, my lord. Kindly make it parted.
Already company
No, my
court,
lord.
only one
My lord,
company court is.
kindly make it parted, my lord. Whenever your lordship will sit, we'll take up this matter. My lord, kindly make it.
Why you putting the burden on
No,
the
no, my lord. My lord, your lordship have heard so many days, my lord.
Lordship?
Kindly make it parted.
Then advocate? appearing for the legal heirs or shareholders?
Yes.
Shareholders of PC Roy.
The legal heir, I'm saying that I'm claiming to be the sole shareholder.
Shareholder / legal heir of PC Roy and Company.
I can't be the legal heir of a company. Legal
That's
heir of the
shareholder.
sole shareholder.
Shareholders. Shareholder of the PC Roy Company. Submit that. That there are some other properties which is not in the knowledge of the official liquidator, and as such he may be granted 10 days time so that he will bring all the property on record by way of an affidavit. Let affidavit be filed
Give me 10 days.
within 10 days after serving the copy to all the parties.
I technically don't even know. I mean,
List the party. List the matter.
I know of only two, Saurashtra and Union.
Saurashtra and official liquidator.
I'm the
This-
Union of India
Yeah.
applicant.
Union of India, Saurashtra and your
all
official
three are
liquidator. Let the matter appear on 6th of August.
All
Mine
the
was given on the
subsequent
30th
matter,
also.
two subsequent applications are also linked with this.
Ma'am,
12, 13,
the
14.
same order can be
Let
passed.
all three matters be parted.
12, 13.
12,
Yes,
14.
13.
12, 13, 14.
12, 13, 14. This will be in 12.
All application by different claimants.
Let all the matter be appear on 6th.
As parted. Kindly, this is my humble prayer.
Now,
Matter being heard several
correct. Now, August, you don't worry. In the meantime, nothing will happen.
What will happen?
It is
If
not
there
held
change
before-
of the bench, it's
Milord
very
can
difficult to
part
convince.
because on the last
Very
day your
difficult
lordship
to
has
convince the bench
held
because
that my lord has
kindly
substantially hard.
Come on, Nagdev will see to that. Yes, next.
Article 15, I am from the official liquidator. Lordship, on the earlier occasion, there was a direction for dissolution, and my lord has been pleased to direct the official liquidator to file a report, your lordship. I'm just praying for weeks' time, your lordship, to file the report, your lordship.
As per prayer made by the counsel for the official liquidator, case is adjourned. Let the matter appear on 23rd, 1 week.
23rd, 1 week. Lordship. It didn't slip to me.
Release the matter on 23rd. Yes, next.
Lordship, item number 16, may be permitted to file the report, your lordship, regarding the auditor's report, your lordship. My lord has been pleased to direct to file the auditor's report.
It is for 3 weeks time to file the certificate from the auditor.
Auditor, lordship, that is there. I have annexed the auditor's report, your lordship. Now the only thing that is remaining, your lordship, that the company can be dissolved, your lordship. So to that effect, your lordship, the prayer E and D can be allowed, your lordship. Rest of the part has already been complied with.
Yes, what is the report says?
Lordship, the report, we have only annexed the auditor's report,
Correct.
and that auditor has only assessed the fund position and some of the accounts that have been assessed. So they have all, the auditor has only given the amount which is lying with the official liquidator.
Where is the certificate? No certificate. No certificate is issued.
Lordship, certificate has been issued. Lordship, the original auditor certificate is page at 23, your lordship, if my lord pleases.
23.
Page 23.
Okay.
The certificate is accompanied by several accounts, your lordship.
Correct.
And the fund position is 3,76,000 and odd. Paragraph 6 of our report.
Yes.
So the company can be dissolved. Necessary direction can be passed.
After dissolved, then what about of the other prayer B?
Lordship, prayer B has been complied, your lordship.
Complied.
Prayer B has been advertisement and all these has already been complied earlier. Prayer B has been complied. So what is remaining is prayer E and prayer D. That is the mere formalities, your lordship, which is to just preserve the records.
Official liquidator has filed the report by disclosing the copy of the auditor's certificate dated 1st July 2025. It is, as per the auditor's report, it is found that the balance fund of rupees 3,76,059.71 is lying in the account of the company within bracket in liquidation as on 31st of March 2025. Police counsel for the official liquidator submits that has only an amount of rupees 3,76,059.71 is lying in the account of the company within bracket in liquidation, and as such, no purpose would be served to continue the liquidation proceeding and prayed for dissolution of the company. But the learned counsel for the official liquidator perused the auditor's report, auditor's certificate dated 1st July 2025. This court has accepted the certificate of the auditor. Accordingly, prayer A.
Prayer A.
Prayer A of
Prayer D.
D. Prayer D and E.
D and
Prayer A, comma, smaller, D and E of the summons for direction is allowed. CA1 of 2024 is disposed of.
Much obliged.
Next.
Lordship, regarding item number 17, your lordship may be permitted to file a report wherein my lord has been pleased to direct that auditor's report was already been filed, but to file the assessment, your lordship, by way of a report, your lordship, the payment that has been made, your lordship, to that effect, the report is being filed. It will into.
Yes.
So, your lordship, this application is also can be that for dissolution can be allowed, your lordship, regarding this matter also.
Amount is paid.
Amount is paid, your lordship.
There is a report.
Pursuant to the direction of 9th April 2025, your lordship, we have paid the amount.
Oh, so what is the total amount lying? Any amount is lying there?
Lordship, it's a meager amount that is lying, your lordship, nothing much.
5,78,000. 5,78,000.
Total
4
amount
rupees.
with the company. 5 lakhs, Lordship, 5 lakhs was earlier, but subsequently it has been deducted because auditors and chartered
177 is deducted. Then what is the now at present? Because as per the report, 5,96,424.
Lordship, so far as the direction of 12th February, in the order, it is indicating that the fund position is 4 lakhs. Thereafter, your lordship, subsequent deductions will be there because this chartered accountant has been paid.
No, then subsequently on 28th of March 2025, report is there. Closing date at 24th of December 2024, amounting to 596,424 was there. You are having the audit report.
Lordship, auditor's report is not.
Then if it is there, auditor certificate, Then if this court has passed an order for
One position to
for
take.
disbursement of 1,77,000 to the of this auditor as per the tax invoices. That
If
is
your lordship pleases, we can come up with the exact fund position.
yes, come with. That will be better. What is the as on date? The counsel for the official liquidator has filed the report. Let the same be kept to the record. Full stop. It is not clear as on date how much amount is lying in the account of the company in liquidation. Accordingly, the official liquidator is directed to submit a report to the effect that as on date, how much amount is lying in the account of the company in liquidation. Let the report be filed by
Actually, lordship,
30th July. List the matter on 30th July.
30th July. Great.
I appear on behalf of the applicant, my lord.
Yes.
My lord, only one thing, my lord. Your lordship has passed an order directing us to file an affidavit in reply to the opposition which has been taken out. My lord, that, my lord, we were humbly praying, my lord, a very short extension. Lordship had extended by the order of June 18. My lord, the contention which has been raised in opposition is that, my lord, the liquidator, according to them, is dead. So therefore, the application is not maintainable. My lord, we have found
Liquidator?
out, my lord, the liquidator whom I represent, my lord, he is dead. My lord, I am told, my lord, that he is very much alive. My lord, we have those documents, and my lord, the power of attorney is very much subsisting in favor of my client. My lord, only in so far as that is concerned, my lord, kindly list it any time next week. My lord, I will file and serve my learned friend on the next before the next date, my lord.
Yes. As per the prayer made by counsel for the state of Bihar.
My lord, no. My lord, the applicant, my lord, the power of attorney holder on behalf.
As per the prayer made by the counsel for the applicant, time to file affidavit in reply is extended for 1 week.
Great.
For a period of 1 week. Let affidavit in reply be filed within 1 week. List the matter on 30th August.
Deeply obliged to you, lord.
1 week. List the matter on 30th August. Okay. Yes.
Lord, I am appearing for the applicant. Lord, may I file my reply, my lord? Affidavit reply, my lord.
As far as my opposition is concerned, your lordship, I have filed the opposition, your lordship.
My lord, in this case, I'm sorry. My lord, in this case, my lord, I am praying for a declaration upon the official liquidator to execute, register and execute deed of conveyance in respect of a plot number 12 of a Dares Das Khaitan number, and also, my lord, to disburse me the settled amount of rupees 22,000. What has happened, my lord? In the year 1976, my lord, my husband purchased a plot of land. And my lord, thereafter, my lord, in the year 1978, this company gone into liquidation. And my lord, my husband died in 1987. And thereafter, my lord, by virtue of an order, my lord, of Calcutta High Court in the 1989, there are two plots, 13 and 12. 13 got registered in my favor. Now, my lord, 12, I have, although my lord, I have paid money in advance, sum of money that I have annexed that, my lord, but that has not been registered. So, my lord, thereafter, my lord, I repeatedly, my lord, wrote a letter to them. In the year 2019, my lord, I also wrote a letter to them asking him why you are not registering or kindly disburse me the amount. Then thereafter, my lord, on the last, if your lordship will, last, my lord, they are saying, my lord, you have to file an application with the High Court, praying for a if the High Court allows, my lord, then we'll execute, my lord. That is the thing, my lord. So what I'm humbly submitting, my lord, if your lordship.
Lordship, opposition we have already
Opposition.
filed.
Yes, what is your contention? What opposition you have filed? Where is the opposition?
Opposition to record है अच्छे.
Opposition नहीं है? File नहीं हुआ?
Lordship, in that effect, may be permitted to come on the next week. I'll file the opposition. Opposition is ready, your lordship.
You got the opposition?
I don't have the, my lord.
Until it has been
Yes, it has been
filed the
served.
reply. Lordship, let the matter be fixed next week. I'll come up with the opposition.
Learned counsel appearing for the official liquidator. Press for time to see whether the affidavit in opposition is filed or not, though it has been served to the learned counsel for the applicant, and the applicant has also filed affidavit in reply. In view of the above, the case adjourned for a week. Let the matter appear on 23rd.
Returnable on, my lord?
23rd.
23rd.
আপনার অ্যাপ্লিকেশন আমাদের কত আছে এটা আমরা চাইছি কপি ওটা
Time for amendment be extended till the returnable date. What amendment?
CA 17 appears to be an application by the liquidator my lord, for dissolution of the company. My lord, I appear for my lord, the contributories, my lord, the promoters of the company, and have already made an application which is CA 13 and it's fixed on 23rd of July. I have prayed for disclaimer of a particular property which is not belonging to the company in liquidation but by the promoters, my lord. Now, this property has not only been possessed by the liquidator, it has already been sold to someone else. So, my application is now fixed for hearing. Affidavits are complete. Now, meanwhile, this application for dissolution, but I have to have a copy of this application because this will clearly come in way of my application. So,
Your
both have to be
application-
heard together.
CA 17 is your application?
No, not mine. Mine is CA 13, which is fixed on 23rd of July. CA 17 is my little friend's application seeking dissolution, my lord. If I'm not wrong, my lord. I don't have a copy of this application.
CA 17, yes.
But that resolution application was filed earlier. Subsequent thereto, my lord, this application has been filed, possibly.
So, my lord, I was only submitting, my lord, if I may.
Very well,
given a
I shall,
copy of
I
this
shall have a
application.
copy of it. Very well.
So you are appearing for whom?
I am for the promoters, my lord, the contributories, my lord.
Learned counsel appearing for the promoters of the contributories of the company. Praise for
Supply of copy of my lord.
praise for supply of copy of CA number 17 of 2024 filed by the official liquidator. Full stop. The official liquidator is directed to serve the copy of CA 17 of 2024 along with all connected documents to the promoter of so by 1 week.
Yes, well, kindly keep this matter on 23rd July.
23rd, the other
Yes,
application is
other
coming
application is also pending on that day.
By Friday, that is on 18th of July 2025, release the matter on 23rd of July.
23rd July, Friday.
Service by Friday.
Come on, 20.
I'm deeply obliged.
I'm deeply blessed. Yes, my lord, I am for the official liquidator as per your lordship's order. Dated. Lord, I am submitting here with my report. But actually, my application was for declaration of dividend. If your lordships kindly see the declaration of dividend, that was the third dividend. Number in annexure A, page 8 of my report, on the dividend which I have already paid, that is given therein. The details.
Only one person has come.
Only two. After giving the notice,
In response to one
in response of the
has
two.
sent a document of his survivor and legal heirs of Mr. Yunis has also informed 2 persons.
Yes, only 2 persons. Annexure B is the paper publication.
Yes.
Annexures, the page 14 also in Bengali and in English.
Yes. So, what has happened to the claim of these 2 persons?
No,
two
they have
persons-
not yet submitted. Only the response they have made that yes, we do not know all the workers are leaving or not.
No,
Most
no,
of the cases.
The 2 persons who have given the
yes
response to the notice.
Yes.
What has happened to the?
But we shall call them to come at the office, at the office of the official liquidator and to submit the documents and to take the amount.
If the other persons will not come, then we'll see to that what will happen.
The difficulty is, my lord,
What will
most
happen to
of the cases, it was returned back, left.
Correct.
Because when a company is running, my lord, your lordship, ever in surrounding, my lord, the workers are staying there in,
Otherwise, they leave.
they leave the places. Your lordship, kindly keep this matter 3 weeks hence. I shall file another report. So far in this, the 2 workers is concerned who has already responded, and balance is, my lord, I shall submit the postal, my lord, the
Address.
yes,
A postal receipt.
track report of the service.
Learned counsel appearing for the official liquidator has filed the report. Let the same be kept with the record. As per the report, in response to the public advertisement published in the English and Bangla newspaper, only 2 ex-workers of the company have sent the response to the official liquidator. Accordingly, the counsel for the official liquidator submit that the official liquidator issue notice to the said 2 ex-workers with respect of their claim.
But one of them has already been died, but his legal heirs intimated, yes.
Legal heirs will come. Kya bola? Will file.
According to the answer for the official liquidator, submit the official issue notice to the said ex-worker with respect of their claim.
Claim and will file report before this court. And will file report before this court. In view of the above, the case is adjourned. Let the matter appear on 6th August for filing a report by the official liquidator. Next.
Lordship, I appear on behalf of the sole creditor in this matter.
Yes. What is your claim?
My lord, may I submit the report, my lord, as per your lordship's order, my lord? The property, only property has been sold for 2 crores 50 lakhs. Sorry, my lord, 3 crores 16 lakhs. Priya S. Junjunwala, page 5, my lord, paragraph 11. Then, my lord, there was a direction passed by your lordships. The out of the sale proceeds.
Present is 244.
Yes. But your lordship's direction was to pay the security charges. My lord,
31 lakh, 31
yes,
lakh 84.
31,
You paid.
31 lakhs 84,000. My lord, I have paid. I have submitted the, my lord, the accounts position. My lord, your lordship kindly turns to page 10. Item number 3. Paid by security charges 31 lakhs 84,400. So now the present fund position is, my lord, is the given there. Column 3, my lord, kindly see 31 lakhs.
Where?
Column page 10, my lord.
Uh-huh.
Column 3. First, my lord, by advance paid of staff, by paid of creditors claim, then, my lord, paid as security charge.
31.
Yes.
So total expenses 37.
Yes.
So
And
closing balance as on 2 crore 44.
right. This is the amount lying with the hands of the official liquidator.
Correct.
No, my lord, we are the only sole creditor in this matter. What happened in this matter? My lord, by a letter, we had submitted our claim before the OL in 1985. That was admitted till 45 lakhs on 23rd of May 2023. Thereafter, my lord, we had filed an application which is listed as serial number 23, IACA 37, wherein we had prayed for complete liquidation of the property and for settlement of a claim. Thereafter, my lord, on 12th of September 2024, with our submission, and on the basis of submission, this honorable court was pleased to direct us to file a revised claim before the official liquidator. We filed a revised claim on 29th of October 2024. A hearing was conducted on 18 December 2024. My lord, thereafter, neither the claim has been admitted nor it has been rejected. It is still pending on that front. If any, unless that is
Your
being done,
Lordship kindly turns to page 2 of the report, my lord. Who are the creditors, secured creditors in this company? My lord, that is given in the record. Page
Who are you?
my lord, we are just the
What is the name?
Azrak India Limited, my lord.
Huh?
Azrak India Limited.
As per the record of registered companies, West Bengal, 4 secured creditors: United Bank, Allahabad Bank, Punjab National,
My lord, we are not the secured creditor, but we are the creditors over here
So what?
secured by the stocks, actually, basically.
How what claim you have made? What document you submitted?
My lord,
The
they
officer-
cannot participate in this matter because they are not the creditors in respect of the property which has been sold.
No, that is
But
not
the
the
secured creditors, my lord, United Bank of India, now my lord, the Punjab National Bank,
Okay.
and Allahabad Bank also, my lord, merged with another bank, Bank of India. Now there are in fact 3 secured creditors: Punjab National Bank, American Express Bank, and my lord, the substitution of the Allahabad Bank. So first of all, as per 529, my lord, of the Companies Act, secured creditors payment is required to be paid. So you have to,
So
my lord,
what is their claim? Secured creditors?
my lord, we have to invite the claim.
Correct.
Because the amount has been realized. Now, my lord, we have to invite the claim to the secured creditors, and we shall come with an application seeking, my lord, direction to, my lord, yes, to invite the claim of the
Correct.
secured creditors.
And in the meantime, also, I'll seek some instruction from the client if any further document can be filed before this court to
Yes,
support our claim.
How you can? How the
I'll seek
credit-
necessary instruction from client, my lord.
You can, because secured creditors are there.
Yes, I know.
If the secured creditors are how your claim can be entertained?
My lord, till now we had the instruction that secure creditors had already been paid off. We are the sole. It is.
They will invite the claim. If they will say no, then we have nothing to do. Then the creditor will come in.
Obviously, my lord.
My lord, kindly grant me 2 weeks' time. I shall come with an application.
And counsel appearing for the official liquidator has filed the report. Let the same be kept with the record. List. Counsel for the
My lord, 4 weeks' time may be given.
liquidator prays for 4 weeks' time for taking appropriate steps. According case adjourned, let the matter appear on 20th August. 20 August. 20. Next.
And like 22, 23 are same.
23 are same.
22.
20 to 23. Same.
Same.
Yes.
My lord, in this matter, I am told, my lord, your lordship was pleased to direct the official liquidator to submit a report. My lord,
No. Counsel produced. Director submit the report within 4 weeks.
my lord, kindly grant me 1 week's time more, my lord. I shall.
Last time also you have taken time. As per prayer made by the counsel for the official liquidator. As per prayer made by the counsel for the official liquidator. Time to file report is extended for a period of
1 week, my lord.
1 week. List the matter on 30th August. 30th July.
30th July. 25. 25. रिपोर्ट दिए
Yes.
रिपोर्ट नहीं तो
Give the report. Where is the report?
But in this case, an appeal is also pending. But the order, my lord, which was passed by this court, that is handing over, my lord, the possession. My lord, we have handed over the possession, my lord, that is the minutes. But I hope that it should be, my lord, given to a report, by way of report.
What has happened to the appeal
No,
court?
my lord, My lord, I am told that in this matter, the liquidation order has not been passed. BIFR number 95 of 1991.
No, the appeal is pending.
Yes, an
What has
appeal is.
happened to the appeal?
Or the appeal is still in the list today also.
So, how this court can proceed? What is the appeal against?
Appeal against, my lord, the past, my lord, that against the order, my lord, passed by this court. But there are. Yes, my lord, if your lordships kindly see CP
Immovable
number
property
3.
of the company are concerned have become infractious and redundant. Alternative case of monetary claim pleaded when certificate shall be considered according to liberty granted to the applicant lodge a monetary claim. Against this order you have challenged.
Yes.
Of the 12th June.
Yes, my lord.
12th June order.
Yes, my lord. 12th June order, my lord, that is the, my lord, the minutes of the meeting. We have handed over the property. And my lord, the CP number 336, in which, my lord, winding of order was passed. So, lordships, my lord, the 12th June order, your lordships kindly see, CP number is mentioned in 336. So once the, my lord, the company is in liquidation, second order cannot be passed.
CP number 336.
But the today's matter is, my lord, the BIFR number, my lord, 30.
BIFR 95.
Yes. So that is, that winding up order cannot be passed in this matter because once winding up order already passed in another.
Of the second order.
Yes.
So both the matter is to be tagged together.
But
let this matter go out of the list for the present. Let the till the disposal of the appeal.
My lord.
Once the appeal is disposed of, then matter
The
can
liberty may be given, my lord, to mention this matter in case of.
Learned Counsel for the official liquidator submits that an appeal is pending before the appellate court against the order dated 12th June 2023, passed in CA 12 of 2023 in CP 336 of 1982.
So this is the notification of the winding of order. Your lordships kindly see 336.
Correct.
In the.
Learned Counsel for the official liquidator submit that by an order dated, what is the order? Order dated 20th June 1984, this court has passed an order for winding of the company. And as such, again, the application being BIFR / 1995 and 95 / 1995 and 1991 cannot be taken up for winding up again. This BIFR, where is the BIFR application? This one. What is the prayer?
That may be the recommendation of the BIFR for winding up. But prior to that, my lord, the
already winding up.
Yes.
Court has passed an order for winding of the company as such.
Winding up. Winding up.
The company and as such, again the application being BIFR /95/1/1991 cannot be taken up for winding up again.
Further again. Full stop. This court find that the matter is pending before the appellate court.
Well, your lordships kindly dispose of this matter. My lord, the BIFR number 25. Otherwise, my lord, this matter again will appear, my lord. Maybe pass further winding up order in.
No, but what I think, let the appellate court order be come here. What will happen? We don't know.
Yes.
That if that order is again upset, then it will be difficult. Let the matter full stop.
This will find that the matter is pending before the
appellate court. In view of the above, for the present, let this matter go out of the list for the present till the disposal of the appeal pending before the appellate court being APO number 164 of 2023 with CP number 336 of 1982. Liberty to mention. Yes.
Lordship, in this matter, I am appearing on behalf of the respondent, Lordship. Lordship, pursuant to the order dated 19th March 2025, we have disbursed all the creditors, almost all the creditors, except some employees, Lordships. So in this regard, I am praying 4 weeks' time to file my further report, Lordship.
My lord,
Pursuant to the directions on 19th March, Lordship.
my lord, I appear on behalf of Steel Authority of India in this matter.
Yes.
My lord, essentially, the Steel Authority of India is the shareholder in the company in liquidation. But a
Yes.
substantial amount, even after the last application, what has been filed by the official liquidator, even all the creditors are paid, substantial amount will remain, my lord,
Yes.
in the tilt of the official liquidator. My lord, I have got a twofold submission in this matter, my lord. Let the official liquidator produce the complete accounts with regard to the liquidation, my lord. Because why I'm submitting? Because I am a shareholder. The money will come to me, my lord. Whatever money will be left. And second is, my lord, since it is a very old case, my lord, I was humbly requesting if your lordship can kindly call for the entire court records with regard to the BIFR case, my lord, which was pursuant to which the liquidation order was passed.
Let us submit the report disclosing all these things.
Lordship, in
Disclosing
this
all these
regard-
things. If the report
Yes,
does not
yes.
disclose, then I will pass appropriate tax.
Yes, Lordship.
But I only one more thing, my lord. Let
Time
your
to
lordship.
file my report, Lordship. In that
Let the
report,
file report, it will be given to you. If you're not satisfied, the court will not satisfy that all the document is not there, then naturally the report will further call for.
No, I'm not for the not of the
we have
liquidator's
not paid
record.
all
I
the
am not seeking
creditors
for
to
the
the
liquidator's
100%.
records, my lord. I am, my lord. I want to, my lord, all the court records, my lord. The BIFR.
Let the report be filed. Let
As
the
your lordship pleases.
liquidator pass
Lordship, we
file
have
the
not-
report. They might be disclosing all these things. They will not disclose, then we'll see to that.
Yes, Lordship. Yes. And I am praying for 4
But
weeks.
perhaps I have not been able to explain, my lord. I was not seeking for that. Perhaps I have not been correct to explain, your lordship. I was seeking for the petition which was filed before this court, my lord.
All
With
the-
for that record to be brought to the court.
What is the number?
My lord, the main CP, the BIFR case number.
BIFR
BIFR
503 of
503.
1994, Lordship.
The BIFR 503, all the records are not here. नहीं है.
Take them, go to the department and search.
My lord, perhaps it will be very difficult because it is a very that's the only reason I'm seeking for your lordship, sir. To as a record.
94. Record. क्या बोला? Counsel for the official liquidator prays for 4 weeks time to file supplementary report. Full stop. Counsel for the Steel Authority of India prays for a direction for bringing all the connected record of BIFR 503 of 1994 for proper adjudication of the present application. In view of the submission made by the counsel for the parties, the official liquidator is granted 4 weeks time to file supplementary report. Full stop. The office is directed to place all the record of BIFR 503 of 1994 before this court on the next date fix. Release the matter on 20 August 2025.
Lordship, only one submission, Lordship. If your Lordships kindly come the last order, Lordship, 19th March 2025, direction was given that, may I read the order, Lordship?
Yes, tell me.
That CS 29 of 2024 is filed by the official liquidator praying for payment of liabilities to the various creditors and claimants. The admitted claims and the remaining amount to be paid to different creditors are given in the details of the application. 36 employees are mentioned who are not named and particulars are not given. The official liquidator shall ascertain the whereabouts of these employees, whether they are surviving or not, and whether any claim is there in case of death by their legal heirs and representative. Till this exercise is done, their claim amount shall be set apart from the fund. The supplementary report is filed today containing a signed statement of accounts of the official liquidator, where from it appears that as on 30th November 2024, the quantum of fund available is rupees 14 crores 12 lakh something. Total amount to be paid according to the application, that is my applications which I have filed before your lordship, that is 9 crores 85 lakh 68,000. Claim of 36 employees stand at rupees 18 lakh 75,000. This amount should be set apart from the fund.
Correct.
In this figure, there was a direction for filing a supplementary.
Correct.
The fund position permits payment to the other
Correct.
creditors. The
Further
official-
report shall be submitted by the official record regarding
Yes, for
disbursement.
that purpose, I am praying for 4
Correct,
weeks
that's the
time
important.
to file the report.
That's why
Lordship.
final
Yes,
report, how
yes.
many amount has been disbursed,
Yes,
how-
yes.
whether it the workers have been identified or not,
Yes, yes,
and what
yes.
amount is lying with
Yes,
you.
yes, Lordship. Only for that purpose. Yes. I'm good.
My lord, may it be also your lordship's pleasure to that the official liquidator indicate all the expenses that they have made in the report that they're going to file.
Already we have mentioned
That is
it.
My lord,
already.
let that be there. That be there.
Yes, call them.
Deeply obliged. But one more thing, my lord, one more thing. Last day order, my last day, my name has not been recorded in the order. If that can be. Okay. I'll not embarrass your lordship if it can be done.
Oh. वाला फाइल क्या है? इससे पहले वाला फाइल? No, I cannot do because I was not there.
As your lordship pleases. Well, I'll not. As your lordship.
Yes, next.
Deeply obliged.
I appear for the official liquidator
Yes.
pursuant to the directions of your lordship on the last occasion, 18th June, your lordship. We are filing this report, your lordship. The order is at page 5 of that report.
My lords, I am appearing for the Assam Tea Employees Provident Fund, the proxy counsel.
Your lordship, the application was allowed, your lordship. Now, your lordship, the Provident Fund authorities have till date not given us their bank accounts or details.
Yes.
They have to. They have not.
Directed to submit the
Even the workers have not till date. Only we have received from Form 138 from 2 unsecured creditors. This is Bansal Tea Company and Rajiv Jain. Others we have not received. So when we receive it, the sums would be dispersed.
Who is
So
appearing?
this is
You
a
are appearing?
I appear for the SM Tea Employees Provident Fund Organization. I'm led by Miss.
My lords, my colleague is there. The main counsel is Miss Priyanka Das. I'm the proxy counsel and my colleague is there physically.
Yes, what has happened? Where is?
Your Lordship, so far as disbursement of the 2 crores amount is concerned, Your Lordship, by a letter dated 30th April 2025, we've already informed the official liquidators as to why we can't accept that amount. But besides that, Your Lordship, my instruction is that the letter is there.
My lords, if I may please submit, our claim was of rupees 5 crore 69 lakhs 21,000 something, and what the amount which has been dispersed, which has been approved to be dispersed to us, is almost 2 crore 64 lakhs 77,000, which is way less than the claim amount which we have submitted to them. And in March, as my colleague has submitted, we have sent the letter to the official liquidator rejecting the claim. So our instruction is that we will file an application for the same. We are not accepting their claim. Which
Even on the last occasion, not before this court, when the company court was taken, they had bid. Nothing has been done. And your lordship knows, your lordship, what happens once your lordship a claim is filed, your lordship. The official liquidator either admits or reject, or partly admit or partly reject. Now, your lordship, once they are informed, your lordship, within 14 days they have to prefer an appeal against that.
They have not done.
21 days. They have not done anything. And now when we apply for the disbursement and we write to them that this amount has to be given to you, so you please file that form, give us all the details so that we can disburse that amount. Then they come, they start writing the letters.
Since 2023.
So I do not know. There's no application, nothing, no appeal preferred against that.
My lords, if I may just submit, we have been instructed as of today only, and the resolution plan has been provided to us recently only, and we have forwarded that to ATPF.
What is the resolution plan on the last?
It's not an IBC matter.
Yes, it is not a resolution plan. What the amount they are having it? They have requested you to notify. You are not notified.
In fact, if your lordship
My
sees
lords, but we had
if your lordship sees 19th March 2025, they appeared, your lordship.
Correct.
And then also, your lordship, they said that proper formalities for disbursement should be complied by both the parties. Necessary formalities should be complete and disbursement shall be made on or before the returnable
Returnable
date.
date.
Now, your lordship, they don't provide us the details. Kindly see the order of 19th March. They were represented at that point of time.
Yes.
My lords, after that date only, we had rejected the claim. We had sent the letter to the official liquidator.
So if you rejected the claim, you could have been filed an appeal. You're not preferred an appeal. So what?
My lords, we did not have the instructions at that time. Please, I am asking, my lords, my senior is not here at the moment. I'm asking just till next date, a short accommodation. I'll seek instructions from the organization and I'll come back to you. A short date, my lords.
Filed in, were made in 2023. Thereafter, they filed the claim. We rejected.
Your office has not taken appropriate steps. So what the court will do here?
My lords, we have just been engaged. On 19th, we had made representation. Before that, there was no representation made on behalf of ATPFO. That is why the delay. Just grant me some a shortest accommodation. I will come back with the instructions.
When your senior will be available.
I'll indicate, your lordship, they had filed a claim of 5 crores 69 lakhs and odd.
Yes.
We admitted as preferential 2 crores 64 lakhs and odd, and as ordinary claim 3 crore and odd. Now,
But
as
my
far
lords,
as the preferential claim is concerned, we said that we want to make payment to them.
Correct. You now they are telling that 2 crore 64 they will not accept. They are having the claim of 5 crore 69 lakhs.
But my lords, only this much has been disbursed. My lords,
They are
I am
telling-
just requesting.
Their claim is 5 crore 69 lakhs
Yes, my lords.
with interest at the rate of 15% per annum.
Yes. So this
Yes, my
now,
lord.
your lordship, if they were aggrieved
That's why.
by this, then they should have come by way of an appeal. They did not.
Okay, let our senior come.
My lords, just a short accommodation.
As per the prayer made by the Learned Counsel appearing for the ATEPFO. As per the prayer made by the Learned Counsel appearing for ATEPFO. Case is adjourned. Let the matter appear on 23rd.
I'm grateful.
23rd July, my lords.
23rd July.
I'm grateful, my lords. Thank you.
Just take this.
Lord, I am for the official liquidator. I am submitting the report, my lord. My lord, this report has been filed in pursuance of the order 12th December 2024. My lord,
Yes.
what was happened for the purpose of, my lord, the dissolution, my lord, that there was the direction for appointment of the, my lord, auditor. The auditor was appointed and then auditor also submitted his report. And he has raised a bill of amounting to rupees, my lord, paragraph 7, page 2, 1,59,892. Yes, my lord, the court says that that amount should be including the, my lord, the fees of the legal charges. So, my lord, the paragraph 7, it has been mentioned that 20,000 rupees for the, my lord, therefore 20,000 is paid to the concerned advocate towards legal expenses, and a sum of rupees 1,33,400 will remain to pay to the, my lord, the chartered accountant, auditor.
1,33,000.
Yes, my lord, that
Will
is,
remain the-
yes,
that-
only that amount is, my lord, your lordship, grant me leave to pay this amount, 1,33,000.
20,000 is the legal expense.
Yes, legal expenses. My lord, the bill of the, my lord, the chartered accountant is enclosed, my lord. In the last page number 7, my lord, tax invoice.
1,53,400 plus tax.
Yes.
23,400. So total it is 1 crore 1,49,892.
Yes.
So you have deducted the legal expenses.
20,000 legal expenses out of the, my lord, the proceeds lying with the official liquidator, and balance amount, my lord, intends to pay the, my lord, auditors. That is the only prayer, my lord, I am seeking.
Advocate appearing for the official liquidator has filed the report. Let the same be kept with the record. It is found that the auditor has raised tax invoice of rupees 1,53,400
plus tax of rupees 23,400 in total 1,59,892. Counsel for the official liquidator submit that in terms of the order passed by this court dated 17th March 2025, the official liquidator has deducted an amount of rupees 20,000 as legal expenses, and the remaining amount of and the official liquidator is ready to pay an amount of 1,33,400 to the as the auditor's fee. In view of the above, the official liquidator is granted liberty to disburse the amount of 1,33,400 being the auditor's fee within a week.
Within a week.
Within a week from date, and to file the report by 6th of August 22.
I'm deeply impressed.
List the matter on 6th August. Next.
But kindly make it 2 weeks, my lord.
That's why 6th
Oh,
August. 6th August, hai na?
Item number 29 may be permitted to file the report, Your Lordship. In this matter, Your Lordship, there was a direction for making payment upon some
Madam.
of the, because this application is the
एक
instance.
week बोला ना 2 weeks कर लो. 1 week बोला ना payment का 2 week का. Yes.
Lordship, this application is at the instance of some of the contributories who are seeking some of the dividends, and also to provide some. There was some claim for the creditors also. Lordship, to that effect, we have disbursed the amount, Your Lordship. We have filed the report accordingly. The applicant is not appearing today, Your Lordship, so the matter can be disposed of. This
Who is
particular
for the applicant?
applicant is not appearing.
Rudradev Chaudhary. Have you served the copy report to them?
Lordship, copy has been served.
Report copy?
Copy has been served, and since it has been complied, perhaps for that reason they are not appearing today. Lordship, we are praying for dissolution, though no application has been taken out to that effect, Your Lordship. In this report, we have filed. Lordship, we have filed an appropriate
File appropriate application. I am keeping this on record. File application for dissolution. I will pass and note.
Lordship, this application can be disposed of, and we will come up with a separate
What
application.
is the application here?
This application is that the instance of the contributories seeking for disbursement of the dividends.
The applicants, being the 100% contributors, have filed the present application being CS 17 of 2024 with the praying for a direction upon the official liquidator to issue dividend of the surplus amount in terms of the affidavit of claim filed by the contributors being 100% contributors of the said company in liquidation along with the interest accrued therein. Full stop. By an order dated 16th April 2025, this court directed the official liquidator to comply with the this court by an order dated 18th April 2012 passed an order. Pass the following order. Pass the following order. Okay. Full stop. By an order dated 16th April 2025, this court directed the official liquidator to comply with the order passed by this court dated 18th April 2012 by issuing dividend of the surplus amount to the contributors in terms of the affidavit of claim filed by the contributors being 100% contributors of the said company in liquidation. Full stop. In compliance of the order dated 18th April 2012 and the order dated 16th April 2025, the official liquidator has filed the report wherein it reveals that after considering the affidavits filed by the contributors along with the copies of the share certificates in form 141 dated 30th April 2025, declaring a sum of rupees 1 crore as surplus to the individuals, namely Mr. Arun Kumar Agrawal and Mr. Ashok Kumar Agrawal respectively, paying each of them a sum of rupees 50 lakhs upon production of the original share certificate. Full stop. The report further reveals that the official liquidator has disbursed the amount of 50 lakhs each to Mr. Arun Kumar Agrawal and Mr. Ashok Kumar Agrawal on 7th May 2025 through NEFT. Considering the above, this court finds that the official liquidator has already disbursed the amount to the contributors, and as such, no further order can be passed in the present application. Accordingly, CS 17 of 2024 is disposed of. The report filed by the official liquidator be kept with the record.
My lord, I appear for the applicant in CA 18. My lord, I'm led by Mr. Dasgupta. May I kindly press the application and my lord may grant me leave if he comes.
CA
My lord,
18.
is CA 18, my lord.
CA 18 is listed today.
It is, my lord. If my lord may kindly take the order dated 26 February.
List में है नहीं, say it is not there.
Lord, it had been directed. My lord may kindly direct it to be listed, my lord, on the next occasion. Then, if I may give a background, my lord, this
17 of 2024 is there
for disbursal, and my lord, 18 is my application, my lord, to my lord, submit my claim and prove my debt, my lord, before the official liquidator.
Okay, I'm passing an order.
In terms of 177.
An advocate appearing for the applicant in CA 18 of 2024 in CP 577.
My lord.
2004 submits that by an order dated 26th of February 2025, this court directed to place the record of CA 18 of 2025, but it is not been placed before this court. In view of the above, the office is directed to place the record of CA 18 of 2025 along with CA 17 of 2024 in CP 577 of 20 by on 30th July 2020.
Grateful, my lord.
Lordship, in this matter, I am for the official liquidator. This application is for dissolution of the company, Lordship. I am praying for 2 weeks' time for filing a auditor's report, Lordship. Publication has been made, auditors has been appointed, Lordship. Only
Last time also you have taken time, madam, 16 April,
uh,
2 weeks time.
Lordship, this is the last chance, Lordship.
As per submission made by the counsel for the official liquidator, time to file auditor's report is extended. As per the submission made by the counsel for the official liquidator, time to file auditor's report is extended for a period of 2 weeks.
Yes.
This is the matter on 30th August, 30th July. For filing report, auditor's report.
Lordship, in 32, I am appearing for the official liquidator.
Yes, madam.
This is my report, Lordship. CA 14 of 24 was asking for leave to conduct a fresh e-auction sale, and by order dated 5th February, we were given a second chance to conduct the sale, but unfortunately, we have not received any bidder. So, Lordship, I was kindly requesting that if a fresh valuation could be conducted, if Lordship may grant the leave.
Already valuation is there.
Lordship, the valuation is of 2018. Lordship may find my submission
Again, it
in
will be
page 4.
increased. If it is increase, how the in the low cost nobody is coming. If it will increase, how the person will come?
Lordship, in any event, no bid has been received for last 8 to 10 months. We have tried to conduct the sale for twice at least.
What do you want?
Leave to conduct a fresh valuation.
Fresh valuation?
On 2018 and 19 valuation report, we have attempted 3 times with no effect.
Learned counsel appearing for the official liquidator submits that as per the valuation report dated. Where is the valuation report?
Valuation report. Lordship, the previous valuation report is not attached with this report.
When it was, where is the report?
It was conducted in 2018 and 19.
Submit that.
The properties are in 3 states.
The last valuation of the property in question was conducted in 2018 and 2019. And as per the said valuation report, twice.
On the last valuation report, 3 times.
No, how much? 3 times. How many advertisement was made?
Thrice.
Thrice an advertisement made for auction of the property. For
Yes,
auction
Lordship.
of the property.
There are 3 properties in
For
3
auction of the
states.
property.
Yes, Lord.
For auction of the properties, but none of the person has come forward. Accordingly, counsel for the official liquidator press for a direction upon the press for leave to obtain fresh valuation report of the properties in question for taking appropriate steps. In view of the above, in view of the submission made by the counsel for the
Lordship, at least 8 weeks time we will need because it's in 3 different states.
liquidator is granted leave to obtain fresh valuation report of the properties in question within a period of 3 weeks from date and to file the report on 20th August 2020.
Grateful.
Item number 33 is my application.
Yes.
Lordship, in this application, it's a very small prayer. I'm just praying to draw and complete the certified copy of the order. The order was passed on 19th April 2023, Your Lordship. The difficulty is that at that point of time, we couldn't decide that the appeal is required to be preferred. That is the reason the certified copy, the entire procedure is that at the time of passing of the order within 7 days, Your Lordship, we have to apply for the draw and complete. So until unless that is done, Your Lordship, we cannot prefer an appeal. That is the only predicament, Your Lordship. Is a very small prayer, Your Lordship. Until and unless we prefer an appeal arising of the order.
What is the order dated?
Order is 19th April 2023. Lordship, in this matter, there's a checkered history because a fraud has been committed and the entire sum of the proceeding is pending before the criminal court also.
19th
Whatever may be the situation, Your Lordship, the appeal is
You're
required.
not mentioning a prayer portion.
Lordship, prayer A and prayer B. Summons for direction.
Summons for direction. Condone the delay. Prayer A grant to leave to draw complete a certified copy of impugn or which what or which of
Order date is not mentioned. I pardon Your Lordship for that. It's 19th April 2023, Your Lordship.
the official liquidator has filed the present application being CA 25.
CA 25.
CA 25 2025 praying for leave to draw and complete the certified copy of the impugn order dated 19th April 2023. Counsel for the official liquidator submit that due to inadvertence, the office of the official liquidator could not apply for the certified copy of the impugn order against which an appeal is required to be filed. And as such, the official liquidator has filed the present appeal. At the learned counsel for the official liquidator produce the application. Leave is granted to the official liquidator to draw and complete the certified copy of the impugn order dated 19th April 2023 within a period of 2 weeks from date.
Much over.
CA disposed of. CA 25 disposed.
Right.
Next.
Milord, I am Milord appearing on behalf of the heirs of the original winding up applicants. Now, Milord, in the passage of time, the original applicant passed away. So we brought this to the notice of the Honorable Court. And firstly, by an order of October 3, 2024, Milord Justice Shobhoshachi Bhattacharya gave us a liberty to come up with an application. Subsequently, Milord, on 30th January 2025, Justice Mojumdar, Milord, gave us a further liberty, Milord, to file an application. But the difficulty which we are facing, Milord, is that the original winding up application, and it's an old matter of 2009, that is, Milord, not traceable. So we, Milord, requested the learned official liquidator to hand up a copy. We have not been given till now. Most recently,
they are having a good reason now.
The same reason may be reiterated.
No, they are not the official liquidator is having good reason. Due to shift of the office, all records have been missed.
Maybe. So, Milord, your Lordship may direct the department to find out a copy and give us a photocopy at our cost and expense.
Apply for the certified copy.
Milord, it's not there. If it is not there, then we have spoken.
In the court, there is not there.
We have spoken, Milord. My learned advocate on record, Milord, has spoken. But if it has been found out by now, then it is our good luck. Here and now, your Lordship may give this direction.
Where? To whom you are having? As the officer, as the persons.
Or, Milord, I can propose one, Milord, suggestion, Milord. I have, Milord, one cost title. If your Lordship, I may hand up, Milord. This is, Milord.
I have to take instruction on this
A very
regard.
small technical thing. I have, Milord, a cost title of a connected company application. Now, Milord, it is only correction in the cost title. So, if this same cost title can be used, Milord, by us, we can suggest and propose our amendment in this cost title, and your Lordship can take this on record. It's only the CA number will not be there. It will be in the CP number. If your Lordship.
CP number already there.
CP number already.
You want to come as a CA.
I want the amendment in the
CP is to
CP
be amended.
because the name of
With
my
applicant credit.
Kamlesh Singh. Kalyan Kumar Miller, that is the original winding
Krishna
up.
Kumar Kalyan.
Krishna Kumar Kalyan. And even my name is appearing in the creditors list also, item 145. So I am a recognized creditor. And I was the original winding up applicant. Now my name of my son and my wife needs to be included.
Yes, madam, you are not having the copy.
Lordship, I need to take instruction in this regard. I shall intimate the council,
Then again, we
Mr.
have to
Council.
come back. If your lordship grants us leave, then we have the cost title. Then based on that cost title, we can propose the amendments.
नहीं मिल रहा है कंपनी पिटिशन नहीं है. Yes.
So, my lord, if your lordship can grant us leave to propose the amendment based on the cost title which we have, which we actually have. We only have the cost title, and then we can file our substitution application proposing our amendments only to the cost title.
You file the substitution application. The substitution application is to be substitution is to be carried out by the department. If the department is
They will have to carry out in the original paper.
Original paper.
By that time, if they find out, which they have told us that it's not there, and there is, I'm only dependent on my learned friend Willard for reconstitution. I really don't have.
Check it.
Lordship, kindly give us some time. We'll take instruction and come back.
Come next week.
Yes.
Lordship. Lordship, this is my CA 44, my application. All the prayers in CA 44 are complied with, and this is my report I'm filing today before Lordship. The application may be disposed of, my lord.
I will dispose next date.
As your lordship pleases.
Official liquidator and counsel for the official liquidator has filed a report. Let the same be kept with the report.
The report has no connection with his prayers, lordship.
Full stop. The counsel for the
আমাকে একটু instruction নিতে হবে whether they can
submit
provide
that.
at all.
Yes.
Because of the distance also.
This court has granted leave to file an application for recording the death of the petitioner and substitution of the legal heirs of the petitioner. But the petitioner is facing difficulties for taking out an application for substitution as the original company petition number 289 of 2009 is not traceable. Full stop. The office is also informed this court that the office is in search of is in process of searching the original company petition number 289 of 2009. In view of the above, the full stop. The counsel for the official liquidator submitted before this court that she will ascertain whether the copy of this company petition number 289 of 2009 is available in the office of the official liquidator or not. If it is available, she will provide the copy of the same to the learned counsel for the petitioner. Let the matter appear on 23rd August.
Lordship,
23rd
July, sorry.
Lordship, one more thing. In item 32, Lordship has granted us 3 weeks time to conduct the fresh valuation. Lordship, because the properties are 3 different states, so it will take some more time for us to
See,
complete.
if not, I will extend the time. No problem.
Lordship, at least we are praying for if Lordship would kindly
Which
grant us
matter?
32, 8 weeks time at least.
32, 8 weeks.
Much grateful.
I'm deeply obliged.
8 weeks का बाद ना डेट आएगा उसमें 20 अगस्त 17 सितंबर को.
17.
I'm deeply obliged. And we have been missing your lordship for the last 15 days.
We all are.
In this case, I am appearing for the secured creditor in pursuance of your lordship's direction. My lord, the payment was made by the official liquidator. to the, my lord, the secure, one of the secured creditor, Union Bank of India.
Which we have made payment to the Union Bank as well as to the Provident Fund authorities. Provident Fund authorities are appearing, Your Lordship. So this application is disposed of. So we can now proceed for the dissolution of the company.
So CA 18 is over. What is the CA 18?
What is the dissolution application?
It is to take on record 71 being the settled list. Make payment of what amount you have paid? 6,44,000
Lordship.
to the Provident Fund organization, Salt Lake, and remaining 11 lakh 20 UBI. You paid?
Yes, ma'am.
Where is the report?
Lordship, report has not yet been filed. Next day we can file the report.
Or perhaps this is their application for dissolution.
Let the report come.
Yes.
Then the
Yes.
resolution will see. Counsel for the official liquidator prays for time to file the report. Let the report be filed within 2 weeks. List the matter on 30th July.
This matter, my lord, I am petitioning.
My lord, I am speaking, my lord, 1 week's time. I am extremely sorry, my lord. The your lordship's order has not yet been complied with. No report has been prepared, my lord. I am extremely sorry. Here, my lord, there was a direction for sale of the property which was not belongs to the company in liquidation.
No, on the last occasion, official liquidator filed report.
Yes, that report was filed. Yes, my lord, that report was filed.
After serving copy to the London Counsel for the applicant, let the same be cut with the record. List the matter on 16 July.
Yes.
So what report you required? Further?
When going to buy the report, that is 5 report. It is a fraud has been committed by the official liquidator and the ex-director. Ex-director.
Ex-director of the official liquidator
Ex-director
of the company.
And the official liquidator.
And?
The official liquidator.
Official liquidator.
Oh. The lordship can take up the first winding a petition, contractor. Or as the CCA.
So have you taken the exception to the report?
Yes, my lord.
Where is the exception?
I am taking the direction for some month.
Where is that? They have filed the report. You are accepting this report. On the last occasion, the report was served to you. If you are making any allegation with regard to the fraud, then you have to take the exception to the report, sir.
I filed the exception, my lord. Because exception is separate thing, but fraud is separate thing in this matter. Fraud is separate thing.
The fraud, how the fraud is committed?
If
If it is a fraud, then what the report is, it is also fraud. So come with all the documents. How you have to, the counsel for the applicant prays for petitioning creditor prays for time to take exception to the report filed by the official liquidator dated 9th April 2025 and 22nd April 2025. Let exception be filed within 2 weeks.
Because
his allegation is against fraud and he is asking for 4 weeks time.
then 21 matter is there. We filed this petition before my lord Justice Kapoor. And Kapoor pointed out it. The first time I heard in the company court, the also leader making disclaimer about the fraud.
How?
Filed by within 4 weeks.
Application has been filed.
This is the matter on 20th August. 20 August. Next.
My lord, I am for the official liquidator, my lord. This is the report.
Yes.
My lord.
So conducted. Nobody has come.
Nobody has come. Only one person for inspection also. Only one person has turned. So I am praying for further publication of sale notice in official website of the official liquidator, my lord. prayer is prayer, paragraph C, page 3.
The official liquidator has filed the report. Let the same be kept with the record. It is submitted that as per the valuation after this, as per the valuation report, a sale notice was published, but none has come forward to purchase the said property. Accordingly, the official liquidator prays for further publication of the sale notice in the official website with respect to the property situated at Moza Debagram, Metapura Police Station, Gangapur District, Noida, by fixing the reverse reserve price of rupees 91,09,000. Consider the submission made by the counsel for the official liquidator. Peruse the report, the official liquidator is granted leave to publish further sale notice in the official website to sell the aforesaid property by fixing the reserve price at rupees 91,09,000 within a period of
4 weeks.
4 weeks. Full stop. Please the matter and to complete the auction. 4 weeks full stop. The auction be done on we will listen the officer liquidator Kabula. Let the report be filed on 27th of August 2025.
Much of this.
Your Lordship, I am the applicant, Your Lordship, in CA number 9, Your Lordship, of 2023, whereby I have prayed that the directions be given to the official liquidator to make
Could I appeal
disbursement
for
of the sale proceeds and, Your Lordship, to make payment towards this cost of security which you have incurred. Liquidator has also made an application for direction to disburse. Now, there is one opposition by the Commercial Tax Department, Telangana. They are saying as the secured creditor had given possession of the property to the liquidator, so they no longer remain the secured creditor because it is relinquishing the security interest. So this is what the case is. And I'll have to demonstrate to your lordship that I have not relinquished my security, and which I can show from the documents annexed also. And even the liquidator can confirm that we have not relinquished our security. Because the liquidator is treating me as a secured creditor and is asking for the disbursement in that respect.
My lord, it's a categorical, my lord, it is a categorical pleading that they have relinquished their rights and security interest in.
Where is
Where
So, my
is
lord,
it?
my lord will kindly take their application. My lord has their application. Kindly take page 8 of their application, my lord. Paragraph 6.
Yes.
My lord, I'll just place from paragraph 6. It's their application, my lord. I say that in terms of the order of winding up, the applicant is handed over the possession of the said property, being the mortgage land, to the official liquidator on the 8th of January 2015, which will be evident from the copy of the minutes recording such handover. The minutes have been duly signed by the representatives of the applicant as well as the officers of the official liquidator. A copy of the minutes of possession dated so and so is annexed hereto and marked as Annexure L. I say that thereafter, in terms of the order passed by this honorable court, the applicant had published advertisements in newspapers, and I've also paid for advertisements which was published in the name of the official liquidator, for which meeting was for meeting the expenses of the asset. The applicant has incurred a substantial expense of deploying security guards for the purpose of safety and security of the said property. The applicant also has paid a sum of rupees 15,000. The assets were finally sold after the publication of several notices, so and so. Paragraph 8, my lord. The applicant thereafter filed its claim, my lord. My lord, paragraph 8. The applicant has also filed its claim under Form 66 with a letter number so and so dated 31st of March 2016. A copy of the order dated so and so is annexed hereto and collectively marked as Annexure N. In the claim, the applicant has also mentioned that the applicant has incurred a sum of rupees 13 lakh on account of expenses towards security of the said property and advertisements in connection with the auction of the said property. The applicant has also remitted a sum of rupees 15,000 to the official liquidator to meet the liquidation expenses. As per the direction in the order by this Honorable Court, these expenses incurred by the applicant are supposed to be reimbursed by the official liquidator from the proceeds received by the official liquidator upon sale of the assets of the company. So, my lord, it is their admitted case, my lord, that they have given up, my lord, the property in question. My lord, let the liquidator file its
Now, may I indicate, Your Lordship, my learned friend has said that she has read. Your Lordship will not find anywhere in any of the paragraphs where you have said that we have relinquished a security. Now, kindly take, Your Lordship, the paragraph 11. I say that in terms of the percentage of the applicant towards security interest, the applicant has a major share in the sale proceeds realized by the official liquidator. Where is the question of relinquishment? I have filed the form 66. If Your Lordship will kindly just have a look at page 293. This is a part of the claim which I have filed before the official liquidator. Page 293.
Yes.
Kindly see paragraph 9. If Your Lordship will see from hence IARC, paragraph 9. Hence, IARC is entitled to receive from the official liquidator as secured creditor in preference to the unsecured creditors a share out of the assets of the company for satisfaction of its claim against the company to the extent of its loan liability and interest of contractual rate. That I say by filing proof of debt, IARC has not relinquished its securities. And therefore, IARC continues to be the secure creditor. This is the proof of claim which I filed before the liquidator.
Yes.
And I am the one who has paid the security expenses also till this property was sold. So I am the one who has paid for the security because this is my security.
Yes.
I have not
Once Ms. Bhuteria concludes the submissions, I'll make submissions on her application where she has herself stated that she has handed over the property which was a secured property.
No,
So
that's
merely filing a form does not give her any right.
okay. So who has filed this application?
No, the applicant.
IA 9, Your Lordship, is my application praying for directions upon the liquidator to disburse my funds.
And CA 10 is my application for declaration of dividends to the two secured creditors, Lordship.
That is my client and one more client.
Yes, Lordship.
Another.
CA 10.
Yes,
Yes.
Lordship. CA 10 is my application.
CA 10 also.
If Your Lordships kindly come for summons for directions, Lordship, I am praying for an order in terms of prayer 1, 2, 3, and 4, Lordship.
Oh, I thought what is this?
Declare dividend along with the accrued interest in favor of the International Assets Fund and Andhra Pradesh State Financial Corporation.
Yes,
So,
Lordship.
whom you are appearing?
My lord, the commercial tax department of government
There
of
are
Telangana.
3 creditors. If Your Lordships kindly come at my applications, Lordship, which I have stated, Lordship.
My lord, that application doesn't even recognize me.
No, their name is there in the ordinary creditor in IA 10. Their name is there.
Page 6, Lordship. If Your Lordships kindly come at page 6, Lordship. We have received 3 claims from the 3 creditors, Lordship. One is International Asset Reconstruction Company Private Limited, and second is Andhra Pradesh State Financial Corporation, and third is the Commercial Tax Department, Government of Telangana.
Correct.
So preferential claim that we have admitted that
There are 2.
yes, 2,
secured
and
creditors.
we have considered them as ordinary creditors.
Ordinary claim.
So fund due to paucity of funds, Lordships kindly see the amount which they have claimed, that 80 crores, 56 crores, and we sold the asset and now the fund is only 3 crores something, some lakhs, Lordship.
3 crore some like.
3 crore 39. If Your Lordship sees the
Yes.
next paragraph at page
The present
8.
fund position of the company in liquidation is 3 crores 36 lakhs 99 as on 20th December 2023. Now it's 2025. It would be higher side, Lordship. So these are the amount which are lying with us, and we are ready to disburse that international asset reconstruction and Andhra Pradesh.
Yes.
My lord, I say that can't be done in terms of their own admission, my lord, that they had handed over possession, my lord.
Handed over, but relinquished. See, if some property handed over to see and look after and whatever it
My
may
lord, but
be,
possession was taken, my lord.
maybe
My lord,
where is the relinquishment?
my lord, let that possession be confirmed by the official liquidator, my lord.
We
Let
have
them-
already stated
Lord,
in
let them-
our summons for directions and in our affidavit, Lordship,
nothing with
what
regard to
further
relinquishment.
issues we have.
Why you are standing on the way?
My lord, because I say, my lord,
May I just take over, my lord? I'm reading Ms. Bhattacharya. My lord, paragraph 6 of Ms. Bhattacharya's application specifically says that she has handed over the secured property.
Correct.
Her rights were secured based on this property. Now, to the very definition of a secured creditor, my lord, is this, that there is a security based on a particular property which is in her custody. Today, my lord, having surrendered that, merely because there's a bond, that does not mean that she continues to remain a secured creditor. Her position as a secured creditor, by her own voluntary act, by discharging the security in favor of the official liquidator, she has now relinquished her position from being a secured creditor to an unsecured creditor.
No.
So once, my lord, she has given up the property goes into the pool, which is the general pool of assets of the company. That general pool of assets of the company, my lord, the official liquidator has to put up for sale. And on the sale being conducted, the official liquidator thereafter, my lord, will have to first pay off the, my lord, the employees, thereafter the secured creditors, and thereafter the unsecured creditors. Today, my lord, with the deepest of respect, Ms. Bhattacharya's client, having relinquished and handed over possession of the property, is no longer a secured creditor and is in fact an unsecured creditor. So today she cannot have a preferential right over, my lord, declaration of any dividend in her favor.
Okay. Yes.
Ms. Bhattacharya on the last occasion, the submission that she's going to cite judgments pertaining to, my lord, as to how by filing of forms, my lord, charges are perfected, and on that basis she would be considered to be a, my lord, secured creditor. I do not think these judgments have come forth to your lordship. On the contrary, my lord, lordship keeps it next Wednesday when your lordship takes up company matters. I will show your lordship that secured creditor only be one who has, my lord, the asset based on which, my lord, the security interest can be exercised. Today, having given up the security interest, she today no longer stands at the same footing or as that of a secured creditor.
Yes.
Now, your lordship, they had also
Judgments of-
filed one affidavit.
Wednesday,
Now, the question is, your lordship, either the liquidator will have to show that I have relinquished my security. A single document which they can show that I have relinquished my security. It is just for the convenience sake that the sale is taking from the courts doesn't mean that I have relinquished my security. I am the one who has even paid all the security expenses.
Post expenses.
Post expenses, I have paid all the security expenses as far as this property is concerned. And the liquidator rightly recognizes me as a secured creditor. Of course, I am. Is there any letter I have to at least, by in writing, I have to inform that I have relinquished my security? I have not.
Yes. Yes, Mr. Ghosh.
On the contrary, my lord, merely payment of, my lord, a security agency's expenses, that wouldn't make her a security creditor. Secured creditor, my lord, there are certain parameters which have to be established. Her claim is that I'm a secured creditor, A, because why? I have paid the security charges. That is not the case. That can't be the basis of qualifying as a secured creditor. One. Two, the official liquidator might recognize her as a secured creditor. Just because she has not issued a letter doesn't mean she continues to remain a secured creditor.
So you mean to say they have handed over the possession, so they are not, they cannot be treated.
That is, and my lord, my learned friend submits that she has not issued a letter relinquishing her right as a secured creditor. She has done something further.
And you see,
She has approached the court. She has affirmed. She has affirmed an affidavit. She has affirmed an affidavit, and on affidavit, on oath, she has said that she has relinquished. Having relinquished her rights.
May I give my book?
On what basis can Tim.
Bit, dilapidated condition. No, not in 2013. This will be like this if your lordship has this. It's a 1956 rule.
1959.
59 rules. If your lordship sees rule
151.
151. Your lordship, kindly take this book. It's in a bit.
It's the end.
The state is bit.
It's the last rule.
Rule 151. An affidavit proving a debt shall contain or refer to a statement of account showing the particulars of the debt and shall specify the vouchers, if any, by which the same can be substantiated. The affidavit shall state whether the creditor is a secured creditor or a preferential creditor, and so set out the particulars. I have specifically said in the form 66 which I have filed, which I showed your lordship, that I am a secured creditor and I am not relinquishing my right. Which is at, it begins, your lordship, the affidavit, your lordship, begins at page 291, and the relevant portion I showed your lordship at page 293, paragraph 10 and even 9. That no, I'm not relinquishing my security interest. And the official liquidator is fully aware of the fact that I have not relinquished my security interest. I have never intimated the official liquidator that I'm relinquishing my security interest.
Yes. That's all.
Yes.
My application is there for declaration of dividends to the two creditors, lordship, and whatever your lordships will pass an order.
Okay.
Lord,
Any further?
I was only praying, my lord, if a report could be called from the official liquidator to confirm this fact, my lord. Only
Yes,
to
fine,
that
that's
effect.
perfect. She's saying that we are the two secure creditors.
Lord,
That is what she said.
She has filed the CA10.
Yes.
She filed a CA10.
So,
My lord, she has.
Then not-
My lord, only one thing, my lord. She said, my lord, that the applicant herself says, my lord, the official liquidator has taken possession of the asset. So there is no
She's not
existing.
denying the fact.
So there is no existing
There is no
security
denial of
interest.
the fact. I am saying I've given the possession. She's saying she has taken.
we
And
sold
she's
the
sold.
asset
Preparing for
pursuant
whom?
to the direction
Lord,
of the
commercial
corporate-
tax.
File any, if you have not filed any objection to
Yes,
this,
but I have.
where?
My lord, I have
Affidavit in
filed my
opposition they have filed.
Where is?
I have filed my affidavit.
Where it is? Of the 10, of
Yes,
10.
Yes, my lord, to her application, my lord.
30th July 2024,
Lord, has
I
that?
think they have
Yes,
approved.
yes, got it.
Lord,
Okay, then
has
I will pass out. Anything submission?
Lord, I was only praying for, my lord, if a date could
Okay, I will consider. I will consider.
my lord, if your lordship keeps it next week for Mr.
My lord, security interest, my lord, your lordship is fully aware. A secured creditor is not somebody who just files a form. Lordship will kindly see the application once. I'm really sorry, my lord. I was addressing another code. I rushed in. Ms. Bhuteria's own application, paragraph 6. I say that in
GA9, GA10.
no, GA9. CA9. I'm so sorry, my lord.
Yes.
I say that in terms of the order of winding up, the applicant has handed over possession of the said property, being the mortgage land. A land which is mortgage is the security interest. That is the property which is charged. That is the basis on which, my lord, any person can claim that I am a secured creditor. The averment is clear that she has handed over possession. So, my lord, for exercise of any right pertaining to, my lord, a mortgage, possession is primary. That is gone. Kindly see, my lord, how this averment is affirmed, my lord. Paragraph 18 at page 12.
Of here?
Of, my lord, the application.
Yes.
It is verified as information derived from records. So it is a fact that this particular property, which was mortgaged in favor of, my lord, Ms. Bhuteria's client, on record, she is stating that based on the records available with them, they have surrendered. On surrendered, this is no longer a secured asset. One. Now, Ms. Bhuteria's submission, if I recollect correctly, is this, that she has not relinquished her rights because she has not written to the official liquidator stating that she is relinquishing this particular property in favor of the general pool. Contrary to that, my lord, if your lordship is pleased to see, my lord, 8th of January 2015, The minutes are annexed to her own application.
Yes.
Now, based on the minutes, my lord, she makes this averment. Kindly seize the minutes, my lord. Minutes. Where is she, my lord? Well, I think it's not marked in. Just a minute, my lord.
You want the page number?
Ah.
288.
My lord, that volume 2 is not marked in my copy somehow.
It's 288.
Yes, my lord. Kindly seize this, my lord. This is the handwritten minutes. In terms of the Honorable High Court's order of 14th August 2014 and letter issued by this office to the secured creditors of the company on 2nd January 2015 and pursuant to the official liquidator, the order of the official liquidator dated 2nd January 2015, the marginally noted representatives of official liquidator along with Mr. Vaidya arrived at the noted marginally place for the purpose of taking possession. On arrival, the representatives of the official liquidator along with representative of IARC found the nameplate of the company now in liquidation and entered the factory premises and met Mr. A. Bhaskar, the security of my lord, the applicant. Thereafter, all the representatives inspected the factory premises and found that no movable assets being there, at only 2 structures are therein. After inspection of the entire area, the possession was taken by the representatives of the official liquidator on as is where is basis from the representative of the applicant. It is also noted that 2 number of locks were replaced by new locks and keys were held by the representatives of the official liquidator. Complete handing over of possession in favor of the official liquidator by, my lord, the secured creditor. After discussion regarding the protection of the asset party, it was decided to continue the existing security till disposal of the asset. So this was the submission made that IARC, my lord, was in possession through, my lord, and maintaining the security personnel. That is all. Under whom? Under the official liquidator.
Kindly read the next.
I'll read it. Mr. Vaidya, representative of IARC, handed over 2 letters.
The 3 lines prior.
After discussion regarding the protect of the assets,
Security disposable security expenses shall be
decided
paid
to
by the
continue
secured creditor.
Yes.
Shall be paid
Exist-
the secured
That
creditor.
doesn't give her any extra right.
security till
Payment
disposal
of-
the assets
yes.
of the
Shall be paid by
property.
the secured creditor.
Doesn't mean anything.
IRC limited to the official liquidator
For
every
all-
month.
For all that is relevant, mere payment of, my lord, the charges of the security agency will not entail any benefit. She for all would have, for the all that we would have cared, she could have paid these charges for any other property anywhere else.
If I was the unsecured creditor,
Doesn't
all the
matter.
creditors had to pay, not me.
So you have paid, the other
Okay.
creditors will have to pay.
Next, anything?
Yes, my lord. Now, my lord, what is a secured creditor?
How much time you will take?
I'll take, my lord, half an hour. Because yes, my lord, because I'll establish because she is not a secured creditor. The test of being a secured creditor, she has not been able to fulfill. Mere filing of the form doesn't entail any benefit to her.
So you are appearing for
I am appealing for, my lord, the
I'll be there for the another matter. So
23rd. Yes, very well.
counsel for the officer liquidator and
Vaishnavi.
IARC
Yes, my lord.
have argued the matter at length. Full stop. Do full stop. Counsel for the
My lord, the Commercial Taxes Department,
Commercial-
Government of Telangana.
Commercial Tax Department, Government of Telangana has argued sometime, but due to paucity of time, hearing could not be completed. Accordingly, is adjourned. Let the matter appear on 23rd.
Great.
Take your book, madam. Come on.
yes, yes.
23rd, my lord.
23rd?
Yes.
One matter where your lordship had directed personal appearance. Lordship, the directors are here. Lordship, this order was passed on the 18th.
Which matter?
5750, I'm sorry, my lord.
Which matter?
Item number 57 and 50.
ये कौन सा है?
ये 40 item number 40.
40?
No, our earlier matter was 38 and 39, and he is mentioning item number
57. I'm
नहीं,
sorry.
ये नहीं, 40 नहीं, कॉल नहीं किया ना. 39, 38 and 39.
Yes, Lordship, that is over, Lordship.
Okay, okay. Yes, which matter you are telling?
Item number 57 and 58, Your Lordship. had
In that
directed
matter
personal-
also, I am appearing on behalf of the official.
58, 59.
Lordship, 57 and 58.
57, 58, yes.
Lordship, the director is here.
There is an order. Which order? You are having all.
PDI 11.
CA 4, 642.
Lordship, this is for non-filing of statement of affairs. Yes, Lordship, we have entered appearance.
Yes.
Lordship, we have entered appearance. The one of the directors is here. The other director is his wife, who's not been able to come, but we have entered appearance for both.
When?
Lordship, we have entered appearance on. Entered appearance on.
He bolse call.
Lordship, it's already been appeared. We had failed to appear.
Why not appearing in the court?
Yes, madam. They should have appeared.
Twice, thrice they are not appeared. On the last occasion, they are in Delhi. That's why.
Lordship will kindly fix it on any day. We will come with the statement of the affidavit which needs to be filed.
हाँ, बोलिए, बोलिए.
57. 57.
So this is a CR case, complaint case.
Yes, yes, Lordship.
For non-filing of statement of affairs.
Correct. Violation.
Mr. Arup Chatterjee is present in court.
But his wife is not present.
Then again, she is not.
Lordship, we are appearing on behalf of the wife also.
Criminal offences, Mr.
Lordship, this is only for non-filing of statement of affairs.
Maybe violation of section 5 and section 5 for 450.
Lordship will kindly fix a date when we'll come with this affidavits. Kindly give us 2 weeks time, we'll come with the affidavits required and we'll file them in court. We'll kindly dispense only till that time the personal.
Then he has to file the bail bond. He has to furnish the bond.
Lordship, he is here. As far as Mr. Arup Chatterjee is concerned, he is there in court today. Lordship will kindly give us 2 weeks time to file the affidavit.
And his wife was a director of the company in liquidation.
Lordship, both the affidavits will be filed in 2 weeks.
No, they are not appearing. This court is not satisfied with the conduct.
Lordship, we are here before your Lordship today.
You are there. Once the notice has been issued, personal appearance, you are there. But the problem is that once again they will go, they will fled away.
Lordship, as a last accommodation, kindly give us 2 weeks time. We will come back with the affidavit.
Yes, madam. Let them
They are not
let the
appearing.
security amount, some security be deposited. I will grant time before the register.
They have not filed any statement.
Correct. That's
of
what I'm
affairs
telling.
since
They are
long.
not filing. Then nothing. They are not appearing. Now, once the court has passed an order, now he is appearing. That also one is not appearing. Who is the original director? Let the security amount of rupees 20 lakhs.
Dues are concerned, the company doesn't have any dues. The dues have been cleared.
Let the security amount.
But there is no amount outstanding because the
Not understanding, but the court is passing an order. Put the security for appearance before the court. Let the secure an amount in the before the registry of 5 lakhs each.
Lordship will kindly not give 5 lakhs because one of the directors is here. Mr. Arup Chatterjee is present before the Lordship.
Present as an invitee. Let the security amount.
Lordship will kindly excuse. They should have appeared earlier.
Unless until the amount is not secured, they will not appear. Tomorrow they will engage some other lawyer.
And
They
this
will
is
say-
2015 matter.
That's why I am telling. Otherwise, I could not
This is
have.
a 2021 matter.
It is 2015.
Yes, the winding up application was made in 2015.
In terms of the order passed by this court dated 18 June 2025. He is one of the director.
He's one of the
He is one of the directors.
Mr. Arup
Ex-director.
Chatterjee.
Ex-director or director?
Lordship, now the company in liquidation ex-directors.
One of the ex-director, namely
Arup Chatterjee.
Arup Chatterjee is present in person, but the other director, namely Srimati
Baby Chatterjee.
Huh?
Baby Chatterjee.
Baby Chatterjee is not present. Who is responsible for the respondent, counsel for the accused, press for time to file affidavit in opposition. Full stop. This court finds that in spite of several orders passed by this court, the ex-directors are not complying with the order of appearing before this court, but only when this court has passed an stringent order. One of the ex-director is present, but another director is not present. Let the another ex-director, namely Srimati so-and-so, be appear before this court on 23rd of July 2023. Let's see come, then I'll pass an order.
Lord, item number 67 of the commercial list. Lord, interim order expires today, my lord.
Any company matters? No.
Lordship, item number 60. This matter was mentioned before your lordship had gone for the short stint, and your lordship had kept it for the immediately 1 week from then.
60, hai na?
No.
Item number 60. Item number 60 है ना?
Not sure.
वो दूसरा है, ये कंपनी मैटर I'm telling you. Item number 60 हम लोग का 60 है ना? उसको जो 23rd में ना ऊपर में 2-3 मैटर के बाद रखते हैं.
I'm grateful, your lordship. I'm grateful.
Yes. Any company matter?
Item number 70, 71 and 72, my lord. The interim order is expiring on 23rd of July, my lord.
You are
Your lordship,
you are coming on the last moment, taking the extension and going.
Your lordship, I'm appearing for the.
I am fixing a specially fixed matter. Otherwise, I am vacating the interim order.
Apology, however, my lord, we were waiting for the matter to be hold on. Only after we filed that the matter.
Every time, this is the third time you are mentioning at the time of rising of the court. You are not mentioning what is the stay order you got.
Lord, there is a not to take any steps, coercive steps against my lord.
For what?
Against the application, my lord, under section 463 of the Companies Act, my lord.
So,
Lord, we waited for the matter, my lord. Matter has been scheduled to be listed. It is listed today, my lord. There are 3 matters, my lord.
Your Lordship, I am appearing for the ROC in this matter. Your Lordship can kindly see the last order of 11th June 2025. Your Lordship has already given the interim order till 23rd July. I don't know, Lordship, why they are mentioning it today.
23rd July is there. Then why you are mentioning? Next.
Yes. May I have item number 67, my lord, of the.
Yes, ma'am. Senior is
Oh,
there.
I'm sorry.
I'm sorry. I have a commercial matter, my lord. Your lordship.
Commercial only, no?
Yes, commercial, my lord, and he's.
You are also commercial.
He's commercial and senior.
Well, this is, my lord, the power trust matter where your lordship had, my lord, by an order dated 16 June, fixed the matter at 12:30 yesterday. Now, yesterday the court didn't sit. Well, so, my lord, that will have to be fixed because, my lord, there are certain developments which has now made the matter even more precarious. And this apart, my lord, the interim order that was passed by your lordship, my lord, expires on 18th. My lord, these are the, my lord, 2 reasons why which compels me to mention this
Which
matter.
matter? Which matter?
My lord, this is, my lord,
My lord, I am appearing, my lord, for the respondent, my lord. This is the trust matter, my lord,
Item
which
number?
involves, my lord.
Acha, that one, Siri. What is
Yes,
the
my lord.
appeal?
Well, appeal is a different matter. They have not pressed the appeal. Well, appeal is in 857 where your lordship injuncted shares of Hiranmaya Energy. Now, well, that apart, my your lordship remembers there was an order passed by Justice Moshumi Bhattacharya directing sale of the shares. That application is pending. My lord, your lord, there is no appeal against that. So, my lord, that has to be proceeded against because what they are doing now, my lord, they have, my lord, ultimately, my lord, decided to sell off all the assets of the company in favor of the subsidiary. If that happens, the share value will immediately drop.
Yes,
Who is that? My lord, I am not aware, my lord.
Well,
Need to, you know, I am not aware of this. This is also coming as a bolt from the blue.
Mr. Shah is having the documentary evidence.
Yes.
Well, then let him also give me a copy of that so that I can also get back to my clients.
The voting resolution where, my lord, they've agreed to spin off.
What you want?
My lord, kindly fix it day after tomorrow, my lord, and my lord, kindly extend the interim order that has been passed in that.
Interim order till?
18th.
18th.
Yes.
18th. It's still 18th, well, it's so.
It will be mentioned. क्या में है ये? क्या लिस्ट में?
Interim order was passed in 857.
Well,
Well, that can be extended. Well, I'm grateful. My only one more thing, well, your lordship had initially fixed item number 29. Your lordship was pleased to direct it will appear at the top of the vote tomorrow. Well, Mr. Sarkar is appearing in the matter. My lord, at his request, my lord, let it appear on Friday if it commends to your lordship.
Not tomorrow.
Mr. Shudipto Sarkar, my lord, is appearing in the matter for the other side. My lord, he finds it more convenient on Friday. One day, my lord, will not make
Friday. ये मनी स्क्वायर वाला ना 29 को उसको
My lord is keeping.
both
My lord is keeping it on Friday, my lord.
Friday.
Very grateful. Very grateful.
Yes.
Extension of interim order, my lord, item number 67 of the commercial list.
You are opposing.
Lordship, I had apprehended this mischief and I had but there are more than 20 respondents and none of them are here. Lordship, and for the court did not preside and that's why it was not taken up. There has been no effort to mention the matter or get it heard. They are enjoying an interim order and this is being a mechanical extension, Lordship. I really do not think it should be extended and the matter should be taken up for hearing.
Yes.
Trifle harsh. It's a trifle harsh. The matter was fixed on the 9th and 10th.
Lordship, I am appearing on it, but
It's a trifle harsh. I am ready that the matter be heard out any day, but to say that we are sitting.
Lordship, I am for the.
Have they given a notice of this mentioning, Lordship? Let them produce the notice of mentioning.
Why not mention?
They are going to mention
The
it.
list mentions that if the matters expire, interim orders expire on the day, then they are generally mentioned, my lord, at the time of rising.
And give with notice, I believe.
I believe my learned friend has already noticed. She has come.
And where are the others?
I believe she's only appearing for her client. If she wants to appear in representative capacity, my task is cut out.
Like क्या time? खाली है.
It was 12:30 p.m. fixed on 2 consecutive days. My lord can keep it accordingly or whichever schedule my lord.
Item number, what is item number?
67, my lord.
So the matter is listed as item number 67 in today's list, but due to pursuit taken of hearing. Counsel for the plaintiff mentioned the matter for extension of the interim order as the interim order is till today only. Counsel for the defend number, madam.
5 and 6, Lordship.
Defend number, madam, you are applying.
Lordship, I am for the 10. I am for respondent number 10.
For the defend number 6. The defendants raised objection for extension of the interim order. Full stop. Though the interim order is extended from time to time, accordingly, the interim order is extended till what date? Manutosh? Till 28 July 2025. This is the matter on 28 July at 12:30 p.m.
But may I have your lordship's leave to mention a matter? It's a non-commercial matter. But the interim order is expiring on 18th July. Well, this is the last order passed.
18 July. Come
yes,
18
but
July.
it is not there in the list.
18 July is the non-commercial day. Come on that day.
The matter will be
Friday, non-commercial.
Very good.
After lunch, after 2, all commercial, non-commercial matter.
Very good. I'll mention
I
that.
think a slightly more extension, maybe 3 or 4 days more. Just in case 28 and 28, just in case, Lord, there may be.
Okay. Fix at 28 at 12:30. Interim order is extended till 31st of July.
Obliged.
Or until further order, whichever is earlier.
Obliged, Lord.
Yes.
Number 66, my lord. I am appearing for the respondent company, my lord. My lord.
Item number
66.
Of the commercial list?
Yes.
Or company matter?
Commercial list.
Yes, 66.
Yes, my lord.
What is the name? Bharat Kushal Bharat.
It was filed by ROC against the Viraj Ishpat Limited, my lord.
66.
Company matters, my lord.
Company matter, yes. Yes.
My lord, I am appearing for the respondent company, my lord. My lord, the liquidator has filed a claim against us stating that we have not filed the statement of affairs, my lord. My lord, when the liquidation was done, the liquidator has seized all the asset of the company. And due to the reason we do not have access
to make the document which has been claimed in this regard, my lord. And
What you want, madam? What you want now?
we have filed a, we have sent them a notice regarding this, and they have actually not communicated with us in this regard.
What you are harping upon?
We have sent them a letter claiming that they give us access to the office only for one
Have
day.
you sent? Have you met with the official liquidator?
Yes, my lord.
So what they inform you?
We have actually sent them a
Okay, you do one thing. इसको एक काम करो. कौन सा 66 है ना? इसको भी ऊपर 66 and 60 ऊपर में 5960 कनेक्टेड 5960 तो कनेक्टेड नहीं 60 अलग है कनेक्टेड है हाँ 5960 हो चुका तो 66 10 का अंदर लेके आ जाओ. Come on Thursday, next Wednesday, 23rd.